Just a few notes from me before we get going. The issue about the microphones is, can parties make sure that they're speaking close enough to the microphone? I think the live stream doesn't always pick up what parties are saying as the reason. Secondly, the witness is in a purdah period following once they're introduced in evidence in chief. So for the avoidance of any doubt, that's been adhered to throughout the inquiry, but it's just a reminder from me to say that there's no speaking to the witnesses during any breaks. Other than that, there's nothing else from me. Do any of the advocates want to raise anything?
Good morning, sir. Just on the unilateral, thank you to the appellant for providing a draft document last night. We've now got that. I've asked for some copies to be prepared because I'll want to ask the appellant's witnesses about that later today if we get to that. So we've got a copy here. I won't hand it up now, save it till later. There's another point, which is the Regulation 122 compliance statement, the SIL compliance statement. We haven't yet received that from the appellant. And I had a message yesterday which suggested that the appellant's expectation is that the council would prepare that. That's not right. That's for the appellant to do. I think they recognised that when they submitted a unilateral undertaking, that it was then for them to produce that compliance statement. Given that we are scheduled to be discussing that tomorrow, could I ask that that's circulated today so that we can consider it?
Mr. Harris, do you have a response to that?
If my learned friend had given me notice, I probably would have. But at the minute, I'll need to take instructions on that. Can I say I don't actually necessarily accept that if we are paying obligations, even under a unilateral undertaking, which are pursuant to heads of terms that have been put to us in the report to committee, that it's for us to justify their heads of terms. But that's a sort of technical argument that we don't need to get into. Can I take instructions as to what's doable, bearing in mind the work that's gone on with the Section 106 over the last couple of days? If it can be done, and if we think it's for us to do it, we will do it, certainly. But we'll do anything that will help your determination if the local authority are not prepared to do it.
Okay. So if I, just to be clear, that the appellant's position, you'll remember on the 16th of October, you would have seen the correspondence. The appellant contacted the planning inspector and said that they would produce both a unilateral undertaking and a SIL compliance statement. That's an email from Ms. Anderson to the case officer on the 16th of October. We've obviously seen the unilateral. We haven't seen the compliance statement. And certainly it's our firm expectation that in those circumstances, that's for the appellant to do. And you will need that for I think there's not necessarily a requirement for a SIL compliance statement, but if there is one, it's for the appellant has already accepted that they should be doing it. So we haven't done it.
Okay, understood. It would be helpful to have the compliance statement.
Yep.
It's just a question of timing.
Yes, it is exactly that.
So I'll take it that that's in hand. Mr. Harris, would you like to continue?
Thank you very much, sir. Mr. Ribbett, we had 10 minutes of looking at weight to benefit yesterday. I'm going to start this morning with reason for refusal dealing with inadequate affordable housing. You've got that as reason for refusal number 2 at your page 3 of your evidence. The proposed development owing to the low level of affordable housing would fail to meet significant need. So we're talking about the whether the 77 is inadequate or not. That's it. These reasons for refusal are put in different orders in different places, but that's the one that we're talking about now. Do you understand?
I understand. Thank you.
Thank you very much. And that was a reason for refusal that was introduced contrary to the officer's recommendation and contrary to the position of BPS, that the proposal had provided the reasonable maximum provision.
It was added at committee, yes, yeah.
Yeah. So officers were really clear, it's a paragraph we've gone to a number of times, that following consideration by BPS, the proposal provided the reasonable maximum provision and that there was no reason for refusal based on adequacy of affordable housing that could be argued. You were at the committee, weren't you?
I was. The reason refusal is about, not about, sorry, I'm finding it difficult to concentrate.
Yeah.
It wasn't about, sorry, let's get my thoughts in right.
Yeah, please do.
Because I
take as much time as you like.
I heard your question, and now I'm just.
Mr. Ibbott mentioned to me earlier, obviously within the terms of the discussion that I'm entitled to have, and that he wasn't feeling very well. I asked him then, are you happy to continue, which I didn't raise at the outset, but it might be worth just checking again, because if he's not well, he shouldn't continue.
I'm fine. It's just my mind moved as you asked me the question.
Fair enough.
And can you just rephrase it, and then I will repeat it, and then I will.
Thank you. I'll try and do it more directly. The introduction of the reason for refusal was contrary to officer's recommendation, which did not include such a reason. Correct?
That's correct. Yes.
Good. And it's clear that officers, aided by BPS, thought that there was no reason for refusal based on the adequacy of affordable housing. They recommended a reason for refusal which was different, but it wasn't based on the adequacy of affordable housing, was it?
And it was based on the financial viability tested route about maximum reasonable amount. Okay. Yes.
And if you look at the transcript, you probably don't need to because you were there. What happened was that the chair said, well, we've got the one reason for refusal that's recommended by officers, but we'd like to add some. Do you remember that?
In general terms, yes, yes.
And then they went into closed session, didn't they?
Yes.
Yeah. And we don't know what happened in closed session, but when they came back, they added this reason for refusal relating to inadequate level of affordable housing.
They did.
Yeah. So far as I can see, apart from the advice from BPS and the officer's report, which identified the differences between BPS and DS2, but also the conclusion that they'd reached as to reasonable maximum provision, officers received no technical advice on viability or any of those matters relevant to development plan viability set out in the policy from anybody else.
On the viability matter, no, they didn't.
No. And BPS are not at this inquiry, perhaps obvious why. And you're not a member of the RICS with appropriate qualifications to do viability.
I'm not, no.
And that policy matrix that we looked at and we'll look at again a little later makes it clear that in determining the quantum of affordable housing, H5, P11, etc., there is not only an identification of something called the maximum level of affordable housing, but also the methodology by which you judge that.
There is, but that's all within the context of a target, which is for 50% across London and 50% across Southwark.
Yeah, from all sources, not just Section 106 positions.
Yes, but I think we know that the proportion that comes from non-Section 106 applications is a relatively small percentage. I haven't got it in front of me, but the vast majority of affordable housing through this Section 106 route, to aim to meet the target is meant to be through this Section 106 route. We've got to the point where that that route is ground into the rammed up into the reality of the perfect storm that is now such a problem. And you know, I think members were entitled to say, well, look, if this is where the financial viability tested route is taking us, then it's not delivering what the policy purpose is. And it might well be that is inverted commas, or more than inverted commas, is policy compliant with the viability tested route. It's clearly the purpose of the policy and the purpose of both in the London plan and the Southwark plan is not being fulfilled. And
we'll just agree to disagree on that, if you don't mind, because it opens up all sorts of stuff that we don't need to trouble the inspector with. But let me ask you this. So when they formulated the reason for refusal, which said an inadequate level of affordable housing, it must follow that they did so without expertise on the operation of the viability system as set out by the development plan.
No, they didn't do it with the lack of expertise. They were saying, and I guess you could say it's an MPPF paragraph 59 route to say, actually, whatever the FVA says, we still consider this is not sufficient to meet local housing needs, which is what the plan, both plans suggest you should do.
I just want to explore that with you, please. First of all, can we look at the nature of the reason for refusal? Look at it on its face. The proposed development, owing to the low level of affordable housing, would fail to meet the significant need for social rented and intermediate homes in the borough. See that?
Yes.
Now, let's just explore that. The proposal provides 77 affordable homes, doesn't it?
It would do, yes.
Yeah, and it provides 867 homes overall, doesn't it?
Yes, I mean 790 market homes doesn't meet significant need for social rented and intermediate homes.
But of course it does, because you'll have 77 individuals and families which will have housing after the grant of this consent when they don't at the minute. So the question isn't whether it meets the need. It clearly meets the need, as the inspector found in Cuba Street. The question is there a way in which the planning system can get more? Isn't it? And if the answer to that question is no, there isn't, then it shouldn't be a reason for refusal, should it?
I'm not convinced by that, because, and clearly, I mean, this comes back to my point about the financial viability tested route coming up against hard reality.
Yeah.
I mean, two things yesterday we heard about. One was, as originally submitted, this application was proposing 35% affordable housing. In January 23, a financial viability assessment seemed to imply a lower level of developer surplus that would have supported 35% than is now proposed. Clearly, this financial viability process, while it follows a well-trodden route, sits alongside the commercial decisions of the event, which is right and proper.
Right. Sorry, I didn't mean to cut across you.
Sorry.
But I have heard everything that you've said there now on a number of occasions. I'm trying to focus my question.
I apologise then. Carry on, Mr. Harris.
No.
We had this yesterday as well. He said 2 points. He gave one of them, and then Mr. Harris cut across.
Right. You please finish. You please finish. But so long as you're answering my questions and not just rehearsing the entire case again.
Okay, I'll do my best, Mr. Harris. I understand.
Okay.
The second point is, and you were saying, you asked me about there's no other route through the planning system. Clearly, the Secretary of State and Mayor's statement from the 23rd of October is recognising that there is a problem with the planning system being able to do this. And interestingly, the floor that's put on that, in that putative policy position, would be 20% affordable housing. So there may well be routes in the near future that would deliver more affordable housing on this site. I I've done a rough calculation, we might get 50 more units. So we might have 127 units on this site, not 77. So I don't take the point that there's no other route for the planning system.
Well, all that's very interesting. Doesn't come close to answering my question. But
in fairness, the question was the question for the planning system is whether you can get more. If the answer is no, that's not a reason for refusal, is it? And he's just answered why is 2 points why he says it is a reason for refusal.
This exercise that you've just spoken about, where you've undertaken an analysis which shows that you get 50 more units, that's not before the inquiry, is it?
No, I didn't introduce it in Chief.
No, you could have, and you didn't.
But I'm sure the appellants have done that exercise for themselves, or they would have that in front of them in the future. I'm sure whatever the outcome of this appeal, while they're waiting for that, they would probably look at their options in relation to this new emerging policy, assuming it comes in.
Can we come back to how you ascertain the reasonable maximum provision, please? Because that's a concept that is embedded in the development plan, isn't it?
It is.
Can you point the inspector to a single other case in London where an alternative route to the viability route has been used to assess the appropriate level of affordable housing?
I can't, because that policy, as I've said in relation to the Southwark experience, has worked reasonably well over the last since it was introduced, and it's only in the last year, 18 months, that the economic realities of it have begun to fall apart.
Can we look at the development plan itself, please, which you accept for the purposes of this inquiry is up to date and relevant, correct?
Yes.
You don't say that it shouldn't be used. In fact, in your proof, you identify that the strength of the development plan system in London at the time of this application is that it is relevant, up to date, and to be used.
Yes.
What you say.
And it was found sound, and with the expectation, indeed, the inspectors on the Southern report expected affordable housing to be delivered somewhere between 35 and 50% on the basis of that.
On most sites is what they said. So
on most
sites.
Yes, of course.
Yeah. So let's look at the up-to-date development plan as you have it. H4.
Sorry, London plan.
Yeah, London plan. H5, which you've gone to a lot of times. It's CD41. And the page number is 176.
Yep.
We're in category F, aren't we? This is what the inspector must do, applying the development plan. F, this requires, where the application does not meet the requirements set out in Part C, it must follow the viability tested route. This requires detailed supporting viability evidence to be submitted in a standardised and accessible format as part of the application. The borough, and where relevant, the mayor should scrutinise the viable information to ascertain the maximum level of affordable housing using the methodology and assumptions set out in this plan and the Affordable Housing and Viability SPG. So what that does is two things, isn't it? It identifies what the test is for maximum reasonable. The test is the maximum reasonable. And then it gives you the methodology which you must use, doesn't it?
It does. Can I just qualify one thing, though, Mr. Harris, that it's not this policy that prompted or required the viability testing to be submitted, because this would, if it had been 35% and only the London plan, then it would have followed the fast track route. It's the Southern plan policy P1 that triggered the requirement.
Forgive me, that's just not correct, is it? Because we are at 12% now, aren't we? So this policy is immediately put in play, isn't it?
Yes, it is now. I'm just making sure that everybody understands it was, as originally submitted, it was a requirement.
We've got that. That's history, and we'll explain why that's history that's not relevant. This is the policy that is applicable, particularly when we are a strategic housing provision of 867 units. So let's not go down a rabbit hole there. There's there's no policy in the development plan that says that the developer is required to provide more than the reasonable maximum provision, correct? There's no policy in the development plan that requires the developer to provide more than the reasonable maximum as identified through that route. Is there?
2 seconds. I was just going to look at 4512 because we looked at that yesterday.
Yeah, we did.
But I accept your question.
Yes, thank you. Because whatever you say about 4512, which isn't a policy but is very helpful, it doesn't say that you can ask for more than the reasonable maximum.
It doesn't. That's what I was.
And that would be an inversion of the whole concept of the reasonable maximum, wouldn't it?
It would.
Yeah. That's nonsense, isn't it? If you were to say that.
If one were to say that, yeah.
Nonsense. And of course, in this case, BPS found, notwithstanding the history which they had been involved in for a very long time, that the proposal's reasonable maximum provision, even including their 8 or 9 differences of opinion, was still 0% affordable housing because of the immense costs and various other factors that are at play, correct?
Yes, I don't think there's any dispute between the parties about this.
Good. That's very good at crystallising the position. Now, of course, lot has been made about what Berkeley Homes did previously, and I just want to see how much, if any, relevance that is to the inspector in the circumstances of this case. Can you pick up Mr. Levine's proof of evidence, please?
Can you give me the CD reference, please?
I'm afraid I can't. Oh, yes, I'll
be able to find it.
BD 8.9. And we could go to this. I think there are 4 places where this is.
It's just loading. Yes.
Can we go to paragraph 2.6, please? Now, let's put this in context. BPS were instructed throughout by the local authority in this case, weren't they? Including at the previous stage of the application.
I understand that's the case, yeah.
And you heard Mr. Levine yesterday say, well, whatever Berkeley Homes were thinking when they went in at 35%, I think that was a mistake. It could never have been built, and his evidence was that no rational developer would build at 35%. Do you remember all of that?
Yes, on the basis of the FVA methodology that's being used, not on the basis clearly that Berkeley had in their mind that was a more commercial view.
Yeah. All right. Well, I banked that, and I'm going to come back to that later and whether that's relevant either for the inspector. But the first 3 propositions I put to you, from a viability point of view, all right, aren't they? That he said he thought it was a mistake. He thought that the scale of the deficit was such that no reasonable developer would develop at that scale of deficit. Do you remember that?
Yes.
Good.
It's not quite right. He didn't say it was a mistake. He didn't accept.
Well, the inspector will have a note.
Well, so you will have a note, but also we can correct it straight away rather than go to the note.
Well,
Mr. Levine's evidence was not that it was a mistake.
You took him to the paragraph. All right. Well, the inspector's recollection will do for me. And if I'm paraphrasing, I am paraphrasing in a way which passes it to such a narrow degree that I'm prepared to let it stay with the inspector. Do you remember yesterday, Mr. Levine saying, I don't think that was the right thing to do, to go in at 35%? in one way, shape or form.
Whatever phraseology he
Yeah.
used, he certainly cast doubt on
Yeah.
on the
Yeah.
on the
I think that's right. That's very fair.
on the what's the word I'm looking for?
Deliverability?
No, on the decision that had been made.
Yeah. All right. Well, the inspector will remember exactly how it went. Can we look at paragraph 2.6, please? Because what the BPS people did, and we might need to look at this a bit further as a result of what Balloon Friend says, is that they looked at that at 35% and said, in light of our assessment, we considered that the scheme would not be able to viably contribute towards providing additional affordable housing. Even allowing that, we concluded a reduced scale of deficit, there must be considerable concerns about the deliverability of this scheme, or that it will be delayed in terms of its delivery pending wider improvements in the market. See that?
I do.
Yeah.
Interested in the last few words, pending wider improvements in the market. That seems to be the very issue we're grappling with here.
Yeah. All right. Thank you very much. At no time in this case did BPS ask for affordable housing in excess of the development plan reasonable maximum as calculated, did they?
It's not their place to do that, but no, they didn't.
No. Well, you see, what they do, though, is as RICS surveyors, they must have regard to the professional standard that tells them how to do it, what to take into account, and what to leave out of account. Correct?
Yes.
Yeah. Good. Thank you. Okay, next heading. Why the situation of or the choices of individual developers are not appropriate to be taken into account in determining the reasonable maximum. A planning permission runs with the land, doesn't it?
It does.
Yeah. And it runs with the land irrespective of who the owner of the land is for the time being.
It does.
Yeah. Section 106, crystallising contributions, including affordable housing, runs with the land.
Does.
And it's a judgment by the planning system of what it is appropriate to ask for, applying the development plan assessment of reasonable maximum affordable housing.
Yes.
Yeah. Land is tradable.
Yes.
So the ownership of land could change tomorrow.
Mm-hmm.
The quantum of affordable housing, or indeed any of the other Section 106 obligations, should not alter just because the landowner alters.
No, I mean that landowner, a different landowner may come forward with a different scheme, but
yeah, all ceteris paribus, as we like to say in economics.
Yes.
Yeah. Good. Further, the developer's circumstances might change. Yeah.
Yeah, they might do.
Well, they might go bust.
Yes.
They might have a windfall, which means that suddenly they've got lots and lots of money sloshing around.
Yes.
Yeah. All of that is irrelevant to the process that the development plan tells us to undertake. And the reason is because the inspector is looking at the site, the development objectivized, and is judging in accordance with the policy what the appropriate level of affordable housing is and can be asked for. Yes?
In terms of the development plan policy and the approach, I understand that entirely, yes.
And you agree with it?
Yes.
Yeah. You. So when it comes to the circumstances of this case, where there is a full agreement as to the reasonable maximum provision equals naught, in terms of assessing whether the planning system should ask for more, the fact that Barclay might be able to afford more or might not be able to afford more is irrelevant. You test it objectively, don't you?
Yes, I suppose the point I'm making is that what was in members' minds was, I suppose, the reality of the market
Thank you.
not providing enough, and therefore they were right to say that the weight should be given to the outcome of the financial viability assessment route. Was less than it perhaps has been in the past.
Yeah, maybe. But the fact that a developer might have felt itself required to, or in a position to, offer more in the past is not relevant to the assertion through the development plan process of what's the reasonable maximum provision, is it? It's entirely irrelevant.
In terms of the development plan test, I understand what you're saying, yeah.
Well, and you agree?
I agree, yes.
Yeah, good. Thank you very much. Now, and you also agree that if you provide the reasonable maximum of affordable housing, applying the methodology and all the things that the policy tells us to do, which, by the way, are all consistent with the national PPG as well, aren't they?
Yes.
Yeah. If you do that, then you comply with the development plan so far as it relates to the assertion of the reasonable maximum provision, correct?
Yes.
You agree, you comply with the guidance in the PPG?
Yes.
Yeah, very much. And if that is compliance, and then you provide more than the reasonable maximum provision, then that is a benefit to which weight should be given, isn't it?
It is.
Yeah. So let's think of a registered provider who provides a mixed-use development and provides it in this borough. And the viability says, actually, you can probably only provide 14 or 15%. But because they are an RSL and because they've got grant funding and various other things, they provide, as often happens now, 65% affordable and the rest market, a sort of payoff. Yep.
Yes.
Now, the fact that they are providing 65% affordable housing means that they are providing more than the reasonable viable position, isn't it?
Yes, but they're not a developer who's
no.
being required to do that under Section 106 agreement.
No, I agree. But if they're at an appeal, or if this is being determined by an application by a local authority, the local authority, when looking at benefits, let's say it causes heritage harm or something of that nature, will be obliged to weigh the benefits that the proposal brings, won't it?
Yes, they would. Yeah.
And because they provide more than the reasonable maximum provision, they'll get the benefit of more than the reasonable maximum provision, won't they?
I mean, it's certainly a benefit if it was, say, 65%, but I'm not sure the fact that it's more than 35% or more than 50% is
be careful where you go here. Yeah, please.
Well, you're giving me warning that I might be straying into difficult territory, Mr. Harris. I'm not quite sure.
Well, you just answered the question.
What I'm saying is that there's an overall target that for affordable housing in London. The fact that it's an RSL bringing that or registered provider bringing that forward, there are different things in play, as you say, because they have access to grant funding, etc. So we're not performing the same sort of balancing exercise, I would suggest, that we are in the current case.
All right, let's try and narrow it down so that we are doing the same. You've got a developer. The developer is proposing 65% affordable housing. The reasonable maximum provision is down at 12. Now, are you seriously saying to me that for one reason or another, because the developer's intentions are not relevant to the identification of the reasonable maximum provision? I just want to see how far you and elected members are pushing this. Are you saying that in no circumstances, if the developer produces 60% affordable housing, you just ignore everything from the 12 to the 60?
No, I'm not suggesting that. I'm just saying that the balancing exercise you do there is We're still talking about registered provider.
No, that's why I just went to another developer.
Oh, sorry.
So, you see, I want to just address you on your own merits, because you were just about to say, and perhaps I shouldn't have warned you, that anything above 35 or 50 shouldn't be given much weight.
No, I'm not suggesting
No,
that.
good.
I'm just saying that when it was a registered provider, you're not comparing apples with apples.
Right, I just come back to the general principle then. If you're providing the reasonable maximum provision pursuant to the development plan and more, then the and more must be given weight as a benefit, mustn't it?
It must be given weight, yes.
Good. I didn't think we were going to find anything else, but thank you for that. And that's what happens in this case as well, isn't it? Because what the officer's report specifically drew to elected members' attention was that the provision of the 77 units was more than the 0%, and that was and should be taken into account as an additional benefit.
Yes.
Yeah. Okay. And that's what happened in Stag as well, where the inspector, very similar case in the sense that it is about 1,000 units. It's in London. The same policies apply to the strategic sites. And what the inspector there did, as we've seen on a couple of occasions, is to say the reasonable maximum provision is 0, and therefore he's given very substantial weight to the provision in that case of more than 0. I think the position in that case, can't remember, was 12 or so. Yeah.
Yes, I mean, I'm not familiar enough with that case to know what other material matters were in front of him, but or them.
No,
but
yeah.
As in terms of applying the policy as you've just described it, that's what they did. Yeah.
Yes, and that's really the principle that I'm going to. 7% there. In fact, I'll pause there. There's 7% there, not 12, so less than in the circumstances of this case. Then, please, Mr. Everett, the reasons why an individual developer might take the view that they should provide more than the reasonable provision, once the reasonable provision has been reasonable maximum provision has been worked out fully in accordance with the plan and agreed and robustly tested as here, the reasons why somebody might be doing that is relevant to the planning merits, clearly, as we've agreed, but isn't relevant to the calculation or identification of the reasonable maximum provision, is it? Because that is objectified, as we've seen.
Yes, I mean, the corollary, obviously, of that point is that we don't know what the basis of the 12% is.
Because it's irrelevant to the calculation of the reasonable maximum, as you've agreed.
Yes, but on the other hand, it's clearly not meeting local need. It's nowhere near the 12% is nowhere near what London needs. And we don't know whether this particular applicant could have offered 13, 14, whatever. We have.
But that's irrelevant. I mean, we've just gone through the reasons why that is the wholly inappropriate approach, because in that case you'd say, well, Berkeley Homes could probably do 9% or 6% or 12%, and then that burden carries its way forward with the granted planning permission for somebody else who comes and develops it. It's a completely irrelevant position, as you've already agreed. And really what you're redoing here, with greatest respect, is to sort of have a renaissance of that argument into a slightly different argument, isn't it?
I accept what you're saying, Mr. Harris.
Thank you. All right, good. And I think, as you've accepted, but I just have to have it formally from you, in this case, the council doesn't suggest a different reasonable maximum at all.
It doesn't, no.
And it doesn't suggest that there is any fault or error or discrepancy in the joint conclusion that 0% affordable housing is the development plan viability reasonable maximum.
It doesn't. No.
Thank you very much. And it calls no expert RICS guidance on the level of affordable housing that's actually achievable in terms of the development plan.
That's right. You asked me that earlier. Yes.
Yeah. Okay. Did I? Sorry. Thank you very much. Good. Next, please. The value of 77 units now. It follows from the answers to the last questions that you gave that you accept that the 77 homes to be provided are more than the reasonable maximum.
They are.
Yeah. It's 2 entire blocks of very much needed affordable housing, isn't it?
The 2 entire blocks is not particularly helpful, but the 77 number is, yeah.
Yeah. That's good. Thank you very much. And a refusal now at a time of very great need, everybody's agreeing that part, would mean that there would be 77 individuals and families that could have that need met for them, having no need.
Well, it would certainly be likely to be delayed. I mean, I can't see that this. I mean, just take one example. You know, the new regime that is being propounded by the Mayor and the Secretary of State.
Yeah.
You know, you were talking about hypotheticals. A hypothetical situation here might be that if this appeal were dismissed, that Berkeley would come back with a fast track route with 20% affordable housing, and that would deliver more homes, wouldn't it?
Well, I'm not entirely sure it would, for reasons that I can go into with other witnesses, because we need to look really carefully at what those emergency measures say, don't we, before we start making those. And I didn't hear any of that in your evidence in chief, and you've already explained that there's a sort of calculation that you've done that we just haven't seen. Good, thank you. Good. That's the end of that issue. I just want to look at the relevance of the previous application in a slightly different light, because in your proof, you speak, if you like, of the affordable housing that would have been provided at 35% as somehow being foregone, is the word you use. And of course, they're only foregone if that was ever a reasonable, likely scenario. That's correct, isn't it?
That's right.
Yeah.
Clearly, at the time that Berkeley made the application, they were anticipating it was a likely scenario.
Yes. Well, we are where we are now, I suppose. Just before we go any further, though, just on that point, it's a little bit of a rabbit hole, but I don't like rabbit holes, but I'm going to go down this one just a little bit. There's reference in a lot of the documents to what this council calls its golden rule, isn't there? And its golden rule is that it expects sites to produce 35% affordable housing. That something you're familiar with?
In my view, it's not a golden rule.
No, in my view as well, it's not a golden rule. They call it a golden rule.
Well, members might have used that phrase, but we know that politicians use phrases sometimes in a way that is slightly ambitious.
But is it
my reading of it is not that it's a golden rule. It's a reflection of the very successful implementation of the policy over the last 5-6 years since the Southwark Plan was adopted. And the 35%, well, I've forgotten what the figures were, between 22, 23, 24, 25, as I said yesterday, 40% of approvals had 40% affordable housing, and completions were 38%. So it was a successful use of this policy that we've been discussing. And so maybe there was a political expectation that it would carry on being able to deliver, but now we've moved on.
Right. Okay. But the golden rule that I was asking about is not a golden rule, because we got the development plan, which is the starting point.
That if there's a golden rule, it's the development
It used to be called the golden thread.
It used to be, yes.
It did. And not the golden shot. I think there aren't many people in this room who remember that.
That dates you, Mr. Harrison.
I'm afraid so. Left a bit, up a bit. But on the on the golden rule, were you also aware that oftentimes developers are told directly by politicians and officers that unless they put an application in at 35%, it just doesn't get to committee? You aware of that?
Well, there are all sorts of things that are said. I'm not
You're not
aware
aware of
of
that?
what happened in this particular case, because obviously I'm not an officer of the council.
Yeah. All right. Well, we'll hear from others on that. Right. Out of the rabbit hole. You've heard, and I'm really careful here because this was what the witness said on a number of occasions yesterday from DS2, that no reasonable developer now or in the foreseeable future would contemplate a 35% proportion of affordable housing.
Yes, I heard that.
Thank you. Can we pick up Cuba Street, please? Now, we've just confirmed that, at least on the council side, there's no expert evidence to contradict what Mr. Levine said in relation to that. Can we look at Cuba Street?
Yeah.
Which is CD 11-2. Now, this was a case where there was a previous permission. It's for 30-odd%, yeah?
It was a Section 73 application.
Yeah, but there was a previous permission at 30-odd%. Now, we've not got a previous permission in this case. What the council are pointing to is a previous application, not a previous permission. Yeah.
You mean this application when it was originally submitted?
Yes.
So, yes.
Yeah. Good. Thank you. 31. The original permission is unviable whether one adopts a present-day approach or relies on forecasts. Well, we've got Mr. Levine's position on that. Favouring the former, it's also undeliverable. Again, we've got Mr. Levine's evidence. It is faced with a widened gap between value and costs and the inability to find a registered provider, etc., etc. Then, about a third away from the bottom, I see no reason why the practical impediments to the delivery of the original permission, out with the control of the appellant, would be overcome as a result of dismissing the appeal. The original permission is therefore a fallback option of little weight, and allowing the appeal would not constitute a lost opportunity to secure greater affordable housing in the current economic circumstance. Now, assume for a minute, underlined, if you want me to underline it, that the inspector agrees with the evidence of Mr. Levine, that no reasonable developer now or in the foreseeable future would contemplate a development of 35%. Then the inspector's conclusions in this case, that in those circumstances where there was an actual permission, much less where it was just a previous part of the same application, would not constitute a lost opportunity to secure greater affordable housing in the current economic circumstance. Now, in the premise which I asked the question, that's right, isn't it?
Yes. I mean, it's interesting that the emerging revised policy includes something about Section 73 applications.
Yeah, we don't know what that's going to be.
We don't.
It's going to be a change of the PPG.
But
that's not relevant to the point I'm making, though, is it?
Well, it may be, because it's a recognition that the market is struggling to deliver through the Section 106 route, through the viability tested route.
Yeah.
And that's exactly what's happened.
But you can see why they're doing it the way they're doing it. What they're saying is, we want more housing and we're prepared to have less affordable housing or fewer affordable units in order to achieve that. That's really what they're saying, isn't it?
That's one of the things they're saying, but what the other things they're saying is reducing SIL for a time limited period, relaxing design standards.
Yeah.
So they're not saying that the viability issue around delivering affordable housing is the only reason for the difficulty in delivery.
No, I think that's a point for us. Don't you think?
it's a point for all of us to consider.
It is.
Including the
All right, okay.
inspector.
Fair enough. Thank you. So then look at the next paragraph. I recognise that need for affordable housing in London and especially Tower Hamlets. I think you could probably say Southwark as well there. Don't you agree?
Yeah.
Is acute. Moreover, the failure to keep pace with rising unmet need has significant consequences with an estimated 183,000 Londoners. The proposed development offers an opportunity to deliver at least some affordable housing to relieve that housing need, which the evidence indicates would not otherwise be forthcoming from this site as things stand. Again, if on the premise that the inspector accepts Mr. Pascal's evidence, the same applies in this case, doesn't it?
Mr. Levine.
Mr.
Yes.
Levine, sorry. I've been called Mr. Russell without anybody picking a point up the whole inquiry, but
I hope I haven't done that.
not you.
Oh,
no,
right.
no, you've been really good.
Yes, I think the answer to your question is yes.
Good, thank you very much. CLT housing, please.
Yes,
CLT is an affordable housing product, isn't it?
it is.
Yeah. The provision of any affordable housing product in Southwark on sites greater than 10 units is subject to viability, isn't it?
I mean, not if it's providing more than 40%. You don't have to go down the viability route. Is that what you mean? Am I misunderstanding?
No. It's a fair point, but I'm not sure it's right anyway. The provision of affordable housing in Southwark is subject to policy P11, isn't it?
You just get that in front of me.
CD.
Yeah, I've got the
Four.
I'm just looking for the policy.
Oh, mine's going to take it. Here we go.
I understand what you're asking me now.
Yeah.
You're saying it's not subject to viability testing, it's subject to viability.
Yeah.
I understand the point.
Yep. And and it's subject to viability on all sites. It doesn't say subject to viability except on Aylesham, does it?
No.
No. And if 0% doing the viability as we've done is the reasonable maximum, the planning system can't ask for any affordable housing. Just gone through it. There's no mechanism for it to require affordable housing if it's naught.
That's right. Yep.
So it can't ask for any CLT, can it, if viability is at naught?
That's right.
Yeah. And there's nothing in the allocation which says otherwise. The only way you can work out the quantum of CLT that might be deliverable there or appropriate there is if it's viable.
Agreed.
And if 0% affordable housing can't be asked for, and if CLT is affordable housing and it's 0% CLT, you can't ask for any. The planning system can't.
That's right.
And what you've got to do is look at the 77 units of affordable housing that are provided in that context.
Yes.
Yeah. And they, as we've worked out, eventually, are a benefit, the weight to which is a matter for the Secretary of State's inspector, but will take into account the pressing need, the urgent need, and the fact that there will be people housed, on anybody's case, in 77 homes.
Yes.
Thank you very much.
You were asking me about CLT. I'm not sure.
Yeah, it doesn't. It's the same.
Yeah.
Can I turn to reason for refusal 1, please? Reason for refusal number 1. If you go to your proof, you identify in the planning balance section, which is on page 72, the various weights that you give. And we started to look at this yesterday. I'm going to come back to it now. And you see, you give the 77 units limited weight. Yes?
Yes.
And you've given it limited weight, as I understand it, as a result of your conclusions on what we've just looked at in terms of reason for refusal number 1. What you say is not enough.
Yes, so I suppose I've always also got in my mind that there are, there's the heritage test that we've gone through as well, about public benefits as well. So.
Yeah, fair enough. I'm going to come to heritage slightly later, but I am right, aren't I, that you've given that limited weight, at least in part then, as a result of the reason for refusal number 1. Not enough.
One being the heritage one.
Well, people, no.
Which one are we talking about now?
No,
Sorry.
we started, I did them in the same order that you did.
Oh,
so if you go to your page 4, look,
sorry,
people got them in different orders. There should be a rule about this. Yeah, so if you go to your page 4, reason for refusal number 2 is the inadequate affordable housing.
Yes.
Right, so let me put it accurately. When we're looking at reason for refusal number 1 and the weight that you place in the planning balance, you've said affordable housing will be provided, but I give that limited weight. At least part of the limitation of the weight there is to do to the reason for refusal number 2 points that we've been discussing, isn't it?
It is, yes.
Yeah, and if and insofar as they're not shared by the inspector, then you'd need to up your weight.
I would, yes.
Good. All right, thank you. So let's see how we can put that in a way which helps the inspector's characterization of the issue. If the inspector believes that it's not appropriate to seek more than the reasonable maximum provision, then given the very pressing need for affordable housing, then surely in that premise, 77 homes, new homes, should be given substantial weight.
Yes, as it was paraphrased in Cuba Street that you just, was it Cuba or good. Which one you took me to?
Good. Excellent, thank you very much. All right, so harm next, please. Heritage harm next, please. I want to look at the campus heritage harm. Excuse me. We've been going an hour. Do you mind if we just carry on a little bit longer?
Thank you for asking.
No, you're very welcome. I want to look at the campus of the heritage case. Can we look at the reason for refusal that you set out on page 2? What you say, the reason for refusal is proposed development owing to the low level of affordable housing failure to deliver any community land trust homes would fail to deliver sufficient public benefits to outweigh the heritage harm to the character and appearance of the conservation area owing. And so we're looking at the height, scale and massing of proposed blocks A, B and C, correct?
Yes.
And we got townscape harm to block L. And the heritage asset, which is at large, is the Rye Lane Peckham Conservation Area. Yep.
Yes. That's
so in heritage terms, we're looking at A, B and C and the Rye Lane Peckham Conservation Area.
Yes.
Good. Thank you very much. The inspector's categorization of the main reasons or main issues is an identification of whether there is harm, and then, if you like, a calibration if there is harm of where it is.
Yes.
So we're going to try and help with that. Can we go to the report to committee, please?
Just 2 seconds.
3.1.
I'm getting there, Mr. Harris. I'm just going back to how the inspector summarised the issues again. Yeah. Sorry, officer's report.
Yeah.
Let me just get that up.
Just since you checked it, I mean, that I've characterised it appropriately and accurately.
Yes, I think it's fair what you said.
Yeah,
I mean,
good.
we could read it out, but I'm sure the
No,
inspectors.
the inspector's got that.
Um,
Now, I'm not going to go through all of the heritage case with you again.
I'm relieved, Mr. Harris.
Good. But I want you to look at para 255 because it goes to the way that the balance is undertaken.
I'm just waiting for it to load.
Yes, it's a very big document. It's also got actually 2 committee reports in it.
It does.
I've never ever wanted to know less about solar panels.
Which PDF page are we on?
I don't know the answer. I've got a paper
Right.
copy which avoids me doing the.
Right, I'll find it. I'll find it.
I'm looking at paragraph 255.
Yeah.
Which is on an internal page of 80.
50 of the PDF.
I'm
Thank
very
you.
nearly there.
Thank you, Mr. Turney.
Yes, I'm there, Mr. Harris.
Okay, now, it's very clear from this and from the transcript of the meeting at which you were at, how officers were minded to deal with this application. Do you see at 255? They take the inspector now, because this was produced for the purposes of this inquiry, wasn't it? This committee report. It's a putative report to, if you like, assist the inquiry and officers and
it is,
together. Yeah. Having recognised the level of harm arising, in this case, the scale and design of the Rye frontage blocks A, B, and C, that's what we just looked at. Para 215 of the NPCF requires decision makers to consider the level of harm in the balance against the public benefits of the proposal, including securing its optimum use. In this case, the harm, so that's the harm from blocks A, B, and C, in this paragraph 215 context, would be localised and focused on this key frontage of the conservation area. See that?
Yes.
So, you know, that's how they are setting the harm in one category against the public benefits in the second. Now look at paragraph 256. We've looked at it a lot, but 2/3 down the page, there's a sentence which begins whilst.
Yep.
Whilst the delivery of 35% affordable housing may have been sufficient to outweigh this harm on the basis of the public benefits, this is not considered to be the case for the 12% affordable housing now proposed. That's what it says. I want to take you to one further reference, please. Oh, and this one might be a tricky one to chase down, but it's CD 807-1. Which are the appendices of the planning proof.
Yep.
It's the internal page. I'm on page 3. I'm trying to get you a PDF page. It's page 3 in Appendix D.
Appendix D is the difficult thing to find.
Yeah, 158. I've got that marked
Thank
on
you.
here. Thank you.
Let me have a go.
It's a very short quote.
Oh, this is the transcript, yes.
Yeah.
Yeah.
And you see 1, 2, 3, Victoria Lewis, that's VL. We'll come to see her in other contexts in this cross-examination. She's the presenting officer, isn't she?
She was, yes.
Yeah. Do you have that? So it's quite a tricky thing to get about. Right, good. And she said, officers advised the applicant that the reduction in affordable homes meant that the public benefits of the proposal would no longer be sufficient to outweigh some heritage harm, which would occur as a result of the proposal. Now, here's the questions. When we're looking at calibration of the harm, the switch from affordable housing 35 to 12 doesn't change that, does it? That's a heritage issue.
The harm is a separate issue.
Yeah, good. And we do know that officers are taking the view, the provisional view, no doubt, that the proposal would no longer be sufficient to outweigh such harm. And whilst the delivery of 35% affordable housing may have been sufficient to outweigh this heritage harm, they had it in mind that whatever the harm was, it was capable of being outweighed by the package of public benefits generally.
Yes, that's an interesting way to characterise it, yes.
Yes. Well, I can't see any other way of doing it. And in setting up that test, having regard to everything they'd said before, when they get to that test position, they identify the harm as being localised and focused on this key frontage, don't they?
Yes.
And if you look at 255, it specifically refers to the balance required in paragraph 215 of the NPPF, that's the heritage balance as we now know it. The numbers keep changing. And they're doing that for the purpose of setting up how they got to the conclusion that the public benefits, including 35% affordable housing, might have been sufficient to outweigh the harm.
Yes.
That's clear as can be, isn't it? Now, two things arise from that. The first is, what is the condition of the key frontage? Because it's localised and focused on the key frontage. The key frontage is the frontage of the existing Aylesham Centre, isn't it?
Well, it's that part of the site, yes.
Yeah. And we know, on anybody's case, that that is identified as a key building that could benefit from being demolished and redeveloped, don't we?
I think the way the conservation area appraisal puts it is that the design is indifferent to the character.
I put to you very, very carefully what the conservation area document says, and I put it to you that it was a key building whose existing condition means that it would benefit from being redeveloped.
Said demolished and redevelopment. I don't think demolished is included in the.
Fair enough.
So is the proposition redevelopment?
It's redevelopment. Yeah. Yeah. Well, all right. Can we go to it then? I mean, I don't mind interruptions when they are accurate and appropriate, but here we go. Can we go?
Mr. Harris, this is the second time Mr. Harris has done this in this inquiry, which is to rephrase the conservation area appraisal, which I think is an important document.
Right. Let's look at it.
So let's put it fairly to witnesses.
Let's look at it then. Can we CD 61, please?
Yes.
So what we've already established that the level of harm that officers identified was, in their views, capable of being overcome by public benefits, and that heritage position had not changed. The next position was to look carefully, and let's look carefully at what the CAA said, but also then what officers and others said by way of guidance. Can we look at paragraph 29, please? It's page 29. Thank you.
We're talking about the conservation area.
Yeah, we are. Yeah. CD 61.
Yeah, I've got it. I'm just looking for that. Yes.
Yeah. There's a heading, negative impacts. Yes?
Yes.
Yeah. So I've got your reference.
It said, yeah.
Yep. So there's no doubt that we're talking about negative impacts here first, is there?
Well, that's not, it just says indifferent character, which doesn't actually allege harm on the character.
Just bear with me. 4.4 is dealing with parts of the conservation area that are negative.
It says negative elements. It doesn't say negative impacts. And I'm just saying when we get to 443, it talks about indifferent character. It doesn't
Yes,
talk
I've got
about
that. I'm going to go to 443 in a minute.
Yeah.
But I'm going to 44 negative elements. That means these are negative in the terms of the conservation area.
Yes.
They have a negative impact. How can you avoid saying that, please, Mr. Ibsen?
I'm not. I'm just making sure that. Yeah.
Yeah.
Fine.
Yeah.
Could I just interject there?
Yeah.
Could I ask a question? What do you take the word negative to mean?
Oh, difficult one. One that does not contribute to the character and appearance of the conservation area. It's if you like, an alien element in the street scene. But there are degrees of negativity, that which I think is the important thing from my point of view, because clearly a conservation area is a layering of lots of different things, and the Aylesham Centre happens to be perhaps one of the more recent layers in that character and appearance. Does that assist? I hope so.
Thank you.
Can I just pick up on your answer to the inspector? The first one, you said negative means make no contribution, makes no contribution.
Is that what I said?
I think so. I mean, I'm sort of bit on tenterhooks here in case I'd misheard you, but it's something that makes no contribution. And I'm just going to put to you that really what you should be saying is a negative element is something that harms.
You're probably right, Mr. Harris. Thank you.
And then the second thing that you said, which I was much more in favour of, was that a negative element is something that is an alien element in the street scene. Okay.
Yes.
Thank you. Now, I've got 443. I've seen what that says, but you need to read the whole document. It then goes on to say, learned friend Mr. Mohammed should listen, the key buildings and sites that detract from the character and appearance of the conservation area are listed below. And yeah, you can read the whole thing. All right, we all heard your intervention. So the key buildings and sites that detract, that is really clear, isn't it? There are certain buildings that are so important that they get the appellation key. Yep. I see you looking to the next page.
No, I'm interested because that paragraph says are listed below.
Yeah, they are. And I don't think you've seen the listed below before.
I've read lots of things, and I've read this, but thank you. I'm just reminding myself.
Yeah, that's fair enough.
So under 452, I see the Aylesham Centre is listed. Yeah.
Yes. So let's stick with 444 first, please. First of all, it makes a point about identifying key buildings, doesn't it?
Yes.
Right. So they're not just buildings that are negative. These are key buildings that detract from the character and appearance of the conservation area, aren't they?
Yes.
And then you need to see what they are. Yes? Okay. And what they are is over the page at 4.5. And at 4.5, it identifies the Rye Peckham Conservation Area includes many buildings in need of reuse. And then at 4.5.2, there are a number of sites located throughout the conservation area that contribute poorly to the character and appearance of the conservation area. So these are the key sites, aren't they?
I guess that's what it's trying to do. I mean, the language is somewhat loose because, as I say, 443 talks about indifferent character.
No, you've got to read it all together.
Yeah, of course you do. But I think the evidence that Mr. Bevan gave, for example, said there were. I mean, he's not exactly saying it's a wonderful building, but he.
I'm not asking about Mr. Bevan now. Sorry.
No, I know, but it's about the degree of harm and negative impact that we're discussing.
No, we are discussing what the CAA says and what it doesn't say. Yeah. And it's a key building that detracts from the character and the appearance of the conservation area. And at 452, and we had taken to section 45, not any paragraph. So at 452, we see there are a number of sites located throughout the conservation area that contribute poorly to the character and appearance of the area. As such, it is recommended that they be nominated for redevelopment. See
Yes.
that?
Yes.
No. In this case, so far as officers were concerned, did officers ever raise an issue with the demolition of the Rye Lane frontage?
Not that I'm aware of. I obviously wasn't party to all those pre-app meetings. I think when you took the architect through her evidence, there were early investigations into retaining it.
That's a very good characterization of it. But it was never suggested that this was a key frontage that was anything other than appropriate for demolition, was it?
I agree with you, yes.
Good. So when we go back to the balancing exercise, which the inspector's got to do with the report to committee, and paragraph 255 in the report to committee, the level of harm caused by blocks A, B and C falls to be considered in relation to the balance against public benefits, including securing its optimum viable use. In this case, the harm would be localized and focused on this key frontage. This is the key frontage that is referred to in the CAA, isn't it?
Yes.
Yeah. On a building that's nominated for redevelopment,
Yes.
as to which there's never been a point taken as to whether it should be demolished.
Yes.
Yeah. Good. Thank you. Okay. And throughout the process, there was very significant engagement with the Southwark cadre of officers, wasn't there? Pre-application.
Yes.
I really don't think we need to go there, but NPPF paragraphs 40 and 41 tell us in terms that pre-application is a very important part of the process.
It does.
Yeah. And in this case, we saw there were, I think, 24 odd meetings, maybe more.
Something like that.
Yeah.
Yes.
And then you dealt with it in brief in your evidence in chief. There was also the production of a planning brief, wasn't there?
It was called a design brief.
Yeah.
Yeah.
Design brief. Thank you. And we got it at CD 717.
Excuse me.
And although there are various drafts and iterations, this 2nd of May 2023 is the Aylesham Centre redevelopment design brief that we've got before the inquiry, isn't it?
It is, yes.
Good. Yeah, thank you. If the council says that it worked closely with the developer on the production of a design brief, is there any other design brief that's before the inquiry or that you were aware of?
No, there's no other design brief. No, answer your limited question, yes. I mean, I've got other things I could say about it, but yes, in terms
of I heard what you said about it in chief, but I'm asking my questions now to the inspector, not to get you to...
I understand.
You got the point?
Thank you.
22nd of May 2023, this was part of the pre-application process that the NPPF tells us is important, one way or another.
Yes, I mean, it occurred during the pre-app process for a very specific purpose.
Yeah. All right. And then if we look at it on page 2, it says this brief is developed in collaboration with the London Borough of Southwark planning officers. Proposals are invited in response to this brief. Now, that was a brief to architects, wasn't it?
Yes.
And the council had specifically indicated that the previous architect should be, use a colloquialism, given the elbow, and that new architects should be employed. Yes?
Yes.
And they wanted to be part of that process.
Yes.
And part of that process was being at the meetings and the pitches of the various architects, wasn't it? Yeah.
Yes.
And part of the process was producing this brief for the architects as well.
Yes. I mean,
Yeah.
it's obviously Barclay's own document, but officers had, I mean, it says in collaboration with officers. Yeah.
Well, and we've got, I mean,
Yeah.
we've got the emails and we've got the suggestions made, etc. See, I'm really not so bothered about what you say about the status of this document, which I'll come back to, but I just want to understand how it helps the inspector calibrate what is said by the council to be the harm. That's really where I'm going on this.
Understand?
Yeah. And so when we look at the document, we've got, mine's not paginated, but then we've got locations, vision, opportunities, constraints, Southwark plan site allocation, core objectives, and then target core objectives. See that? What's the page?
It's page 8 of the,
Page 8.
of
yeah.
the PDF. Yeah.
Okay, these are target core objectives on this document. And the first one is buildings on Rye Lane to be no more than 7 stories with the 7th story set back. Buildings adjacent to the clock tower, no more than 4 stories. Buildings adjacent to HSBC building on Rye Lane, no more than 5 stories. Okay?
That's
Now,
what it says. Yeah.
it does. So I'm looking at buildings A, B, and C. No more than 7 stories with the 7th story set back. Now, in calibrating the alleged level of harm, because conservation officers were part of this process as well as ordinary planning officers, weren't they?
I understand that was the case.
Yeah.
Yes.
Then
I'm not sure that officers have written this first bullet point, though. It says target core objectives. These are presumably Barclay's target core objectives.
listen, this is a document that has been developed in collaboration with the London Borough of Southwark planning officers. And just on that very point, why can't I chase that down at the minute? And I should. Because I suggest to you that's not a coincidence that line appears there. And
It's in one of the pre-app meetings.
yeah, it is, isn't it? So let's look at CD72. Just to see whether it comes from Barclay or from somebody else. Can you go to page 68?
Yep. Is this PDF 68? It happens to be the same as the internal 68.
I think so.
Yeah.
Can we go to 4.4?
Yep.
CJ, I think if we go back in the document, we'll find that that's Catherine Jeter on behalf of the London Borough.
The design officer, yeah.
Design officer. Mr. Wilson, who sits behind you with all of his incredible design past. And we get to 4.4. CJ noted that officers are comfortable with the direction of travel of the master plan principles. They would like to see more on individual character areas within the master plan. Officers advised that the route from Peckham High Street needs to be improved. And then we go to 4.9. CJ noted the buildings fronting Rye Lane need to be integrated well, suggesting 7 stories is potentially too tall, which it was at the time, 7 stories. A shoulder height of 5 stories with 2 upper story setback was suggested as a possible alternative.
Yes.
Yeah, that's consistent with one of those principles that we just looked at in the design brief, isn't it?
Well, I mean, the phraseology of what the officers said there is not saying it shall be 7 stories with the top story set back. That's not, it's become very much more black and white in the core objectives in the design brief. That is a comment in a pre-app meeting, which was expressing the position at the time.
Yeah, all right. Well, you can see why I take or might take the view, can't you, that this was not just something that Barclays had magicked up, but it was, let's put it in the ether, one way or another, as a positive suggestion from Catherine Jeter herself.
So can you just go to the data?
Yes, I've understood that.
No, it's not whether you've understood. It's for the witness and for the inspector.
Yeah.
I know you understand it. You've chosen not to identify.
No. Just bear with me, please, and don't be rude.
So I'm not trying to be rude. It's just, it's...
Mr. Ibbotson, can we deal with it in this way? Whichever of those came first, whether it's the brief or the pre-app, or whether it's the other way around, they're expressing similar indications of potential acceptability, aren't they?
Or one might phrase it, I mean, just for the record, clearly this meeting was after the design brief. The important thing is that the officer is expressing reservations about what was then on the table, and I can't remember exactly.
7 stories.
7 stories.
And what did you suggest might be an appropriate alternative?
5 stories with 2 stories set back.
How consistent or other? Yeah, go ahead.
But what she's not saying is, therefore, the scheme that you've now got is the right one.
No.
She's giving some general advice to the design team.
Yeah.
To have another think about that.
Yes.
And I don't want to re-rehearse everything that obviously Mr. Bevan said, and that's not my role. But
No.
Clearly, the outcome of that process did not fully address the concerns that are, if you like, lie beneath that comment about. Sorry, let me just. In other words, they didn't fully integrate well the buildings fronting Rye Lane, potentially too tall.
Well, I've understood that, and
Yeah.
I'm not going to go over that, because I think the point my learned friend was making, that in failing to identify the various dates, there was an attempt to mislead. Now, you were fully aware of the existence of the pre-app before I even took you to it, weren't you?
Yes, I mean, I wasn't wholly familiar with the date and the timing, but that's not a problem for me.
No.
I'm just saying this is a fairly typical exchange in the pre-app process.
Exactly. All right.
And there's a danger often with design teams to latch on to every word that a design officer says and take it as not exactly as gospel, but to follow it to the T, and that's not the design officer's role.
No,
it's the design team, the architect's team, to design a scheme that fits.
Yeah.
And as I say, without going back to Mr. Bevan's evidence, our case is that, notwithstanding what it says in the design brief and in these notes, the heritage impacts on the Rye Lane frontage were not properly explored.
I did explain just really quite clearly that this was going to the calibration point. I've understood that the council say that there is that harm to the degree that they explain it in the report to committee, and that then needs to be balanced against the public benefits, right? So that's where I'm going to. Mm-hmm. And in the calibration of that harm, one is entitled to look at pre-application discussions, because the PPG and the NPPF tell us they're really important. And in this case, the concept of having a 5-story with a shoulder or a 5-story with 2 setback shoulders was alive and was not being said to be out of the way or so harmful as to be avoided consideration, was it?
Not at that stage, no.
And in the document that was produced in the way that we've identified it, it is the first target core objective.
It is, yeah.
Okay. This isn't a policy document, but it's part of the pre-app. Look at the next one, please. I'm going to say...
the core objectives, you said?
Yes, core objectives. First, second, third, fourth, fifth bullet point. Clear sky behind the turret of the clock tower when viewed from Peckham Road. Again, this is on a calibration point.
Yeah.
Yep. Now, the inspector's recently been there and has walked up that thing, so we can take this reasonably quickly, but we'll get back to the report to committee, please. CD, oh dear, should be emblazoned in my mind. CD 31. Can we go to paragraphs 241 and 243? Can you see it says, important local landmark sits pride of place at the junction of Rye Lane with Peckham High Street. Yeah. It's covered up now, but you can sort of get the gist of it anyway. Yeah. It's got an expensive advert on it. Whilst it's been altered historically, still has architectural detail, etc., the taller buildings in the site have been clustered away from the head and shoulders of the clock, and in views from Peckham Road, the top of the clock tower outline would remain free from clutter when viewed in the more important views along Peckham High Street.
From the west, yeah.
Yeah, from the, sorry, you're exactly right, from the more important views along Peckham High Street from the west. And then there's a photograph of what the officers meant, this time without the hoarding on it. Then it says the taller buildings would come into view in some townscape views, but there would be many other uncluttered views available within the street. Do you agree with that?
Well, up to a point. I mean, clearly, you know, one's experience of approaching this sort of central junction in Peckham from the west is a kinetic one, to use the terminology, and you know, one would become aware of the development, and particularly of the Rye Lane frontage, fairly soon, I would suggest. Yes, this is identified as a key view and is being kept free from that background clutter. I accept that point. Thank you very much.
Now, on the Rye Lane position, it's a clock face, but there's no clock on the face facing up Rye Lane, is there?
Don't think so, no.
No. And in fact, that part of the clock face, that part of the clock tower, doesn't actually face up Rye Lane at all. Its axis reflects the Peckham, if you like, the Peckham Road access. If you go on the site,
it's chamfered, if you like.
Well, it's not chamfered. It's an angle. It's at an angle, and the angle reflects the fact that the clock face faces up Peckham Road.
It does, yeah.
That's what gives you the angle on Rye Lane, and that's what you see. In effect, it reflects the return face of the main axis, and therefore you see it at an angle. If you go on the site at the minute, what you see is a lady in a state of undress shown on that flank, isn't it?
I hadn't noticed that graffiti, but if that's what's there,
all right. Okay,
I'll take your word for it, Mr.
Make submissions about that. All right, is it an appropriate time to take a break, sir?
It is, yes.
So I think we're now 2.5 hours into a 2-hour cross-examination estimate. I just wonder if we could have an indication as to how much longer it's going to go on.
I'm on the last stretch, so 20 to 30 minutes, subject to interruptions.
Regarding the timings, I am requesting that the advocates sort of try and tighten up on those. I'm conscious that we won't have enough time left. But other than that, yes, we'll have an adjournment for 20 minutes.
Thank you very much, sir.
Mr. Harris, please continue.
Thank you, sir. Just before I do, can I report that the advocates have got together over the adjournment and looked at the future progress of the inquiry, and I think I can report that we're all confident that even perhaps with a later start on Friday, we will finish the evidence on Friday. I just thought you would welcome hearing
that's
that.
good to know. I welcome that. Thank you.
So, Mr. Ibbott, if you can take up your proof now, please. And I'm going to ask about, last thing I'm going to ask about is the planning balance and your various weightings. So you need to go to 9.25 of your proof.
Yes.
And I'm going to ask you about the third bullet point, which I started to ask you about yesterday. Do you remember?
Yes.
There you say the provision of housing, moderate weight, given that Southwark has a 7.21 year housing supply. Because the 7.21 year housing supply includes market as well as affordable housing, doesn't it?
It does, yeah.
Yeah. So when we're looking at housing here, we're looking at housing in the round, not just market housing.
Yes, I mean, obviously, the third and fourth bullet points rather allied in that respect.
They do,
yeah.
They do. But you specifically, to compare apples and apples, you choose housing, and you give to choose housing moderate weight, and then affordable housing limited weight. I've gone through that one. I'm not going to go through that again. The inspector's got our points on that, and he's heard your answers to my questions. But I want to ask about the provision of housing. We looked yesterday at the London plan and its requirement for over 600,000 units a year against a most recent delivery of about, well, less than 10,000. I think we looked at yesterday. Then we looked at the ministerial letter, which increases the need for housing in London to over 800,000 per annum from the 600,000 it is now. Do you remember the letter? It's the fourth paragraph if you need to check, I think.
Yeah, 81,000, not 810,000.
810,000. Have I got the decimal point in the wrong place?
There's an annual figure, yes.
Yeah.
I'd be very worried if it was 810,000.
Yeah, exactly. Thank you. But it's gone up from 66 to 81.
Yes.
Yeah, that right. We're all on the same page. Then we looked, didn't we, at paragraph 120 of the NPPF and the presumption in favour of brownfield land, which you deal with in your first bullet point. I want to look at paragraph 11 next, please, though.
Of the
NPPF.
Yeah.
And again, because you did this in chief with my learned friend, I think we can be quite quick. And the way that it works, let's see if we can deal with it in shorthand, is that the tilted balance applies if the council can't show or demonstrate a 5-year land supply.
That's right.
At the point of the decision making, or if at the point of the decision making they fail to get to the appropriate percentage in the HDT, the housing delivery test. Yes?
Yeah, that's when footnote 8 is engaged.
Right.
Yes.
And we'll come to the consequences of that now. Now, very, very helpfully yesterday, and probably saving a good chunk of the inquiry as a result of the note that you put in just before the inquiry started. You said yesterday, let's deal with the housing delivery target first. Remember that? And the housing delivery target requires that, in effect, if you don't get above the stated percentage, then the tilted balance applies. Yes?
Yes.
And you said, in the circumstances of the perfect storm, we aren't going to reach. It's almost impossible for us to reach the 75%. Remember that answer to questions from a learned friend?
Yes, I mean, that's in relation to the I mean, it's not obviously not the published HDT
No,
data,
No.
but it's in as you say, in relation to the perfect storm and
yeah.
and everything that sits behind that.
Well, let's see where
Clearly
that
there is a
takes us.
crisis in delivery.
There is. There's a crisis in delivery, which plays into the 5-year land supply as well. But I'm not asking about that for the minute. In terms of the HDT, the completion figures will have been sent by this local authority to the department already, won't they?
As I understand it, yes.
And they're unlikely to be so different from the AMR figures that we've got before the inquiry at the minute.
They're unlikely to be, yeah.
And the HDT figures, there's an expectation now that they are going to be published in the first or second week of December.
That's my understanding,
Yeah.
That's the way the system works.
Yeah. So unless the inspector works like Usain Bolt of inspectors,
Yes.
given that we are still sitting in this inquiry at the 17th of March, the HDT figures, according to the timetable that you and I agreed they're trying to reach, are going to be known before the decision maker makes the decision. Correct?
Yes.
Yes.
I don't know whether that means formally that it's engaged.
It is engaged. Let me tell you as a matter of law that the inspector is duty bound to take everything that is material into consideration, including until it puts the thing in the post or pushes the button send.
Fine.
Yeah.
Thank you for that clarification.
But we're looking here, if previous years are to go by, and the intention of government is that in the year that you sit, you get your HDT for the previous year. If that happens, we can say for almost complete certainty on the figures that we've got that we're not going to be anywhere near 75% by the time the inspector gets to write the decision.
The likelihood is it will fall short of the target.
Well, let's work that out, shall we? This year it'll be 2024, 2024, 2023 and 2022. They're the 3 years. How the HDT works, HDT works is
the last 3 years.
The last 3 years. Now, the pandemic, for the 2 years of the pandemic, the targets were all dropped by 3 months, equivalent of 3 months. Mm-hmm. So if you were going to look at last year's, where the borough scored 80%, that's because for 2 of those years, entire quarters were written off as inappropriate. Whereas that's all out of the system now. We're looking at 24, 23 and 22. So it's the actual figures that count. There's no manipulation to be done, is there?
No.
I mean, and if you look,
manipulation's obviously a loaded word, but adjustment.
Adjustments. Yeah. Okay. Good. Thank you. And we, because of the perfect storm, we already know that there's no real prospect of us reaching 75% on the figures that are already before the inquiry. It's correct, isn't it?
Highly likely that that's the case.
All right. Well, I put it higher than that, but that means I can spend less time with you on 5-year land supply. In terms of the 5-year land supply, I don't think this is an issue. The test set by the PPG is for the authority will need to be able to demonstrate a 5-year land supply when dealing with applications.
Yes.
The authority will need to demonstrate. That's paragraph 4. And then again, this is all stuff that's not contested. Paragraph, just bear with me. I think that will do for my purposes. I can come back to the other paragraphs with another witness, but for paragraph 4, there's that requirement on the local authority to demonstrate a 5-year land supply. Here it is. In paragraph 7, in order to demonstrate 5 years worth of deliverable housing sites, robust, up-to-date evidence needs to be available to support the preparation of strategic policies and planning decisions. Yeah.
Well, remind me what you're quoting here, Mr.
I'm quoting from the PPG.
Yeah.
And it's under the heading housing supply and delivery.
Yeah.
So paragraphs 4 and paragraph 7. Now, as I heard in evidence in chief, you've just been provided the 5-year land supply stuff by somebody else.
This has been produced by the policy team at Southwark, yes.
And I can't cross-examine them, can I?
No.
And the inspector won't have the benefit of a robust exchange between us testing their evidence. I've only got you.
You have?
Yeah. Okay. And in terms of your case, there was a Rule 6 statement published by the council, wasn't there? And in the Rule 6 statement, it asserted there was a 5-year land supply based on a 2021 document.
Yes.
Yeah. So that would be out of date, wouldn't it?
It would, yes.
Yeah. And so that assertion should be given no weight, should it?
Well, it's historical rather.
Yeah, that's fair. Yeah. But it did say there is a 5-year land supply. Here's the 2021 thing that proves it. But that doesn't prove anything really much, does it? And then in your proof, since we're on it, 925, you asserted a 7.21 year housing supply, didn't you?
That was the last published data I had to hand.
I don't think it was even published, though, was it? It was it was put together for the purposes of this inquiry by the team that has now put together the different one.
I'm confusing in my mind between what was published for the inspectors for the Southwark Plan EIP and this.
Yeah, I think the EIP one was the 2021.
Yes.
For the proof, there's an exercise that was undertaken, and the first we heard about this was when we got your proof with its appendix, appendix MI2.
Yeah, you're right. You're right.
Yeah.
Yeah.
Right. So it's not like it's been a formal AMR done at that stage, 7.21 years. And it's important because you say moderate weight to housing because of a 7.21 year housing supply. Correct?
That's what I've written, yeah.
Yeah. So, I mean, we can note that that wasn't accurate or robust in the way that it should be, because when that was seen by Mr. Alston in his role as planning witness, he looked at that, didn't he, very carefully. And can we go to his rebuttal?
Yep.
He explains that his concerns with the identification of 7.21. He says, your evidence has produced updated information on a 5-year land supply. Summary details were set out in the 2004-2005 AMR, which are replicated in MI2 of MI's POE. The schedule of sites that make up the identified supply of deliverable sites is not included in the evidence. And it wasn't, was it? It was just a table. So nobody could robustly consider it. Correct?
Yes, I don't know whether I understood at that stage that information, because I was obviously in communication with policy officers about these matters, and I know Mr. Alston was as well. So it was made available.
Yes, thank you. It was. But after the proofs of evidence have been exchanged, in which somebody suggests 7.21 for the first time. And he then goes on to say the schedule of sites that make up the identified supply of deliverable sites not included, etc. And then he made over, I don't know, 3 or 4 pages, careful analysis of why it is that some of those sites couldn't robustly be relied on.
His case, yeah.
Yep. Well, then on the Friday before the inquiry started, we received another note at CD82. Oh, 827, I can't read it. 8.27. Tell me when you're there.
I am here. I've got it in hard copy. Thank you.
You've got a hard copy. Yeah, good. I can't remember whether we went to this in chief. I think it was mentioned. But the upshot of that is that having in the proof of evidence provided for the inquiry claimed 7.21, you relying on 7.21, the local authority, as I understand this note, is now claiming 5.04 years.
Yes.
Yeah. That's just about as tight a 5-year land supply as possible to have.
Yes.
Yeah.
Yeah. Arithmetically, yeah.
Yeah. Okay. And just looking, because we take the view that that's more, when you look at it appropriately, site by site, that which was what we have done, that it's less than 4. Or the region. Yeah, I should get that right. Just bear with me.
3.92. Yeah.
3.92. Thank you very much. Good. Now, when you're that close, it's important, particularly given the consequences of the tilted balance applying, to make sure that you are accurate and robust in each of the sites that are retained. Yes?
Yes.
Okay. Thank you very much. Can we look at one site, which is Malt Street and Nye Wharf? Please. And you'll need to pick up Mr. Alston's rebuttal.
Yes.
You need to go to Appendix D. And there's a letter from Barclay Homes.
Yeah.
There are a number of Barclay Homes sites that were included in the 5-year or the 7-year housing land supply that have been removed as a result of Mr. Alston's work, haven't there?
There are, yes.
Yeah. This is a site that is kept in. There's 153 units in phase 3 of this development. And can we look at what is said at the last paragraph of this letter from Barclay Homes? Phases 2 and 3 will not come forward in line with the extant consent due to similar viability constraints. For this reason, a fresh planning application was submitted on the 3rd of the 10th, 2025, and is awaiting validation by the council. No delivery on these phases is forecast within the next 5 years. See that?
I do, yeah.
That's exactly the sort of evidence that the NPPF and the PPG tell you to look for in deciding whether a site should be left in or left out of a 5-year land supply, isn't it?
It is.
Yeah. Why, can you help me, is that 153 left in when all similar Barclay sites have been taken out?
I can't explain that. My understanding from policy officers was that they accepted all the
me too.
Sites that they were given specific intelligence on. So
yes.
I can't explain that.
But listen, because you're at, remarkably, I can say, for all the purposes that we've been looking at 5.04, if you knock off just 153, it's just one example, you haven't got a 5-year land supply, have you?
No, it'd be very near. I mean, depends how many decimal places you get to, but it's just under 5. Yeah.
Well, because then we'd have to look at other sites, wouldn't we?
Yes.
So, for example, Canada Water. If you go to Mr. Alston's appendices and go to where he's considered every single site, which is Appendix C. Right.
Yep.
Now, we only got this document from you on Friday, so I'm going to have to ask my witness live to deal with it, so that the learned friend has an opportunity to cross-examine. But I'm just picking 2 that I asked Mr. Levine about. Do you remember?
Yes.
Right. And we've got 257. So I'm looking at the last but one page of that appendix.
It's got a site number, Mr.
Yeah,
Nash.
NSP.
Yeah.
B61, I think it is that right? I've got so small that my eyes have given up.
I've had to print them at A3.
Yeah. And the sort of intelligence that we're looking for is the viability statement with a Section 73 application that's gone in that is quoted here. The viability statement in support of the Section 73 application states at para 2, compounded by a period of sustained high build cost inflation and muted value growth, the viability of the master plan has become severely challenged to the extent that the HPP scheme cannot secure further investment and delivery cannot be progressed. Stalled. Evidence indicates not deliverable in the next 5 years. See that?
Yes.
Now that would take another 257. That's just two I've looked at, which I knew that Mr. Levine was involved in. That would take you further below the 5-year land supply, wouldn't it?
Yes.
But it also establishes that it's not a very robust document, because even what you've been told about it hasn't been done. Correct?
On the face of it, yes.
Yeah. And let's bear in mind that 4 weeks before the inquiry, you were telling the inspector 7.21. Now you're telling the inspector, like halfway through the inquiry, but it came in on Friday, grant you, 5.04. And just with two sites that I've looked at, we can show that that's neither reliable nor robust either. Correct?
On those two sites, it looks like an error has been made, yes.
Yeah. But what that means is that you are below the 5-year land supply, and therefore, in addition to the presumption in favour of brownfield development, and in addition to the NPPF and what it says about significantly boosting housing, you're also A, very likely to fail the HDT, and B, certainly fail the 5-year land supply.
Yes, but I would point out that footnote 7 then comes into play.
Yes, well,
Yeah.
that's fine, but
Yeah.
we knew that anyway, and that's
Yeah,
what
sure
we
did.
that's what we are saying. But what it does mean is, looking at your 925, the weight to be given to the provision of housing, moderate, given that the Southwark has a 7.21 housing supply, must be altered, mustn't it?
Yes.
Yeah. And it follows that the weight, if you're being fair, ought to go up.
Yes.
Thank you very much for your patience, and thank you for persevering, because otherwise we'd have had a big adjournment.
Thank you, Mr. Harris.
Any further questions, Mr. Harris?
No, sir. Sorry, I should have said.
Oh,
That's why I was.
Go on.
It was implied, but I should have said.
Yeah.
Mr. Attorney, do you have re-examination?
I have just a few points, if I may. Mr. Ribbett, can you just first of all go to the Southwark plan, have it to
Yes.
hand? And you'll remember Ms. Foster was asking you some questions about main town centre uses and the benefits of delivering main town centre uses in town centres.
Yes.
First of all, can you just remind the inquiry of the relative dates of the London plan and the Southwark plan? What's the date of the London plan?
One's before the other. I should know this off the top of my head, shouldn't I?
Okay, London plan 2021, Southwark plan 2022. Which one came first?
London plan. I knew that.
Thank you. No, I know.
In my befuddled state, I'm afraid that didn't come to mind.
I know. It's not really the question I need anyway. NSP 74, please.
Yes.
And I just want to get you to explain, is the requirement to retain certain uses at a certain level by reference to main town centre uses generally, or by reference to retail uses specifically?
Retail uses specifically.
Thank you. And in your view, is that a policy choice which is consistent with the rest of the policy prescriptions for Peckham?
Yes, very much so, because the retail growth that's expected in Peckham that's set out in policy ST2 of the plan is where that growth strategy and that geographical distribution of that is set out.
Thank you. And if they meant main town centre uses, would they have said main town centre uses?
I imagine they would have done, yes.
Thank you very much. And then can you just go to policy P32? It's page 161 of the plan.
Yes.
And I just want to get this clear. You in the cross-examination, you went first to limb 2, but can we just go to limb 1 first, taken in the order in the policy? Development must retain small shops where existing small shops are at risk of displacement from a development. And then there's consideration of feasibility of providing affordable and suitable space for existing occupiers. Replacement shops should be like for like in terms of floor space or bespoke to suit the requirements of the business, including provision of storage and servicing space. So reading that line in isolation, is that a policy which applies to this case?
It does.
And then when we look at limb 2, the 10% of floor space should be small shops. Is that an additional requirement, or is that the same requirement?
I read that as an additional requirement.
Thank you. And we've been to the definition of small shop you have in the fact box, but just for certainty, a market stall or shop, just on the question of market stall, does that include the marketplace operators on the facts of this case?
In my view, that does include those, yes.
Thank you. Yeah, can you go to the MPPF next? And you were asked to look at various paragraphs, including paragraph 61 of the MPPF.
Yeah.
And Mr. Harris said yesterday afternoon, you see in paragraph 61 the reference to supporting the government's objective of significantly boosting the supply of homes.
Yes.
And he said, so that's clearly the objective, isn't it? And you said, yes, it is, but that includes coming forward where it is needed to meet the needs of groups with specific housing requirements.
Yeah.
Can we just look at the text of 61? And if you just read through it, which part of that paragraph were you referring to there?
Well, the specific housing requirements is one part of that, if you like, caveat or additional point underneath the overall boosting of supply. And then there's the last sentence, which says the overall aim should be to meet an area's identified housing need, including with an appropriate mix of housing types for the local community. And I read that very much as being affordable housing.
Thank you very much. Now, this morning, Mr. Harris asked you some questions about affordable housing provision and the relationship to the financial viability evidence. And in answer to the question about the reasonable maximum provision, said the corollary is that we don't know the basis of the 12%. Do you remember giving that answer?
Yes, I remember that.
Yeah. And you were then referred to Mr. Levine's evidence, where he had said no reasonable developer would contemplate proceeding at 35% affordable housing. You remember that? Yeah. Do you remember also Mr. Levine said that his evidence cannot be used to show that 12% is the tipping point at which the scheme goes from being deliverable to undeliverable?
Yeah, I remember that. Yes.
Yeah. And when asked again, but where that point lies between 12% and 35%, I said, we don't have any evidence, do we? And he said, no, not in front of you. Do you remember that?
Yes.
So, given that's the case, and looking at the question of whether the scheme will come forward, is the evidence before this inquiry that the scheme cannot come forward at more than 12%?
There's nothing showing that, no.
There's nothing showing that. Thank you. You mentioned an extra 50 homes if you were to deliver 20% affordable housing. Mr. Harris said, well, we haven't seen that anywhere. Can you just explain, please, why you say it's 50 homes? We can ask the appellant's witnesses whether they agree.
Yes, so it's the difference between 20%.
Sorry? Oh, okay. Okay, well, that's fine. I'll leave that, and we'll ask Mr. Alston where he says a shift from 12% to 20%. How many units would it be? And perhaps we can agree it's 50 units, or well, okay. Was it's yeah,
You've been tested. Sorry.
fine. I think it's
inappropriate to introduce it in re-examination in this way.
I didn't introduce it, so it's just to be clear, sir. I don't know why this is causing a problem. I didn't introduce it in re-examination. The witness gave an answer, and I'm asking for him to clarify where he gets that from. If Mr. Harris has a problem with that, then I'm sure we can put in a joint note what the shift from 12% to 20% affordable housing would mean in terms of unit numbers. I'm sure we can do that, and we will endeavour to do that if the other side will agree it. Let's move on. Can we turn then to the heritage issue? You were taken to paragraph 255 of the report to committee. Sorry to ask you to pick up that document again with all its shortcomings in terms of the size of the document and the inclusion of material that doesn't relate to this application.
I'm there.
Do you remember the questions were about the key frontage and the impacts on Rye Lane?
Yes.
Yeah. And you were asked about the demolition of the Aylesham Centre and whether that had ever been objected to. Can you just turn then, please, to the section which deals with the demolition of the Aylesham Centre and the impact on the Rye Lane frontage, which is paragraph 235 under the heading Demolition of Existing Buildings. And there's this section of the officer's report. It's page 144 of the PDF. Around 1/3 of the Aylesham Centre sits within the Rye Lane Peckham Conservation Area. This is mainly the western part of the shopping centre and includes the full length of the Rye Lane frontage. And it predates the conservation area designation. It was incorporated into the conservation area not because of its historic significance, but because of the significance of the historic townscape which surrounds it. It's flanked by the two buildings, James and Higgins and the former HSBC. Beyond this and across the street, there's a cohesive and well-preserved historic frontage. The adopted conservation area appraisal notes this and recognises the Aylesham Centre frontage as a negative contributor. Do you see that?
Yes.
Is that a fair summary?
It is, and it's interesting to be reminded of the reason for incorporating this in the conservation area.
Yeah.
Despite it being a negative contributor.
Yeah. And at 236, then, notwithstanding this, so notwithstanding what's said in the previous paragraph, the existing frontage owing to its height is not particularly harmful because it's not visually dominant and it retains key views within the conservation area, including the Jones and Higgins building and its distinctive clock tower. Yeah.
Yes.
And then as such, ... in accordance with the MPF, the demolition of the existing building is considered to be acceptable. However, if planning permission is granted on appeal, officers would recommend a condition preventing its demolition until a new building is in place to ensure that there be no harmful gap. Just in those terms, are officers there saying that there needs to be demolition of that building?
No, they're saying that it's acceptable in the context of this proposal.
Yeah, and then of course they come on to deal with the replacement building that's proposed and identify harm from those replacements.
They do, yes.
Thank you very much. That's all. Thank you very much, sir.
Thank you. No further questions from me. Thank you.
Sir, if I may assist, next on your list should be Mr. Holloway's evidence.
Yes, indeed.
That's helpful. Just maybe a couple of minutes to just let Mr. Or do you want to go sit on that side? It's entirely up to you. But
We'll just wait,
Mr. Ribbit.
5 minutes and
Thank you. Thank you.
I think everyone's ready, so over to you, Mr. Mohammed.
Thank you very much. Sir, may I introduce the Community Action Group's final witness for this inquiry. For the documents that you're going to need, there's proof of evidence together with a summary within it. We will need the London plan that we've been looking at, the local plan, and then we'll be looking at a few other core documents that I won't trouble you with at this stage, but I've got the references when we get there. Good afternoon, can you just confirm you are Mr. Jed Holloway?
Yes.
Thank you. Mr. Holloway, we have your proof of evidence contained at 822 of the core documents. On page 2, you set out who you are. You're appearing as a planning witness on behalf of the Rule 6 party, and you're a solicitor specializing in planning law over the past 5 years experience. And then for the last 2 years, you've run the Planning Voice project at the Southern Law Centre, providing free legal advice and broader support for individuals and campaigns negatively affected by redevelopment. You've worked closely with the ACA campaign for a period of time, paragraph 3. Prior to that role, you were at the Town Legal planning firm, leading planning firm in London that will be known to most people, working on various matters. You're familiar with the Aylesham Centre, and I'm going to ask you a bit more about that. So I'll take the rest of that introduction as read. Paragraph 9, you confirm your scope of evidence, what the issues you're considering, and to what extent your evidence also seeks to complement or align with the council. Is that a fair introduction?
Yes, it is.
So the first question I have for you is just how did you become involved on this site, and what sort of work have you been doing over the years with it?
Yeah, so I was in my previous role doing pro bono work around Peckham with Eileen, and that's how I found out about the job at the Law Centre first of all. And then when I moved over to the Law Centre, one of the first projects was the Aylesham Centre. There was already a campaign formed, there was already concerns. So for the last 2 and a bit years now, I've been intimately involved with the campaign, supporting it not just on the sort of technical legal side, but broader community building, awareness building, understanding of the planning process. So it kind of goes beyond your standard legal role.
Thank you, and you're the reason why I was also involved in that part of the case. Now, there were multiple references by my learned friend in the various committee reports, sections of the various in various sections in the committee report, where there's references made to the Southwark Law Centre's representations. Do you remember those elements? Can you just tell us who wrote those entries? How did they come about? And were you involved?
Yeah, so I wrote those. They are concerns that resulted not just from my sort of technical analysis of the documents, but from speaking to many members of the community, not just the campaign, going to engagement events, awareness events, and hearing what the community were concerned about. And I translated those concerns into sort of policy arguments.
Thank you. And then final question, just on your involvement. I mean, just give the inspector the scale of people who have been engaged on this site, and sort of how representative would you say it is of local communities' concerns?
Yeah, it's very representative. I think there's, sometimes a dismissal that it's the same old faces, but there's a core group of campaigners, then there's a group beyond that, and then there's a group beyond that, and a group beyond that. This is hundreds and hundreds, definitely thousands of people that the campaign has engaged, a very diverse array of people. I myself have been on the streets. I've spent lots of time speaking to the businesses. My colleague Caitlin has spent even more time speaking to those businesses. It's very much a whole community role, and we're very much representing a broad swathe of the community and listening to all of their concerns. And we've been particularly conscious of that we want to capture the whole community's voice in this and want to speak to everyone and make sure they're not excluded.
Can I then just move on to the first heading about the London plan, core document 4.1. the London Plan, core document 4.1. I'm looking at policy GG2, PDF page 32.
Got it. Yep.
Yeah, and this is, and I particularly want to take you to, yes, well, talk us through why this particular paragraph or this particular policy of GG2 is relevant to your evidence.
Yep. So GG2 is good growth. These sort of, in my view, frame the whole London plan, that underpinning idea of good growth. GG2 subparagraph E says development must understand what is valued about existing places and use this as a catalyst for growth, renewal and placemaking, strengthening London's distinct and varied character. And for me, that is exactly what hasn't happened here, kind of across the board. It's been, they've not really taken the time to understand what's valued about Peckham, which is, you know, its people, the diversity of those people, the vibrant culture that comes from them, the businesses, and the kind of retail identity, but also the history and the heritage that ties into that. For me, that's what makes Peckham valuable, and for me, this development really fails to respond to each of those in turn.
Thank you. So you just said this isn't sort of a development for Peckham. Could you just explain why, please, in short order, if you may?
Yeah, so to kind of take the reason for refusal as headings, the housing does not meet the need. And, you know, we've heard that 93% figure a lot, but we need to remember that's for Southwark. For Peckham, it's going to be even worse because this is one of the most deprived areas in the borough, and that really needs to be remembered. Peckham in particular is going to be even worse than that. So it's not meeting that need. Specific reference to CLT, that's not being met. That's specifically identified for this site and for Peckham. The businesses, that very specific identity, they're being displaced. And then again, that heritage history is not responding to that too. So sort of in every sense, it's not, that's Peckham, and that vibrancy is not being protected or respected.
And again, thinking about the scale of this development and thinking about what you were saying about the level of involvement for local people, I think in your evidence of paragraph 12, you say this is by far the largest site allocation for housing in Peckham, and the community will only get this opportunity once. Could you just elaborate on that in terms of what you're trying to communicate there?
Yep. So the other site allocations for housing, well, some of them are for housing, and none of them are as big as this. This is substantially the biggest. So in terms of that scale, it's the most important. It's this central location which gives it a real importance as well. And, you know, this is the one chance to make a big difference in the middle of Peckham in terms of delivering housing that's needed, in terms of delivering retail and bringing those communities along with it, and, you know, getting it right in terms of the heritage and responding to the Rye Lane High Street in that broader context for the conservation area.
Okay, I'm going to move on to the first heading of the main issues now on housing. Paragraph 24 of your proof, paragraph 24, page 5 of your proof deals with various policies and both locally and nationally and various aspects of that. But can we just first start with the site allocation?
Yep.
Site allocation, please. Wherever you can find it.
Yeah, 450 on the Southwark plan.
Page 450 in the PDF
Yep.
Of the Southwark plan. Just give us a kind of your, first of all, just your reading of this policy and how it should work, how it should be applied, just as your interpretation of it, please.
Sure. So I think I would begin with running through it bit by bit. The 850, which we've spoken a lot about. I think there's a flaw in how the appellant has approached it. First of all, it's indicative, so it's not an absolute. Whereas, you know, we'll get onto the other policies which are framed as a must, so they are framed in absolute terms. The 850 applies to the entire site, so it includes the bus station, which is about a fifth of the area. So obviously, relatively, the Aylesham site isn't the indicative isn't 850 for the Aylesham site. The appellant site. And finally, I think it's fair to say that one of the reasons there is this push for densification throughout the plan is because of the cross-subsidy idea that delivering housing delivers affordable housing. And I'd go back to paragraph 61 of the NPPF, the overall aim is about delivering housing that meets local needs. So the 850, the overall aim of delivering that 850 would be to deliver housing that meets local needs. When that falls away with a drop in affordable housing, the imperative for densification also falls away. So I'd view the 850 in that context. And then moving on to the other bits of the policy which are framed as a must. The first one, retain the supermarket use, fine. Provide at least the same amount of retail floor space, clearly not being met. Retain bus station capacity, not relevant to this aspect of it. Public realm, fine. Links, fine. Active frontages, some are being provided, but as we saw from Ms. Stichtenote's proof, they haven't really considered the external areas of that. I read this site allocation as very much including the external areas. I mean, they've obviously included Rye Lane, but beyond that, and as we've seen from Block L in particular, there's a complete lack of active frontages there. The diversification and complementing the existing retail offer in the town centre, that is not being achieved, and we'll go on to explain that. I completely disagree with Ms. Foster's analysis of this policy yesterday. She tried to suggest that the phrase "with new opportunities for a range of shop sizes" is the only way that you can diversify and complement, or that's the only. The site allocation is saying you can own. What we're asking for is diversification and complementing through a mix of shop sizes. I think the comma there is doing a lot of work. It says diversify and complement the existing retail offer with new opportunities in a range of shop sizes. That, for me, that's an aspect of it, but not the whole thing. So even if you are achieving a range of shop sizes, you are not necessarily achieving diversification and complementing the existing retail offer. And I very much believe that's not being met here. Providing new homes, fine. Providing new intermediate housing, not being met. So, about half of the allocation musts are not being met here.
Thank you. And then just thinking about the CLT point, and yesterday I had put this to Mr. Levine as this being the only policy that actually mentions the CLT, a unique mentioning of this particular way of delivering affordable housing. Can I just get you to just reflect firstly on your view on what this means and how the inspector should read it, please?
Yep, so it's framed as a must provide. It's unique for this site, and it actually arose on this site because of campaigning by Peckham, I believe, Peckham citizens in association with London CLT. So it was a kind of worked up package that was felt to be specifically responding to the needs of Peckham, designed for this site. I see it as a must. I agree it is subject to viability, but I'd add a bit of nuance to that. Just because it's subject to viability, if you're not delivering it, even because of, it might be explained by viability, but you're still not meeting that site allocation requirement. It can be, there's a reason that you're not meeting it because of viability, but you're still not meeting that site allocation requirement.
Thank you. Insofar as the 12 units that are being offered by the commercial decision, we're being told by the developer, sorry, did I say 12 units? I beg your pardon. 12%. Insofar as that percentage is concerned, do you know whether it has been explored as to whether the 12% would be of interest to any CLT by the appellants?
Well, there were negotiations with London CLT.
And how did that go as far as you're aware?
I think it broke down because of the financing. Basically, I mean, I believe London CLT walked away frustrated because Barclay weren't effectively negotiating with them and said it was too costly. But I believe there was appetite to deliver CLT.
Thank you. Moving on to then finally the National Planning Policy Framework, the NPPF, paragraph 61. Just so we can contextualize this housing issue in the grander national policy picture. Just let me know when you have the framework, please.
Yep, I've got it.
Paragraph 61 is the paragraph that deals with the delivery of sufficient supply of homes. And yesterday, I think my learned friend had taken it to Mr. Ribbett at some point in relation to it. But can I just invite you to just reflect on that paragraph as a whole, and also just consider the last sentence that says the overall aim, when it comes to the significantly boosting the supply of homes, the overall aim should be to meet an area's identified housing need, including with an appropriate mix of housing types for the local community. How should then the inspector read this question of what the appellants are trying to do, please?
So I think, first of all, I'd stress the importance of overall aim, and it's not a tack on, that it's the overall aim. So everything, when we're discussing housing, that overall aim needs to be borne in mind. Clearly here, the areas identified housing need and an appropriate mix for the local community is a high level of affordable housing, social housing. So that overall aim is plainly not being met. And I think what it also shows is the appellants try to turn the conversation as to suggest, well, this is my view anyway, that they're suggesting that you have to look at London as a single housing market, and that's the only thing you can do. But clearly this is saying, well, at the strategic London plan level, yes, there's the London housing market, and that's what that document does. But clearly you have to look at an area's need and the local community, which is clearly more hyper-local than London. So I reject this idea that you're almost suggesting that you can't consider those things. You have to consider those things as part of the overall aim. It's fundamental.
Historic England is a party that has described this development from their perspective in particular in relation to heritage impacts as a missed opportunity. Do you agree with that in the wider context? What do you think about whether or not an opportunity here has been grasped or not?
Yeah, I think it's pertinent, not just for heritage, which is their context, but also generally to deliver something that's right for Peckham. And that's the language that ACA has used throughout this. This is not right for Peckham. It's not about stopping development. It's about making sure it's the right development. And that this is very much a missed opportunity to do that.
Then there's the question, which I'll be discussing with Ms. Gordon this afternoon, about to what extent house prices will be going up and the impacts on the socio-economic issues. You deal with this in your evidence, and there are various ways in which you deal with it. Could you just summarise for the inspector in terms of where you are on this issue, please? Socio-economic impacts are dealt with at paragraph 17 through to paragraph 23 of your proof.
Yeah, so in my proof, I rely on a statement made by the council in their committee report that the likely effect of a high level of private housing without affordable is increase in local house prices and local business rents, I think, as well. I also rely on the kind of academic research of Habiba Jalali, which is appended to my proof. Since then, in the rebuttals, there's been a criticism of a lack of kind of more more sort of numeric data on that. So I think in response, I would point to the GLA note, which is CD 611, which was added by the appellant. I'd draw attention to paragraphs 1.6 and also 6.1.
We don't need to turn that up.
Sure. But effectively what they're saying is when you deliver high levels of private housing alongside a retail transformation in an area of low income, it is likely, or that the result seems to be, that you increase local house prices. So that's borne out in the GLA evidence. And I'd also point to what has been added as CDs 9.4 and 9.5, two reports by CBRE. They refer to it in positive terms as the regeneration effect. Look how much everyone's local house prices are going to go up. Obviously, if you're a renter, that's a very bad effect. So the first CBRE report 2019, it says an average of 3.6% increase on house prices above the London average. So it's an additional 3.6% increase in local house prices. The other document, I think, is 2024, again, CBRE, and that gives a range. I think it gives an average of 2.2, but it goes, in some cases, all the way up to 5.6 relative increase in prices.
Yeah. Okay, thank you. That's prices again. I'll be delving into that with Ms. Gordon later on, so I didn't want to spend too much. Viability is the other issue that's being discussed at this inquiry. But before I do that, can I just to finish off the point about the prices?
Yeah.
SP5 of the policy, SP5. Is there anything in particular in relation to SP5 that relates to house prices? You mentioned it in your proof.
Yes, I'll turn to my proof because it's taken me a second. So SP5, thriving neighbourhoods and tackling health inequalities. So paragraph 5 focuses on enabling people to remain in their homes for longer. If you're in an area of low incomes, deprivation, precarious housing situation, and you increase local house prices, you're going to seriously, threaten their people's ability to remain in their homes for longer. And I'd add as well that it is relevant to the businesses, the local off-site local businesses as well. If their rents go up, it's going to be an issue. It's effectively, the GLA report calls it gentrification.
Viability. We've heard the evidence of Mr. Venning. We've heard the evidence of him not taking any issues with the approach taken. We know the position of the council. Is that the only sort of material considerations for this inspector?
No, and I think the appellant's approach places far too much focus on, and it seems to be the main focus, is viability. But of course, we have 59, which shows that
MPPF 59.
Paragraph 59 of the MPPF, which says it's in your discretion, sir, as to what weight you give that. I hope we've revealed in our evidence that what the FEA shows doesn't match up to reality. And we've got the fact that there is a commercial negotiation that happens after the FEA process, which should also be borne in mind. And then beyond that, beyond viability and what weight you give to it, there's obviously a host of other concerns and other policies, which I've set out some of them just now, that need to be considered. The viability is just one aspect of housing policy, and it's one aspect of the broader planning balance, and that's what you need to keep coming back to. That needs to be the main thrust rather than viability.
And yesterday, Mr. Levine very fairly accepted that the 12% is something that sits outside of the viability assessment in its way that it was done. He also accepted, in answer to Mr. Turney's questions in relation to that, we don't know what the tipping point is for deliverability. And we also know that the viability assessment and how it relates to H5 is what justifies the 0% being policy compliant, and yet the 12% that sits outside the process is being leveraged as a planning benefit. You recall that exchange?
Yep.
So what's your view on the extent to which a financial viability assessment represents the maximum reasonable for a developer to be able to do this development?
Yeah. I mean, clearly, in common sense terms, what they are saying they can deliver, which is above what the FEA churned out, is what they can reasonably deliver. So in the FEA maximum reasonable policy H5 world, there's one figure. Then in commercial reality, there's another figure.
And just taking that one step further, we know that they have taken a commercial view outside that process of 12%. Do we have any indication that they couldn't go up to 20%, for example, as far as their commercial decision making is concerned?
No, there's no sort of evidentiary basis for the 12% that we've seen in the evidence. It seems to be just a number picked.
And insofar as our inspector is here to understand that 12%, we know that I want you just to invite you to just reflect on how he should factor that 12% into the equation in the history that we know about. July 2024, the 35%, December 2024. Yep. We know what happened then, and we know where we are now. Just in terms of then this inspector deciding this today, what do you want to say about what weight or how he should approach this?
Yeah, so I suppose, first of all, we've seen other evidence that another scheme for this site, in a more challenging financial situation, they said they could deliver 35%, so that needs to be borne in mind. And then also, just in the same way we've seen this reduction from 35 to 12 based on a commercial decision without any clear evidentiary or policy sort of reasoning, those same arguments could just be, they could come with those same arguments again tomorrow and reduce it even further once they kind of back the principle of development and once they sort of get a permission through the door. There's nothing stopping them, copying and pasting the same sentences they've already used to try and take the 12% to zero.
Thank you. And then what we also know is, in terms of when you were inviting the inspector to think about paragraph 59 and the weight to be attached to that, are there other material considerations that are relevant to that judgment, or is it purely about the viability?
I mean, clearly it's, if the weight is discretionary, then other things are going to have to be borne in mind as well. And I think the acute need, the local context is key, tying back to the overall aim under paragraph 61. And the commercial realities that we've just discussed as well. And I think there's a sort of telling thing in Mr. Levine's evidence. He said, well, yes, Mr. Venning has changed the finance costs inputs based on his understanding of the commercial reality. And then Mr. Levine said, well, yes, that's not untrue, but I was limited by the scope of the FVA test, which for me shows, Mr. Levine was effectively saying, yes, the commercial reality of the financial inputs is different to what I was hamstrung by the FVA. It shows to me that you've got to look at that broader commercial context outside the scope of the FVA, and paragraph 59 allows you to do that.
Can I then just reflect on a number of occasions Mr. Harris says the planning system cannot request more than the maximum reasonable amount in line with policy. Do you remember that?
Yep.
On a number of occasions. Is the planning system entitled to try and understand the basis on which 12% is being offered and how we should calibrate that in the overall decision?
Absolutely. Absolutely. I think there's a difference between what the H5 FVA reasonable maximum thing can churn out and this concept of asking for more, but you also have to view in the context what is being offered, whether there is a commercial likelihood that more could be offered, and also bringing it back, is this actually achieving the overall aim, benefits versus harms, is this actually an acceptable development? Even if they can't ask for more, the policy doesn't say, well, you have to say that this is enough. You can say this is not enough, and I'm refusing it. And that's what Schneck kind of achieves.
Thinking about Schneck, core document 1103, so you will have that, and the first page of that judgment, we've put in what the relevance is and the particular paragraphs on which we rely. And it says, this case confirms that it is open to the decision maker to conclude that consenting residential development lacks affordable housing is too high a price to pay, even where the viability evidence demonstrates that none can be afforded, provided there is applicable policy to support that conclusion. Again, when the inspector comes to think about whether or not this development going ahead in this form is too high a price to pay, and then starts to think about what the other applicable policies are to support that conclusion, what would you advise him to think about?
So I'd tie back to 61, overall aim, local need, that not being achieved, the handful of policies that I run through in my proof at paragraph 24, I think it is. So
yeah.
There's what I'm trying to show there is there's a very clear policy basis on which you can find that this is too high a price to pay. And
is that beyond the viability issue?
Exactly, beyond viability.
Okay. Thank you. I want to move on to the loss of retail and the changing retail offer. Now, you are much more familiar than I am with the Section 106 negotiations, so I'm not going to try and summarize them. But what I want to do is, as we're going through the material, it might be worth you just sort of reflecting on where the latest position is on the negotiations.
Sure.
But before we do that, my learned friend, Miss Foster, yesterday was going through the rebuttal of Mr. Alston, and in particular in relation to the numbers and the context of what is happening on the loss of retail and the changing reality of this. Can I start with Mr. Alston's rebuttal?
8.24.
8.24, please. Thank you. And in that document, I think it's at page 30. Bear with me. Let me find the page.
Is it a table?
The table. That was the one. The table that my learned friend took.
It's page 12. I don't know if that's. Sorry, that's page 12 internal. I don't think I have the PDF page.
Bear with me.
Paragraph 3.2 anyway.
Page 12 PDF is page 12 PDF. So internal, and top marks to Mr. Alston for matching his PDF numbers and the internal pages. So the question here is just I just wanted you to reflect on this table in light of the answers that you had heard yesterday in relation to what Ms. Foster was talking about.
Yeah. So
sorry, the context is this is when Ms. Foster was going through this table and also the committee report. Do you remember that?
Yeah. So before we begin, I think reminder that the site allocation and policy P35, the focus is retail. It's not main town centre use, this is retail. So if we want to get an understanding of the loss of retail floor space here, I think this table doesn't set that out very clearly, but also has a couple sort of mistakes or oversights in it that I think need to be corrected. So first of all, on the retail units row, we've got on proposed 3,812.70, triple asterisk, flexible uses, drinking establishments limited to 320 and drinking establishments limited to 320. One of those, the 320, should actually be workspace. It's not drinking establishments twice. My view, which I've set out in my proof, is that you need to assume the least amount possible of retail here. So assume that full 320 is delivered as workspace, in which case that needs to be deducted from the 3812. That's a reasonable view. So if you do that, then you've got a lower amount of retail proposed. So instead of minus 1836 at that point, you have actually minus 2156.
Sorry, just so slow down.
Sorry.
So that's on the retail section A.
Yeah, section A.
And you have deducted
320 from the proposed retail units because it's possible that it could be workspace.
And that figure of 1836 becomes
2156
as a minus.
as a minus. And then if I carry on.
Yep.
So I skip over B, that's workspace, that's not retail. Then at C, we've got ancillary internal space, and they've got the internal mall atrium, which they are not including as retail. The first thing I'd say is it's ancillary to what? It's ancillary to retail. And in planning terms, the use class of ancillary space is the use class to which it's ancillary. So it's retail for use class purposes. Also, it's more than ancillary here because it's literally got the handcarts in it. I think it should be kind of seen as primarily it just is retail. It's got shops in it, and the customers are walking in the atrium when they buy stuff from those handcarts. So so my point is the 1392 needs to be considered in the existing retail. So if you do that.
So pausing there, the 1932.
1392.
Sorry, 1392 should finish that sentence.
That should be a further sort of deduction on the existing versus proposed. So if we had minus 2156, you've got a minus 1392 from that. So you end up with minus 3548 at that point.
So you've just added the two numbers together there of the subtotal A and the internal mall atrium minus as well.
Yeah, effectively moving that 1392 up to the 5109, making sure it's part of the retail.
Okay. So what's the consequence of that? I think paragraph 35 of your proof deals with this.
Yeah. So
paragraph 35 of your proof on page 8.
Yes. So the importance is, well, I mean, before we get to the Southwark target, I think it's important in Peckham terms because it is a retail town centre. That's its kind of identity, and this is the main shopping centre site, you know, with that heritage history behind it. A loss of 3,500 square metres of retail in that is important, but it's also important in Southwark plan target terms. The overall target is an increase in 76,670 square metres of new retail, and 7,000 of that's meant to be in Peckham. So they're relying on Peckham. If you look at the site allocation methodology report for the Southwark plan, it says growth of retail will mainly be accommodated in the redevelopment of 3 large shopping centres, one being in Peckham. I take that to mean the Aylesham Centre. So clear reliance, the main reliance for delivery of these targets is 3 shopping centre sites, including the Aylesham Centre. So instead of, you know, reaching towards that 7,000 uplift in Peckham and main reliance to hit the target, we're actually dealing with a 3,500 deficit here. So completely against the Southwark plan targets.
Okay. Can I just then gallop through the context of the impacts of this? So we've covered the loss of retail point. What about, you mentioned earlier Block L. What's the consequence of the active frontages point that you also pointed out earlier?
So a lack of frontages there is not only a breach of the site allocation, but I think again goes to this question of, you know, the retail identity and vitality. That's not being achieved.
Okay, we've touched upon your interpretation of what diversify and complement means in relation to what my learned friend was saying yesterday. Anything you want to say about that further? You've mentioned how this is breached. Can I just deal with this higher end premium businesses now, alongside the net loss we've just been discussing, and what do you say about that?
So in the CF commercial documents, there's been a few, but kind of littered through their evidence. It quotes what they want to bring on site, and it's all about, you know, this is me quoting them, high end, premium, you know, clearly shopping targeted at higher income people. And that is not reflective of what is already in Peckham. And if you look at the health check, which is in their own evidence, what they say that the town centre is vibrant and has vitality, and they say the reason it does is because of the diverse and affordable and specialist goods offer that it has there. So in terms of sort of supporting that vitality and viability, you're kind of actively harming what gives this place those benefits. You're going against that. It's not affordable by the people of Peckham, so that's a harm as well. And if you look at this specific economic context, again, this is in their documents, they say right now in the troubling economic time, there should be a pivot to value retail. That's what's going to survive because people can't afford very much. So why in that current climate, especially in Peckham, would you pivot to a high-end offer? So it doesn't work for Peckham, and it doesn't make sense in this current climate.
Thank you. And then I just want to touch upon the paragraph 53 on your proof, page 15, paragraph 53, where you're quoting from the draft Peckham area character study. Yep. Just what do you want the inspector to draw from this, please?
Yeah, so I quoted this because this is this gives a kind of flavour of what Peckham's about, and this is based on interviews with local people. So Peckham is praised for its diversity, community links and cultural life. The area is seen as vibrant and authentic, an area with a rich and multicultural community, includes a significant West African community. But then it sets out some concerns as well, which is again reflected from people they spoke to. There are concerns about some changes in Peckham. There's been an increase in pricey shops, bars and restaurants, so we're seeing that creep in, and that's seen as a negative and against Peckham's identity. The people feel these new shops often cater to wealthier white residents. Some pre-existing residents worry they are being left out. I think that trend would be accelerated with what is being proposed here. And I think there's an important contrast in the final quote between Bellenden Road and Rye Lane. So you've got Bellenden, people often say it's a tale of two Peckhams. You've got an adjacent road called Bellenden Road, not far away. I think it's been excluded in some of their analysis, but it's very much your kind of alternative, as it says here, white higher income groups use Bellenden, diverse lower income groups use Rye Lane more. So looking at diversity in the other sense, I think we have that diversity when you factor in Bellenden Road. There's the two offers side by side. But what this is doing is kind of reaching for homogeneity, where we will have two Bellendens. We'll have two white high income shopping opportunities, and the diverse lower income pre-existing residents will be left behind.
I just want to quickly move on to the next issue before we do that. Just on the loss of retail and the changing retail offer in particular, can I just finish this off on paragraph 90 of the framework, please? But 90. Yep. This is where the government, national policy levels, telling us how we should seek to ensure the vitality of town centres. Anything you want to just draw the inspector's attention to MPPF paragraph 90, please?
Yeah, so I mean, it focuses, as you've said, on vitality, viability, and it says distinctive character as well. For all the reasons explained, that is being lost here. So I think this is the proposal's breach paragraph 90. And what I would also say as well, it sets up a scheme through which the borough is meant to decide what is appropriate for a site and appropriate for a town centre. That has been done through the Southwark plan, through the site allocation, and clearly the indication was what's needed here is retail, and what is needed here is a specific type of retail that reflects the vibrancy and the distinctive character. So that is not being met here quite clearly.
And I just want to finish back on that table of Mr. Alston again. Your thoughts on whether or not, what, even if there's a focus on main town centres, what's the consequence of this?
So not to endorse focusing on main town centres, but even if you take that approach, I think on a fair calculation, you actually still have a net loss in main town centre uses. That relies on, so what they've done here is, if you look at C in the table, they've included internal plant and service and basement car park for the supermarket, but they haven't included existing plant and existing car park. So I think you have to, to be fair, you have to consider both. If you deduct those two, so if you deduct the 1544 and the 4731, you end up with a net loss of main town centre uses. That's what, 6,300 something. So if you look in the subtotal A plus B plus C, it's 5,770. So if you deduct 6,000 something from 5,700, you're in the negative. So there's a net loss of main town centre uses, even if you were to humour the idea that that's the appropriate metric.
Thank you. Next is the displacement of businesses. I know there's been moving parts on this, but just to give the inspector an understanding of this, how long have you been trying to communicate with the appellants about the displacement of businesses and what this means, please?
Yeah, so I have a lot of experience with applying these policies in Southwark. It's been one of the key parts of the project. Had this conversation with Barclay on another scheme in Elephant and Castle, Mercato Metropolitano, exact same arguments. Specifically with this scheme, we raised, there's an email appended to my proof, a year ago, October last year, flagging concerns about how they've defined small shops and how they've defined small and independent businesses. And we've had inconsistencies throughout. The email confirmed with our view, and then documents that came since contradicted that view. The appellant has frequently changed their position. At no point have they got it correct. Our point has been consistent throughout and remains consistent and remains correct.
Okay, and then just dealing with just the approach of the appellants to just sort of try and resolve this issue. How would you characterize their attempts at trying to resolve this issue? I know that this thing has been negotiated and is still moving parts up until yesterday.
So I think it all feels very last minute, and it all feels like it's very tacked on to the end of the development rather than it being baked into the proposals itself. I feel like we've largely been ignored throughout this process. But lo and behold, I think they're coming closer to our position. Not that they're close to it, but they've abandoned their old position. So yeah, I think we felt ignored until right in the last minute, and that's frustrating. But it's also important because a key part of this is consultation with the businesses and understanding their specific requirements. That's a key thing we've been asking for throughout, and that's just not happened, and it's not going to happen by the end of this week. So frankly, that infects the whole proposal, and it's too late.
Thank you. Again, thinking about why this matters and helping the inspector understand why this matters. for the purposes of policy P32 in the PDF dealing with small shops, PDF page 161.
I've got it.
We'll let the inspector catch up. It's P32 on the page 161 of the Southwark plan. Again, just help the inspector understand the consequences of what you've just been talking about, please.
Yeah, so I think step one is defining small shops. The appellant now accepts that 2 of the bricks and mortar are small shops, despite frequent refusal to engage with that point for over a year. There's also the handcart traders, which clearly meet the definition of a shop or market stall measuring less than 80 square meters, excluding floor space, and also the marketplace food vendors. It's called marketplace. They're clearly market stalls or small shops. So all in all, you have 10 in marketplace. I think roughly 8 handcarts and 2 bricks and mortar. So what's that? 20 roughly small shops. They're only identifying 2 as small shops, the bricks and mortar. And what the policy requires under subparagraph 1, development must retain small shops where existing small shops are at risk of displacement from a development, full stop. So I reject Ms. Foster's view yesterday where she said there should be full consideration, next sentence, there should be full consideration of the feasibility of providing affordable and suitable space for existing occupiers. She said, so there's no right to return, it's just a full consideration. I think you have to look at those 2 sentences as 2 different sentences. First sentence, must retain. Second sentence, full consideration of the feasibility of providing affordable and suitable space. For me, that's an additional requirement to look at affordable and sort of bespoke terms to make it work for them. But the retention is absolute, it's a must, and that's a separate sentence.
Thank you. P33, just on the same document about business relocation, P33, we can see again what in policy terms is the consequence of where we are on this.
So this begins with where existing small shops or small independent businesses may be displaced. There needs to be a business relocation strategy written in consultation with affected businesses, and it must set out viable relocation options. There's been a lot of to and froing on who should be included. I think they now have accepted that everyone is a small and independent shop. The business relocation strategy has not been written in consultation with those businesses, which is fundamental to understanding what they need and what is appropriate. That's not properly happened. You heard the testimony on the first day. And also the strategy doesn't set out viable relocation options. So it's, what's it based on? They have kind of throwaway comments of, oh no, I'm sure they can relocate to elsewhere in Peckham. There's no real analysis of whether that's feasible, affordable or suitable. And they also say, oh, they can just go to Elephant and Castle. But they know full well that they're currently displacing other traders from Elephant and Castle. There's a historic displacement from the shopping centre in Elephant and Castle, which Latin Elephant gave testimony on the first day. So it's just not realistic. They haven't set out viable relocation options. There's a backlog in Elephant and Castle. And the sad irony is one of the handcart traders was actually displaced from Elephant and Castle. So to say that, oh, just send him back to Elephant and Castle, he was there, and another developer got rid of his space. So where's the viable relocation option for him now?
Can you just say something about the latest UU wording, please? I'm just conscious of the time as well.
Sorry.
Just the latest UU and to what extent. I mean, we'll discuss this on Friday, and you'll be part of that discussion. But just in terms of the relocation, and in particular relocation off-site, and then any likely return. What's the latest position as far as the ACA is concerned?
So I think the EU doesn't meet what's required. P33 is slightly softer than 332. It doesn't require retention on site, but it's clearly the priority, and you have to give reasons why that cannot happen. That's not being done. In terms of there's vague offers of return to site, and we'll get into the detail, but basically, it's not meaningful without temporary relocation, and P33.3 makes that clear, where they're going to go in the meantime, how they're going to survive in the meantime.
So when you say not meaningful unless there's temporary relocation, just explain that.
Because during construction, they've got to go somewhere and they've got to survive somewhere. And the way that the policy says that can be achieved is through the developer offering a temporary relocation site, and that is not being offered here.
Has there been anything that you've seen that is a feasibility study or anything that has demonstrated where such a temporary relocation would be, how it would work?
I've not seen any detailed evidence assessing whether that could happen. There's kind of just statements of, oh, sorry, we can't do that.
Okay.
We've looked into it, we can't do that, but there's no real evidence.
And again, let's help the inspector understand in policy terms. We've looked at the local plan. Let's look at the national policy, please, to help him locate why this matters. MPPF 98, please. Page 28 or of the PDF.
Yep.
Again, help the inspector understand why this matters in national policy.
So this is about providing space for the services communities. And then there's a particular aspect of this that I wanted to draw to your attention. So yeah, D, ensure that established shops, facilities and services are able to develop and modernise and retain for the benefit of the community. And also C, before that, guard against the unnecessary loss of valued facilities and services, particularly where this would reduce the community's ability to meet its day-to-day needs. So I think both of those.
So C,
are not
98C and 98D.
Yeah, D. Did them in the wrong order.
Moving on to the next topic, the equalities context. We talked about this at length in our openings. Briefly, just why does this matter to the equalities question?
As we've seen, all of these businesses are run by individuals from global majority backgrounds. They largely serve people from those backgrounds as well. There's the slightly different question of, do they provide specialist goods? I think the reality is being understated. I think they do, more of them provide specialist goods than has been suggested by the appellant. But that's only one part of the picture. You've also got to look at, if they serve a diverse community, if they are run by a diverse community, and losing those businesses is going to affect both of them. And I, on the specialist point, I have an anecdote here, which I think kind of shows that more nuance is required. And then specifically to this West African specialist point. The question has been, does it say I sell African goods sort of in the description, or is it run by a West African person? If you go to Pax Butchers, halal butcher run by a South Asian man, if you go to the sign for the Aylesham Centre at the car park by the petrol station, and you look at Pax Butcher's little logo, it says on it, we sell Nigerian products, we sell African products. And that kind of shows the intermingling and the ecosystem that you've got here. It's different diverse groups coming together, providing for each other. It's not, you can't pigeonhole it in the way that I think the conversation has been doing so far. And I think that's really important to bear in mind.
Thank you. And then briefly, public sector equality duty. Again, we've dealt with that extensively in our opening, and the inspector can see how we've pitched this. Just give the inspector the understanding of his role and why this matters.
So the duty under Section 149 of the Equality Act, it applies to you, sir, but the appellant kind of gives you the data to allow you to do that. The Equalities Impact Assessment that's been provided isn't sufficient. That's our view, that's the council's view, and even in the UU, they open the possibility of submitting another one, which I see as a sort of tacit acceptance that it's not good enough yet. You cannot delegate or defer that duty. What the appellant is basically proposing is, we'll deal with that down the line because the council will sign off on the EQIA down the line. That would be you deferring your duty. That would be dependent on you deferring your duty to the council after your decision has been made. In public sector equality duty terms, that is unlawful and unacceptable. You need the detail.
Sorry, I was just going to say, you said that in the UU, and again, we'll get to this on Friday, what does it say about the equality assessment?
It's an acknowledgement, I don't have the exact wording, but that one will be submitted down the line for approval that will assess what the impacts are. And then it will be signed off. And in the business relocation strategy might have to change in accordance with that.
And to what extent is that appropriate, adequate?
It's inappropriate, inadequate. You need the full information in front of you to understand what the impacts are and make a fully informed decision. Under the duty, and I would say also just in planning terms.
And again, why does this matter in policy terms? I think we touched upon local policy 33 again.
Yeah, so to understand the socioeconomic impacts, the impacts to the vitality, the distinctive character, the impacts under P33, 32, all of that depends on the business relocation strategy and the equalities impacts and the mitigation. if the details coming later, you don't have it. You can't make a fully informed assessment.
And then back to the allocation policy, please. You've touched upon the must section. You've touched upon the 850. Can I just get you to just comment on the section that says approach to tall buildings and the extent to which that's been complied with here, please?
So there's 3 aspects to the approach to tall buildings. I'm just going to pull it up. And all 3 aspects are not being met in my view. So we've got, oh, sorry, I can't find it.
Page 450 of
yeah, of course.
PDF.
So approach to tall buildings, it's narrative, so it took me a while to find it. Taller development should be set back from Rye Lane shopping frontage towards the eastern end of the site to mitigate its impact. Our evidence is that impact, there is an impact to the conservation area from the tall buildings. That has not been achieved. And in their own evidence, I think they agree that the massing is in the middle and the east, not just to the east. And I think that's quite crucial. The tallest building is in the east, but there's still very tall buildings in the middle, and they accept that. So that is why that aspect's not been achieved. Again, massing should be directed to the east to minimise impact on the view of the city from the Bussey building rooftop. You can see for yourself from the views, I just think they've failed to achieve that. The impact has not been minimised. It's still very, very high impact on the view. 20-storey should be observed. Careful consideration would also need to be given to the neighbouring residential areas and important local heritage buildings. Our evidence is that there is impact to 8 heritage assets, 7 heritage buildings. So again, that has not been achieved.
And then finally, just in your overall view on whether or not, do you have an expectation that the whole policy should be met in part, in full? I mean, what's your view on both the approach and the application, please, of NSP 74?
Yeah, so I would say on the tall buildings, that those are the 3 requirements for kind of consent to do tall buildings, and they haven't met that. So I wouldn't say the site allocation consents to tall buildings they are offering. Looking at this at the whole, in the whole, which is how you need to look at the site allocation, this does not conform with the site allocation. This quite clearly breaches the site allocation.
Finally, on planning balance, I'm going to go through each of the various benefits and the various harms. But just before I do that, give the inspector your sort of understanding of the scale that you're using when he comes to understand your balancing exercise. I think this is Justice Lang that talked about identifying what the scale that you're using is at the outset so that the inspector can calibrate. So what's the scale that you're working with here, please?
There's loads of adjectives and they're unhelpfully used in different circumstances. But I'm going for substantial, the highest, significant less than that, moderate, limited, and then neutral. And then obviously no weight.
Okay, thank you. So then let's start with the housing, the overall housing that's being provided here. How would you characterize that, and what would your view on that, please?
Yeah, I'm saying that is significant weight, and in a normal circumstance, I would say substantial for housing. But that's where, bearing in mind the overall aim, it's delivering housing that meets local need. That is the overall aim of delivery of housing. That is not happening here, so I'm tempering it down to lower end of significant. It's significant instead of substantial because of the local context.
Affordable housing, we know it's 12% that's being offered here. We know the context in which it's being offered. Again, your calibration of what the weight is, please.
Yeah, I'm calling that sort of significant or maybe moderate. It's delivery of affordable housing is a benefit. The benefit is 77 homes. That's regardless of viability. Planning benefit is not interested in the developer's finances. It's how many affordable homes are being offered. But what is relevant to that is, again, the acute local need, and its benefit needs to be seen in light of that. And I also tie back to the point of the likelihood or potential for them to just go back in and reduce that number of affordable homes. So that needs to be seen in that light as well, which is why I take it to a more sort of moderate, significant weight.
Thank you. Given the track record and the history that we know, just help the inspector understand the likelihood or not of this being reduced.
I think it's highly likely they'll go back in and reduce it. So it's certainly something that needs to be seriously taken into account.
Next is
The affordable housing offer will be reduced.
thank you. Another paragraph that my learned friend has referred to is MPPF 125C and the substantial benefit. I can't remember the wording that talks about the use of brownfield sites.
Yep.
Again, how would you say this inspector should approach 125C, please?
Yep. So I was thinking about this, and effectively what 125C does, it was introduced as a part of this sort of brownfield first initiative. The idea is, let's bring forward development on brownfield. It's a principle of development point. We already have a principle of development here. No one's disputing that. And we've got site allocation. For me, it's effectively the kind of a blunt instrument version of the site allocation. So they're kind of doing the one and the same thing. So when we have the site allocation, let's look at the site allocation, because that tells you exactly how housing and other identified needs should come forward on this brownfield site. So I don't think 125C sort of overrides the site allocation. And, we have to bear in mind that the site allocation is not being met here.
And then the workspace that's being offered here, again, the benefit or not of your view on that?
Yes, it's a benefit. It has to be considered a benefit. However, I give it very low weight. I'd give it limited weight because it's not what is identified as the need for this site or appropriate for this site, and it is coming at the cost of the retail that is identified as being appropriate for this site.
Harms now, please. First, in terms of, you've mentioned a number of times the breach of the allocation as a whole. What weight do you say should be attached to that?
Substantial weight.
And why?
It's the clearest indication we have of what is appropriate to deliver on this site, and it's breaching multiple key aspects of that.
And what's that likely to be in terms of the impact on local rents and local people?
Yeah, so kind of turning to the sort of socioeconomic impacts, the delivery of a high amount of private housing, as I've said, will increase local rents. It's going to lead, and this is where Habiba's stuff comes in. Once you establish the point that rents will increase, this indirect displacement that impacts communities, and again, I think has an equalities angle. When you look at people who are most kind of precarious in the housing market, it's going to be, it's likely to be Peckham's diverse, lower income communities. So there's a big socioeconomic impact of delivering this sort of development.
Heritage, we've heard the heritage evidence of Ms. Hegarty and others. Again, the impact on heritage aspects.
Yeah.
What weight do you give this before you explain why?
Yeah, so I give substantial weight, and it needs to be very substantial, I think, because there's 3 different designated heritage assets to which there is a harm. I understand there's dispute as to 2 of those, but the appellant on 58 Peckham High Street accepts there will be harm to the designated heritage asset. That's outside of their whole heritage balance discussion. They accept there is a net harm to that asset. Under the MPPF, that needs to be given great weight. So when you've got 3 of them, and then you've got 7 other locally listed heritage assets that harm is being caused to them, that needs to be given substantial, very substantial weight here.
The net loss of retail that you touched upon, again, what weight do you attach to that?
Substantial, because it's a clear requirement in site allocation. Policy P35, key part of the identity of this area, ties into the heritage as well. And instead of retaining or increasing, we're seeing a serious loss.
The impact of that on, I think you've touched upon this, the borough-wide target and the vitality and identity of the of Peckham.
Yeah, that wraps into it, and I think part of it. This isn't the loss of retail. This is the shift in retail to those higher end things. I attach a separate harm to that as well. That kind of undermines the vitality of Peckham. If you shift its identity and you move away from what the appellant accepts is what makes it vital and viable.
And then you just touched upon there the shift in retail. I think we talked about this in terms of the higher end premium point that you made earlier.
So yeah, they're 2 separate harms. I think I would say both substantial. Thank
you. And then I think the final point is about the point, I guess, the displacement of the businesses, the lack of temporary relocation, the breach that you talked about of policy 32 and 33 locally.
Yeah, I see that as a distinct third harm, the impact on those businesses and their clientele. And again, I see that as a substantial harm. I think it's highly likely that all of them will end up being displaced, and highly likely, at least very highly likely, that most of them will be permanently displaced.
Thank you very much. So those are my questions for Mr. Holloway.
Thank you. I think that's an appropriate time to break for lunch, so we'll take a pause there and just reminding the witnesses in Purdah.
It's really important that people behind me also understand that they shouldn't approach Mr. Holloway or speak to him. I know that they're not familiar with the laws and the rules.
Just to expand on that, there's no discussion with any of the witnesses following their introduction to the inquiry, and that's something we've looked to do throughout the inquiry so far, but just to reaffirm that.
But you can still get me some lunch, please.
So we'll pause there. Thank you. Mr. Harris, I think you're going to start cross-examination, I believe.
Yes, thank you very much, sir. I am. And so I'm not going to re-ask or reopen retail questions that were asked yesterday by my learned friend. I'm not going to duplicate stuff that's going to be discussed at the Section 106 roundtable, particularly in connection with the Section 106 agreement. I noticed my learned friend and the witness are still calling it a UU. It's an agreement now.
It's really absolutely not an agreement. It's a unilateral undertaking. That's the document you have. There may be scope to agree an agreement next week, but it really absolutely is not
Right.
an agreement. And
Well,
so,
then there's a difference of opinion across the room, which is quite a large one.
there's no difference of opinion. It's a unilateral undertaking, sir. That's the document you've had. That's the only document you've got.
Yes, that's the document that was produced because we said we would produce it on the understanding that it was going to be an agreement. But that's fine. That's fine. That's just another brick in the wall that I'll make submissions about. All right, but I'm not going to duplicate stuff. This is the purpose of me saying it, that we are going to discuss in the Section 106 roundtable. It's the same section, whichever, unilateral or otherwise. First question, and it's a point you raised yourself, and the inspector's got to explore this. You're not a planner or a member of the RTPI or the RICS, are you?
No, I'm not.
No, you're not. And you explained very fairly that you are a lawyer making planning judgments, but you also identified yourself as intimately involved with the campaign. Remember that?
Supporting the campaign, yeah.
Yeah, intimately involved with the campaign. I've been on the streets with the campaigners.
Yep.
And that's the context within which you frame and form your planning conclusions in the circumstances of this case.
Yes, I think you can draw a parallel to being employed by a developer.
Well, except, of course, if you are employed by the developer and you're a member of a professional body, then you get relevant training, relevant qualifications. You are obliged to state a declaration in your proof of evidence, etc., which is a position that you don't find yourself in, do you?
No, I mean, no, and I'm not regulated by regs now.
That's fine. But, I'm a lawyer. My own friend's a lawyer. He explained to me I didn't have room for opinions earlier on. I'm not sure that's right, but we're not saying that there's anything wrong with a lawyer doing it, but the inspector's got to look to consider whether you've looked at things consistently and objectively.
Sure. I would say my understanding of the policy is very high level, though.
Yeah. All right. But, you can look at it as a campaigner, or you can look at it as somebody who's got that relevant qualification, experience, CPD, as to how properly to give evidence before an inspector, how to write a proof, those sorts of things. Can we just have a look at to benchmark this, please? In the circumstances of this case, there will be 77 new affordable homes for a section of the community that desperately needs them, correct?
Yes.
Right. Good. Can you pick up your proof, please?
I guess the one thing I would qualify that with is there's a question of shared ownership versus CLT.
Yeah, well, yes, I've understood that. But even if it isn't CLT, these are going to be desperately needed homes for people who desperately need homes, aren't they?
Yep.
Good. All right. Now, when you're drafting your proof, you no doubt did so with care. Can we look at paragraph 23, please?
Yes.
In the light of all the above, you tell us, and you go through all the policy that you say you've got a very high understanding of, the very low level of affordable housing should not merely be considered a lack of a benefit, it should also be considered an active harm to the existing local community.
Yeah, it's not very well phrased, so let me explain that. What I mean is the high level of private housing and the resulting increase in prices that results from that. So it's not the small amount of affordable housing causing a harm, it's the resulting higher proportion of private housing.
Sorry, let me read it again. The very low level of affordable housing should not merely be considered a lack of a benefit, that's a harm. it should also be considered an active harm.
A lack of a benefit is not a harm; it's a lack of a benefit, and an active harm. And it's badly phrased. I'll admit that, but
Yeah.
I'm telling you what the intention was
Right.
when I wrote it, and I think it's quite clear. I'm talking about the low level of affordable housing. If you go back through the paragraphs, I'm saying the high level of private housing that results. It's I admit badly written, but the intention is clear.
All right. Well, maybe it's a slip up. Let me look at paragraph 28.
It's not a slip up. The
Paragraph
meaning
20
is clear.
Paragraph 28. I would encourage the inspector to find that the very low level of affordable housing here is too high a price to pay, regardless of viability, based on the extensive policy breaches and other material considerations set out above. At the very least, it forms one of the planning harms, which, when taken together, amount to substantial harm that outweigh the planning benefits as per my planning balance exercise below.
I'm explaining the socioeconomic harm that flows from the high level of private housing. Again, the very low level of affordable housing is a harm.
It is a harm now.
No, sorry, I'm saying that was misleading, but
Yeah.
the intention again is the socioeconomic harm that emanates from the high proportion of private housing, which is a necessary logical conclusion of a low amount of affordable housing.
All right. See, when you're looking at a proof like this, one of the things you look for in terms of credibility is consistency.
Sure.
So can we look at paragraph page 18?
Yep.
Because when I read, and can you understand, question, that when I read those parts of your proof where you're identifying that provision of affordable housing is an active harm and is something that should be weighed in the balance as part of a substantial harm against benefits, you can see why I'm beginning to wonder, can you, whether I'm reading something that's credible. Well, I read out what he said.
Okay, well, fair enough. My framing of it, the focus on low level affordable housing wasn't very clear. I've now explained what I meant, and I think it's totally credible and makes complete sense. The phrasing was off, but the intention and the substance behind it was not.
Okay, then we go to page 18.
Yeah.
The delivery of affordable housing, particularly social rent, is always a planning benefit.
I don't need to repeat myself. I'm telling you that the affordable housing is a benefit, but the low level reduces the value of that benefit. There is a high, disproportionate amount of private housing here, which is not in line with the overall aim of meeting local need. And separate to that, it is causing a harm through increased prices, local rents.
Yeah, I've heard that. I've seen what you've said in your proof.
Sure.
You started with my learned friend with policy GG2, good growth 2.
Yep.
And you used that as the sort of backcloth to explain what you thought was inappropriate about the development.
Yep.
Now, I appreciate and accept that you've got your own judgment. None of the reasons for refusal suggest that there is a breach with GG2, do they?
No.
No.
They stuck to P1 and they didn't look more sort of broadly.
Well, they did look more broadly because they refer to GG4, for example.
Okay.
But none of the reasons for refusal refer to GG2. So the cadre of officers in control of considering this didn't have that as their starting point, did they?
No.
No, fine. Thank you. And of course, GG2 was part of the development plan when the allocation was renewed, wasn't it?
Yes.
Yes. And so one of the things that the panel had to consider was whether the allocation was consistent in broad terms with GG2.
Yeah.
Yeah, good. Thank you very much.
I mean, there's a question about the reality of how forensically are they going through every single policy. But I take the point.
Thank you. Next, please. You were very keen to ask the inspector to ensure that the planning system didn't sort of move too quickly in relation to in relation to this planning application. Do you remember that sort of line of approach?
I actually don't. I genuinely don't understand what you mean.
Oh,
sorry.
Right. Let me just set it out in a bit more detail then. What you were saying in your evidence in chief and also in your proof is, and I think we've just gone to one of the paragraphs, this is too important a site to get wrong.
Right.
May need more consideration. Remember that?
Okay. I mean,
yeah.
I spoke about the importance of the site.
Yeah.
Yeah.
Okay. All right. Good. Well, I think the point is still fair. This site was a draft allocation back in 2011, wasn't it?
I think so.
Yeah.
I don't know.
And it's been a formal allocation since 2014.
Again, I think so.
Renewed in 2017 and again in the most recent plan.
Sure.
Yeah. Hardly looks like a rush, does it?
You're turning this into a rush thing. That's not how I framed it. I said it's important to get it right.
Yeah. Okay. Thank you very much. I heard you say I'm clear that so far as the CLT part of the allocation was concerned, you agreed that that was subject to viability, quotes.
Yeah.
Yeah, good. Thank you.
It's but then what I added was it's framed in a must language. So it's,
Yeah.
I agree with the concept that delivery of affordable housing is subject to viability, but that is framed as a must in the allocation uniquely.
Yeah. I've got that. But you were very clear that the CLT part of the allocation was subject to viability. You volunteered.
I think that's right. Yeah.
Yeah, good. And if undertaking a viability exercise shows that 0% affordable housing is the reasonable maximum, then you can't require any affordable housing applying the matrix of policy that we looked at this morning.
Yeah, it's the two perspectives of looking at it, I suppose.
Yeah.
Are you requiring CLT on the site? Well, no, we can't because it's subject to viability. Is it delivering what's identified as a need for the site in the site allocation? No. So it doesn't sort of justify, it doesn't mean that you're meeting the site allocation.
No, but if you can't require any affordable home, including CLT, reading the development plan as a whole, if you can't require it, then its absence can't be a reason for refusal, can it?
I think it forms part of the policy consideration still.
All right. Well, I'm just going to note that you didn't answer the question. I don't spend time on it. Do you remember you were asked a question which went along something like this? We don't know what the tipping point for Barclay Homes would be in terms of deliverability.
Yeah.
Do you remember that?
Yeah.
And you were here yesterday when Mr. Levine explained why you don't need to know because it's irrelevant. I'd just like to explore that with you, just to see.
So he said,
let me finish because I haven't asked the question yet. Okay. The question goes as follows. Imagine that Barclay Homes sold this site to Ballymore.
Mm-hmm.
Do we know where Ballymore would find the tipping point?
No.
No. And if Ballymore sold it to a housing provider, would we know where their tipping point was?
No.
No. And if Barclay Homes, suddenly one of its sites went wrong and they were in economic trouble, would we know where their tipping point was?
No.
No. Is the tipping point relevant to an understanding of whether reasonable maximum provision as accounted for by the policies is it necessary or is it relevant to a calculation of where the reasonable maximum provision is?
It's not relevant to that specific scope of question.
Right.
And the policy that emanates from that. It is relevant to the broader planning considerations.
Well, let's just explore that. If there's a section 106 secured on this site, and if you were successful and either the scheme was refused or through the next process, some sort of non-development plan process led to a different figure, and then the site was sold, how would that work? How would that work in planning terms, please?
If whatever you secure in planning, be it affordable housing requirements or anything else, it's the result of a very specific negotiation between the developer and the council.
Okay.
It runs with the land afterwards.
Yeah.
I mean, the specific business offer here, if someone bought the site, they'd have to adhere to the very specific business offer, not very good one. That's outside. The FVA process is objectified, as you said.
Yeah.
Objectivized.
Objectified.
Objectivized. But what we're talking about is outside of that, and
yeah,
it's a weird quirk of the planning process, that yes, it's highly specific negotiations that are taking place that then run with the land.
I'm going to ask you, as I've asked other people who take this view, I'll not comment on it. Can you point to a single decision where the approach set out in the policies has not been followed and has resulted in a reason for refusal based on an inadequacy of quantity of affordable housing?
Do you mean the policy has been followed?
No, where the policy hasn't been followed. We've got hundreds for where it has been. Can you point me?
Can you say again? I
Can you point me to a single case? You've been here, I think, during the
yeah.
So I have asked this of a number.
I'm not trying to be obtuse.
No. Can you point me to a single decision where an approach other than the decision, other than the process set out in policy H5 and P1.1 has been followed?
No, I can't.
No.
But I also don't think that very often there's a community action group representing a fight for more affordable housing, making these sort of arguments. And the fact of previous cases that come before cannot change the inspector's discretion under paragraph 59.
Right, but you read 59 and then you look at what it says is relevant to the exercise of that discretion, don't you?
All circumstances.
Yeah. All right. See, I did quite a lot of work in Elephant and Castle.
So did I.
Yeah. I would say that the campaign there was bigger and more targeted than this campaign. That's just my view, and I'm putting it to you and asking you a question. Do you agree?
I was not there at the beginning of the Elephant campaign.
All right.
But I think this is probably, this is certainly regarded by the council as one of the largest campaigns ever.
Yeah.
A high number of signatories. A whole movement's been created off the back of this.
Okay. Let me just ask you this in terms of the planning system, because we've had a few recent Secretary of State's decisions. I'm just going to put a general position to you. The Secretary of State has recently agreed with a proposition that the number of objections is not a material consideration. It's the quality of the objections that's relevant.
Sure.
And he's also agreed and accepted to this proposition that the planning determination system is a system, not a referendum.
Sure.
You agree with both those things?
Yeah.
Yeah. Good.
Oh, I think quantity is also relevant. I agree that he said them.
Yeah. Good. All right. Next point, please.
But I would also say the quality of those objections has been really strong, and the strength of feeling has been really strong.
Well, so the strength of feeling is different from the quality, isn't it?
No, but I'm saying both are strong.
Okay. Right. I hear that. That's a matter for the inspector to judge.
Yeah.
Do you remember the inspector interposed and said, in effect, are you saying I should reduce the value of the affordable houses on offer now because there might in the future be a reduction of affordable houses? And you said, yeah, I am saying that, more or less.
I genuinely don't recall it going like that. But
do you remember the inspector asked the question as to, it was a clarification of whether you were in effect saying that there was a potential for the number of affordable houses to be brought down by way of another application?
Oh, sorry. Yes.
Yeah.
I think
just wait a minute, because you
sorry.
do remember that. So
I do.
I just want to just confirm with you. Now, this application falls to be considered on the basis of the proposals that are in front of the inspector. 12%.
Yes.
867. That's it. That's his remit. There is no evidence before the inquiry, or is there? Because if there is, I want you to point me to it. That there is any intention of reducing the affordable housing offer below 12%.
Only insofar as the logic of the reduction from 35 to 12 equally applies.
Right. So that equally applies at any time to any application, doesn't it?
Unless the 12% was based in a kind of more evidence-based logical reason.
Got you. No. So I think we're agreeing there's no evidence. You're pointing to a sort of ineluctable logic that would.
I think the starting point to the balancing exercise is the number of homes.
Yeah.
Number of affordable homes.
Good.
I totally think that.
But what you were saying to the inspector was that the weight to be given to that should be reduced, at least in part because of the potential for it to be reduced further.
I think the more important context is the local need and the context of what we're seeing on the ground of people actually needing and the overall aim. I think it's a factor to bear in mind, the potential for that to change as well. But I'm much more driven by the first point.
With the first one, I agree with you. The second one, you're just plain wrong, aren't you? Because if there were such an application, then that would be determined on its merits at the time by a different body, probably the local authority, or a different inspector.
Yeah.
Or the inspector might
I'd take
come back to this one.
I take the point it would be a separate application.
Separate application. So you can't, and it would be determined on its merits then. You can't ask the inspector to reduce the weight now because of what might or might not happen in the future, which would be the subject of a independent consideration then in any event, can you?
I take the point, but I think the reality is that Section 73 is scrutinised in a different way, particularly when you look at the Homes for Londoners guidance, which opens the door to Section 73 coming down the line to reduce affordable housing. I think that is a relevant context.
Okay. All right. I think we've got the point.
I don't think it's, it's much more limited. I'm not trying to say that's massively sways anything, but it's something that I think you should bear in mind.
Okay. I want to look now very briefly at your concerns in relation to retail, because we're going to deal with most of these in the Section 106 session.
Sure.
And I want to look at this in the context of the proposals as a whole. Can we pick up the report to committee, please?
Yep.
And can we go to the executive summary?
Could I have a paragraph, please?
Yes, it's paragraph 11.
Okay. I have a page as well, actually. There's
Page 6 on the internal.
Yeah.
It's above a heading called Planning Summary Tables.
Got it.
Whilst there are a number of other areas in which the proposed development would not fully comply with the development plan, in the main, these could be overcome through the imposition of planning conditions or planning obligations. Planning permission should not be refused for reasons which could be overcome by way of conditions, and to do so would put the council at risk of having to pay appellant costs at appeal. In the light of this, throughout the report, officers have identified which issues could be addressed by condition, and which could be addressed by planning obligations. As part of the appeal process, officers will need to identify which conditions and planning obligations would be required if planning permission were granted on appeal, and the report, therefore, includes a list of obligations which officers consider would be necessary. Then these will have to be negotiated with the appellant as part of the appeal process. First, the principle of that, the approach is to ask yourself whether your concerns, instead of being full-throatedly expressed, could in fact be addressed by condition. Is that the approach that you've adopted?
In relation to retail.
Yeah.
I see what you mean. There's a starting point here, I think, from the Rule 6 point of view, where we say currently it's not sufficient, but with the view to, if we got there, we'd withdraw it. But we're not a LPA, so we operate slightly differently. We're saying what the issues are, and we will remove them if they are satisfied by condition or obligation. But we wanted to stake a claim to those issues from day one.
Yeah. But, one of the things that all Rule 6 parties have to do is to consider whether their concern is capable of being addressed by a condition or not. It's not just the local authority that.
No, of course, and we do.
You have?
Yeah.
Right. So when I put to you a few moments ago, is that the approach that you adopted? You sort of sidelined it by saying, well, no, that's for them, really.
Well, it's nuanced, isn't it? I think it's within my power to say, I think that this proposal and what you're proposing to put in the conditions and obligations currently is insufficient. And that
where is your draft of alternatives then?
Well, where is my ability to negotiate the Section 106? I'm excluded from that process. I have very little faith, and I've been proven correct, that the Section 106 negotiation process would achieve an policy compliant outcome, and that is based on my experience of trying to secure this.
I heard all of that, but that's not the point, is it? When it comes to conditions, there's nothing. I've heard you go into very minor detail in relation to floor space and various other things. Have you given any consideration as to whether your concerns can be dealt with by way of a condition? And if so, where's the evidence?
I haven't presented evidence that gives condition offers as the way out of the solution. But if they were coming, I would happily remove my objection on that point.
Yeah, but if the inspector wanted to look for that sort of engagement, there's none before
No,
the
I mean,
inquiry.
I think that's a high bar you're asking for a Rule 6 party.
No, well, having a
say-
Rule 6 party, sorry, I don't want to cut across you.
Go ahead.
Being a Rule 6 party brings responsibilities as
I'm
well
well
as
aware.
benefits.
I'm well aware.
And you've got counsel here.
Yes.
And we've got the guidance for those involved with inquiries, the blue book, which makes it really clear that, you know, one should look to consider to see whether your concerns could be overcome by a condition.
Okay.
And I want to put some of those concerns just in context by seeing what the officers thought about this, because they did not recommend a reason for refusal based on retail grounds, did they?
No.
No.
We can go to the reasoning for that.
No.
I'd like to go to the reasoning for that.
Just bear with me for a second. They went into a closed session, and out of the closed session came the reason for refusal relating to retail.
Yep.
Yeah. Okay. And retail concerns, valid and otherwise, I don't need to go into that, actually drive the largest number of the objections to this proposal, or at least one of the largest.
One of the, I wouldn't say the largest, but one of.
Yeah, good. Thank you.
It's up there.
Good.
If you include displacement of businesses as well, I would say.
Yes, I was including that. Can we look at paragraph 126 of the report to committee then, please?
Yep, I'm there.
The proposed development would result in a loss of retail floor space compared to that which currently exists on the site, and would also include workspace and drinking establishments which do not form part of the site allocation, but are uses supported by policies about development in town centres. For the reasons outlined in detail above, officers consider that the land use proposed and quantum of floor space are in compliance with the development plan when read as a whole.
Yep.
That was their opinion.
That was their opinion.
And you disagree.
Totally disagree.
Yeah, and you disagree from the standpoint that we first identified in this case.
Yeah, so if you go to the reasons why the officers suggested that it would be okay here, they said, oh, well, you could deliver the retail some retail could be delivered on the bus station site. That's one reason they pointed to. I think that's an error for two reasons. One, I think each development, an aspect of development needs to wash its own face. And two, if you look at the wording of the site allocation, it doesn't say the site allocation must overall result in a net retention or uplift of floor space. It says development must retain or increase retail floor space. So I think you need to look at this development in itself, and you can't just hypothetically say, oh, well, the bus station might deliver some. So that is why I think the officers erred. And I think also if you look, so that's the site allocation, and if you look at P35, that says same thing, retain or uplift in retail floor space. It gives an exception, and I'll get the exact wording. The exception is in the case of something that delivers a public benefit. I'll get the exact wording, but something that clearly doesn't apply to workspace. The wording in P35, retain, so this is P35(1)(3), retain retail floor space or replace retail floor space with an alternative use that provides a service to the general public and would not harm the vitality and viability of the centre. It's quite clear to me that that's being breached.
Okay. Can we look at sort of how planning works? But planning is not the blind following of policies. It requires you to look at the development plan as a whole, doesn't it?
Yes.
Yeah. And here we've got a cadre of officers looking at their own development plan, which includes enhancing the vitality and viability of various town centres, concluding that when you look at the development in the round, it complies with the allocation and the development plan when read as a whole.
Yeah, I suppose the other reason they're relying on that is
Well,
this
is that
reference. Yes, that's what they're saying. But if one of the reasons they're saying that is because of this reliance on main town centre uses.
Yeah.
You go to my paragraph 37.
I know you take a different view.
I'm just explaining.
Yeah. Right,
Why?
go ahead.
Okay. 37C for the inspectors, where I say why I think they're flawed in their approach to main town centre use. I think that infects their conclusion about the development plan as a whole.
Yeah. All right. And then just dealing with the comprehensiveness point, they dealt with that as well, didn't they? They dealt with that under the heading comprehensiveness.
Can I have a page reference?
Yeah, I will give you the page reference, but just before I do, were you aware that they dealt with this issue that you raised in relation to comprehensiveness?
I mean, I've read the.
All right. It's paragraph 65 on page 32.
Oh, paragraph 65.
And there are a number of headings starting comprehensiveness.
Yep.
And it explains the way in which the officers looked at it. At 66, the proposed site layout would provide new north, south and east, west green links through the site, and the potential improvements to the bus station would enable these routes to extend beyond the site boundary, providing connectivity to the wider area. The proposed development would not impact on the ability to provide active frontages facing Peckham High Street as part of a comprehensive redevelopment of the bus station. So they considered that, didn't they?
That's slightly different to what I was suggesting.
Right.
That's frontages on Peckham High Street on the bus station development. I'm talking about Block L.
Yeah. All right.
Which is clearly still part of the site allocation, whether or not development would or wouldn't come forward on that.
Yes, but the point I think that you were making, but forgive me if I'm wrong, the point that I am putting to you is that officers considered the absence of the bus station as part of the site, but considered whether the proposal would prejudice the bus station allocation from coming forward and concluded that it wouldn't, didn't they?
Yeah, I've not made any evidence to suggest it would.
Good, thank you very much. And then there was one, we all looked a bit puzzled on this side of the room. Your suggestion about equality assessment, in effect, being deficient now and requiring some sort of later assessment, freestanding to put right that which is wrong now. Do you remember that?
Yeah.
Okay. I just see whether that's in fact right, or whether there's a sort of misunderstanding.
Sure.
It's right, isn't it? And I think this was gone through yesterday, that the relocation of the traders will only happen after the first phase of development. And I think there's an estimated figure of 2030.
Yeah.
And the point is made by officers, probably don't need to go to it, but the position is raised by officers. And the position is that it's accepted that because things may change between now and then, it's appropriate that the detail of that analysis on relocation, etc., should be determined closer to the date. And there's a series of timetables in this document, starting at 2 years, 1 year, 6 months, 9 months, dealing with that, for example. Now, I'm not asking you about that, but it's in connection with that paragraph 138 should be read. And it's in connection with that the applicant intends to carry out further engagement with the independent businesses closer to obtaining vacant possession of the shopping centre in January 2030. Given that some of these businesses could relocate or close prior to this date, for reasons not linked to the planning application, there could be equality impacts which it is not currently possible to identify. The following paragraphs set out potential equality impacts which have been identified to date. If planning permission is granted on appeal, officers would seek to secure a planning obligation requiring a detailed EQIA to be carried out specifically for the existing independent businesses closer to the time of any likely impacts. That's a perfectly proper position, isn't it? It's not just making good later. It's ensuring that you capture everything with a change of circumstance.
No, I understand. There's sort of two different things here. There's this sort of sweeping exercise. If things change in the 5 years,
yeah,
fine. But there is also a concern that what has been presented is insufficient at this stage.
Well, that's your point.
That is my point. I would say, I think the preceding paragraph set out some concerns about the EQIA currently from the planning officers. Officers consider that whilst the applicant's EQIA provides a lot of general detail, which it defines, it does not provide focused detail about the owners, employees of the existing independent businesses.
And then, next sentence, please.
Additional information has however, been provided in the appellant's follow-up email and a summary of information, but I don't think that information is sufficient.
Well, that's your point. But what you were saying was that the local authority and indeed the applicants themselves have got this later stage because they recognise the deficiencies of the earlier stage. That's not what this says, is it?
No, I suppose it doesn't. I think it's kind of ambiguous as to whether 137 is now enough for them to conclude that the EQIA position is, as it stands, sufficient, subject to the sweep up.
All right. Just last question then, please. You indicated in your evidence in chief that the delivery of housing should be given a significant, but lower end of the significant weight as a planning benefit.
Lowered too significant. I was saying, I would, if it met the overall aim, it would be substantial, but I've lowered it to too significant.
Oh, lowered, right. So it's still significant.
If I'm saying significant.
Okay, yeah. Okay. And then you went on to explain why, because you said you didn't think it was addressing appropriate needs. Now, Southwark has got a formal duty to provide and to demonstrate a 5-year land supply, hasn't it?
Mm-hmm.
That's specific to Southwark, isn't it?
Yes.
Yeah. There's also a wider duty on local authorities in London to seek to meet the very pressing need through London as a whole, which is one housing market.
There is a need to meet the London's housing need, yes.
Yeah, good, okay. And one of the reasons you gave for reducing the value of housing overall, market housing in particular, was because you didn't think it was capable of meeting a relevant need.
The overall aim, yeah.
Yeah. If we've just shared the evidence, if this local authority doesn't have a very specific 5-year land supply, would that increase the weight that you give to the housing or decrease it?
To the affordable housing or to all of the housing?
All of the housing.
If it doesn't, well, it triggers the tilted balance.
I think it does.
But in that hypothetical, which I don't have evidence on, but then you go to 11D, and I think the test there is met.
Yes. Well, I knew you'd say that, but you didn't answer the question.
I did.
No, you didn't, because the question was, if they haven't got a 5-year land supply...
I said, yes, the tilted balance would apply.
No, the question was, if they didn't have a 5-year land supply, would that decrease or increase the weight that you gave to the delivery of housing? Because that is a specific Southwark proposition.
Mm-hmm.
You volunteered the tilted balance. The question was about the weight.
Oh, no, I see the difference. There is a difference. And I think it doesn't affect the weight, because I think the overall aim is the overall aim, and that's still there.
Can we pick up, please, with that answer ringing in our mind a little, can we pick up CD 11.1?
Yep.
And this is a recent inspector's case where actually during the inquiry, as we'll see in a minute, the local authority went from having a 5-year land supply to not having a 5-year land supply. Just bear with me, I'll find my notes. My learned friend who was sitting next to me at that inquiry, so I get there quicker than me. There is a heading, 5-year land supply. Just bear with me. I know it's at the top left of the page. Yeah, that's it. So if we go to paragraph 175.
Yes. No.
This was after an adjournment and the HDT came out and the land supply came out as well. The council currently has a housing land supply of 4.93 years. This is not disputed by the parties. The ELP site allocation expects that development would be implemented in the short to medium term, thereby contributing to the council's expecting housing delivery in the relatively near future. The scale of the proposed scheme and its contribution to the council's future housing provision is particularly apparent when it is removed from the 5-year housing land supply calculation, as would be likely if the appeals were to be dismissed. In this instance, the housing land supply position would be 4.37, and these figures have not been disputed. In summary, based on the current lender plan, the council has a housing land supply of 4.93 years and does not have a 5-year housing land supply. Now, in the circumstances of this case, to be fair to you, the allocation site, the Aylesham allocation site, isn't in the 5-year land supply that we discussed this morning. But there is still, if the inspector goes with the evidence, an absence of a 5-year land supply. So let's see then what the inspector did about that in the planning balance.
Mm-hmm.
We go to the planning balance section of the proposal. And it's 196.
Yes.
197, the provision of market housing would be in line with the site allocations and essential in assisting the council to meet its future delivery targets. The borough has a supply shortfall and a poor record of recent provision. The development would make optimal use of the potential of the site, assist the council in meeting the future housing supply target, and make sufficient use of the land in accordance with paragraph 130 of the framework. This attracts very substantial beneficial weight. So obviously different cases, different circumstances, but are you really saying that the existence now of a 5-year land supply, if the inspector finds that, doesn't shift the weight to be given to the housing at all? That's how I understood your answer.
I think you rely instead on the function of the tilted balance. I think that would kind of be double counting if it affected the weight and the tilted balance.
Is that really what you think?
Yes.
Okay.
I think so. I mean, it's hard to think it through on the spot, but
well,
I
I
would
would
say
say on the spot, is it? You're giving planning evidence
what
on the planning balance
I think
to an inquiry for a Rule 6 party.
So does the change in the amount of housing that has been delivered in the borough change my context of waiting?
That's not the question. The question is the fact that the borough doesn't have a 5-year land supply.
Yeah.
Does that affect the weight that you give to housing that would increase?
I think the notion of a 5-year housing land supply is relevant to paragraph 11 of the NPPF. I don't think picking this notion of a 5-year housing land supply and then applying it back to the weighting, I don't think that makes sense.
Right. Okay, that's fine. That's good for me. Thank you very much. Those are my questions, sir.
Thank you, Mr. Harris. Mr. Mohammed, would you like to?
Do you have any questions? So I'm happy to move on if you don't.
I don't have any questions.
Thank you very much. Mr. Holloway, let's start with the personal attacks first. You're obviously here to give evidence on planning matters, and you were asked about your qualifications to be able to do that. First of all, are you currently a lawyer?
Yeah, I'm a senior solicitor.
And what area of law do you practice?
Planning.
And are you regulated as a planning lawyer?
Yes, by the SRA.
And if you do not do what you're supposed to do, or you're accused of anything, what will the SRA do?
Yeah, regulate me.
Do you, did you, or do you still ensure that you comply with the SRA regulations?
Yes.
And have you been accused of not complying with the SRA regulations? And insofar as the barristers' world is concerned, who regulates the barristers? Do you know?
The bar
council. And I suppose when my learned friend was saying I'm a lawyer, my learned friend is a lawyer, and so on. It's
the bar standards board, apparently.
Sorry, what did I say? Did I say bar council? Bar standards board. I beg your pardon. And so what
we're all regulated here.
Okay.
And I think something I would add is in theory I have the credentials to become a planning inspector. Planning lawyers can become planning inspectors, so that's relevant.
That was going to
of course, but as in it's the same route through either a planner or a planning lawyer can do it. I'm not saying I can be a planning inspector now. I'm saying a route through is being a planning lawyer.
Okay. The next question was going to be about how many inspectors have you seen who do not have MRTPI against their names? Have you come across any inspectors?
It's not yes. It's something I've been conscious of, but yes.
Okay, it's fortunate that this inspector does have those letters, but what would have been interesting to see where those questions would have gone. Right, on the credibility point, you've talked about reaching your judgments. Now, let me test this idea that your credibility is at large, which is what the undertone was. Do you remember what the council's planning witness gave when asked about the weight to market housing. Do you remember yesterday? What did he say?
Was that the one he gave moderate weight to?
Yes. And what weight do you give to?
I'm giving significant here.
So, insofar as
I'm going further than the regulated witness for the council.
Next is about this relevance of the 12%. You're being more helpful to the appellant than the council's witness, but that's a different matter. You're not credible, apparently. Can I ask you about the 12% question that you were being asked, and the 12% being a tipping point? And my learned friend's line of questioning was, there is no evidence before this inquiry that it will be reduced, and that's a matter for a different application for possibly a different inspector. Do you remember that?
Yes.
First things first, what evidence, do we have any evidence of the appellants reducing the affordable housing from one number to another?
Yes.
Do we have any evidence to support why they've picked this number of 12%?
No.
And insofar as why that whether or not that 12% has a tipping point, why it's been picked, why it's not 8%, why it's not 20%, do we have any evidence in relation to that?
No.
So just thinking about what we know the appellants have done and what they're offering now, how does that factor into what might happen in the future?
So on the evidence we have, this appears to be an arbitrary commercial decision with no sort of clear rationale. It could have been 1% higher, 1% lower, or anything else. So the same logic can apply to reducing it to 0.
On the question of your concerns on the retail issue, you were asked about this in the context of the conditions. Do you remember that?
Yeah.
How long have you been raising issues to do with the condition, to do with the retail problem?
Over a year.
And how often have the appellants engaged with you directly on this issue?
Very, very little. I mean, one time they responded to say we were right and then ignored us thereafter.
And given where we are today, have they moved closer to your view or further away from your view?
Closer. Still not there, but closer.
Did the appellants ever write to you and say, Mr. Holloway, we have a condition that could address your concerns. Have a look and tell us what you think.
No.
On the question of the equality impact assessment and its sufficiency today, what's your view in light of the questions that you were being asked in relation to the phasing and what will happen through the phasing and whether that will change? As matters currently stand, what's your view on the equality impact assessment?
My current view is that it's insufficient. It hasn't properly consulted with the businesses to understand their needs or how the community uses them, and that kind of duty of inquiry is a part of the equalities impact assessment process. Their sort of responses and mitigation for the harms that they identify is oh, it's fine, there's other options nearby, or we can relocate them. But I don't think that's been properly evidenced or assessed. So I think detail is lacking there. And then more broadly, looking at the mitigations they look at for kind of socioeconomic impacts, they say, oh, don't worry, we're delivering affordable housing. They said that when it was 35%. It's now reduced to 12%, and they've just said the same thing, oh, don't worry, there's affordable housing. So it doesn't really feel like there's that detailed qualitative kind of analysis going on. So I think it's still lacking in detail. It's not sufficient currently.
Finally, on this question of weighting, I'm not going to ask you about what my learned friend was asking you about, but you did refer to paragraph 11 of the framework. Should we just turn that up to see what that does? And you were talking about the tilted balance question.
Mm-hmm.
Just let me know when you're
I'm there.
there. Bear with me. Yeah, so you can see 11D of the framework, and then can you just look at what footnote 7 says?
Yes.
And just read out that beginning bit up until about the heritage point, if you just help me understand what you see there, please.
The policies referred to are those in this framework rather than those in development plans relating to habitat sites and or designated as sites sites as special scientific interest land, land designated as greenbelt, local green space, national landscape, national park, irreplaceable habitats, designated heritage assets.
Pausing there, you can see where it says about designated heritage assets. So even if we are in tilted balance territory and the application to the policies of the framework, when it says 11D1, the application of these policies in this framework that protect areas of assets of particular importance provides a strong reason for refusing this development. One of those issues being a designated heritage assets, and you've given evidence on the weight that you attach to the designated heritage assets. Do you think they provide a strong reason for refusing this development?
Yeah, here we have harm to 3 designated heritage assets.
Finally, you were taken to a couple of paragraphs at the beginning of your cross-examination as being inconsistent and so on. Insofar as the inspector is concerned, what weight do you say the inspector should attach to the totality of your evidence?
Full weight.
Thank you very much, Mr. Holloway. Thank you.
Thanks.
Thank you both. I'm just going to wait a few moments, but I think we've got more evidence in chief now from the appellants. So I'll just wait for a few moments for the witnesses to come forward. I think everyone's ready now, so, oh. Yeah, I think everyone's ready, so over to you.
Thank you,
Ms. Foster.
sir. Thank you. Good afternoon. Just to introduce our next witness to the inquiry, your name is Sasha Gordon.
Yes.
Miss Gordon, you have prepared 2 pieces of evidence for the purposes of this inquiry. You've got your report, which is an appendix to Mr. Alston's proof.
Yes.
That can be found, just so everyone has the reference, CD 8.07 Part 2, electronic page 116. And then your rebuttal is slightly easier to find because that's a separate document. And then those are the 2 pieces of evidence that you provided to this inquiry. I'll just introduce you by reference to the experience that you've written at the start of your report. You are a director of Quad. You set out there that you've worked in the regeneration economic development and planning fields for 17 years, firstly at Hunt Dobson Stringer Limited, and then when the 2 firms merged at Quad. Is everything you've set out there in your report correct in terms of your experience?
Absolutely, yes.
Thank you. So I'm going to take your evidence as read and just ask you a few supplementary questions. First question, it's not common at inquiries to have a specific witness on socioeconomic issues appearing at an inquiry. Could you just explain a little bit about the relevant skills that you bring in relation to assessing a development and why that's important?
Absolutely, yes. So as an economist, I help stakeholders and landowners, that includes sometimes the local authority. I have worked for local authorities. I help them weigh up different options in the context of resource constraints and their policy objectives. I look at these options and I help them decide which one will be better in social and economic terms. In this particular case, I'm helping decide whether the site allocation and this expression of the site allocation that we are discussing here today has significant beneficial economic and social outcomes, perhaps better than an alternative on the table.
And just starting in this case with the site allocation itself, what do you understand were the social objectives and economic objectives of Southwark in allocating this site? That's policy NSP 74 in the current development plan.
Yes, so both in that site allocation specifically and in the wider plan, Southwark has a very clear motivation and requirement to promote regeneration and change. I was at the committee and this was very much the discussion, and I even I know from the Rule 6 party that they are in favour of change. Southwark also has a very clear commitment to delivering housing of every kind. They have a focus, as does the NPPF and the London Plan, on town centres. And there are the specific words which we've heard a lot at this inquiry, but I will echo because they're very important, and that is vitality and viability of the town centre. That's a strong message running through their plan and this allocation. Southwark wants and needs Peckham to change. This is part of their good growth objectives. And this is part of a strategy and a requirement to improve the quality of its places, the quality of its homes and its buildings. Specifically, if we look at the words that are of specific interest to me in NSP 74, it says attract a variety of retailers to Peckham. And there are several references across this allocation and the other ones relating to town centres about new and existing businesses.
Thank you. And just turning to some of the specifics, particularly an issue that arose in Mr. Holloway's evidence that we heard just now. You'll recall an exchange in the questioning as to whether the 12% affordable housing was an act of harm, and Mr. Holloway said that was in relation to socioeconomic harm. Yes. So just asking you, do you consider the 12% affordable housing offer in this development to be an adverse effect in socio-economic terms?
Absolutely not. That's 77 homes that would not otherwise be delivered, and that I think our minister has recently said people cannot live in a home that's on paper. So 77 homes I do consider to be a benefit and certainly not a harm.
We've also heard a bit at this inquiry about alternatives. What happens if permission is not granted on this proposed development? Do you have any thoughts on that particular issue?
Yes, so I think I said at the beginning that part of my discipline, part of the way I am required by my clients, by local authorities, and by my discipline to think about things is what are the alternative options available? There's a limited amount of resource in this country, then that includes money and land and time. Those are all limited resources. And given those parameters and given all the evidence that I've seen submitted to this inquiry and the discussions I've heard, I do not consider there's any other likely scenario in the short to medium term for what will happen on this site apart from this development. So I guess my alternative in weighing up costs and benefits is do nothing. So that will be the site retained in its current use in the short to medium term.
A particular issue has arisen in the evidence in relation to this notion of residential displacement. Mr. Holloway referred in his evidence in terms of residential use. We'll come on to retail, but in terms of residential use and rising rents and issues around that. You've addressed this fully in your proof and your report and your rebuttal proof, that is. But again, could you just summarise your views on this notion of residential displacement, particularly the allegations made not by the council, but by the Rule 6 party?
Absolutely. I can see how this is an incredibly important issue for local residents as for the London economy as a whole. I think the most important thing to note is that there are no residents currently living on the site. I have worked on many estate renewal projects, including for Berkeley, and that is a slightly different context when you are displacing existing residents. I've written equality impact assessments and health impact assessments in that context. This is very different. There are no people who live on the site. We'll come to businesses later. There are, of course, possibilities, which I fully acknowledge through many assessments of economic impact, of indirect effects. So could something we do on this site have indirect effects? These in the housing market are very challenging to predict. I talk about that and acknowledge that in my report. But the evidence, including evidence presented by the GLA, is quite good and helpful on this, in that it shows that there are two important points. The forces leading to house price increases in a city like London are often unrelated to housing development. They are wider demographic, economic changes, shifts in housing market demand that are well beyond the remit or control of one local authority or the impact of one single site. These will not be stopped by either developing this site or not developing this site, although my conclusion in my report is that they could well be made worse by not delivering on this site. My second point is taken particularly from the GLA study, which I would strongly recommend you read the conclusions of, sir, if you haven't. The conclusions are very clear and helpful. That is reference CD 611 for your notes. And one of the important conclusions for this context is about the fact that housing development in this sort of area may change the type of people who move into an area, but will not necessarily push people out. So it's what we call in economics or demographics a compositional effect. So the average may change slightly, but that's not people being put out. It's a slightly different type of person moving in.
You're referring to residential
I am.
scenarios there, not necessarily to trade.
Yes, I think we'll come to business separately. This is residential, exactly. So, to summarize that, different types of people may move in, but this will not be existing residents being pushed out. I think this is in particularly the case in Peckham, because half of Peckham residents, I'm rounding there, it's a slightly different percentage, but about half of Peckham residents live in social rented homes, so they will not be affected directly by the housing market impacts.
And just to elaborate on that point, why not? Why not in relation to those who are in social rented homes?
So they live in rent-controlled properties. The vast majority of them will be in secure tenancies. There may be some in temporary, so they may not be all, but secure tenancy tends to be a feature of affordable housing in this location. And their rent is linked to house prices, but then capped. So almost all of London, if not all of London, is under the rent cap.
A point you just made, again, just to pick up on as well, is that you mentioned, I'm paraphrasing here, that the house prices and forces leading Peckham to change will happen whether or not this development happens or not. And then you made a comment, you went on to say, in fact, I say it could well be made worse by not developing this site. Could you just elaborate on that point, please?
Absolutely. So those forces will continue. One expects that Peckham has experienced transport investment. Peckham is now very well connected to central London. And house price demand in London continues. I know we've had some debates about that, this inquiry about the weight of market forces happening in the housing market. But I think all of policy and all of national sentiment is clear that we need to build more houses. No one is suggesting that shouldn't happen. So the forces that have pushed Peckham's house prices up over the last 10 years, and they have significantly increased, I would never deny that, those forces will continue unabated, and delivering this development will at least help to slow that.
Now, and then the inspectors rightly mentioned this issue in terms of retail and traders, and separate for a moment the issue of equalities, because we'll come to that afterwards. But just in terms of retail, we've heard a lot about consultation or allegations as to the lack of consultation. You were involved in this a little bit in the pre-app and application process. Could you just explain to the inspector the consultation that did take place, specifically in relation to retail?
Absolutely. So actually that reminded me of a correction I wanted to raise at the beginning, which I didn't. There was a date in my saying what date I was instructed, and I said May 2024. I meant May 2023, which is important to this. So during 2023 and 2024, I was involved. I appeared at the forum several times, and I was involved in commissioning the tree shepherd work. I'll come to the detail of that in a second, but as an overarching point, I was personally involved, and I know the extent of the engagement on this development was well in excess of what I have done on other similar scale developments in London. I think it was a very positive and proactive exercise, and I think the fact that people are in this room today who I recognise is a testament to that. Specifically on the Tree Shepherd work, so Tree Shepherd is a charity who I believe partners with Southwark. I'm not sure of their exact relationship, but they do work together, and they are a business support network charity, and they help local businesses write business plans, etc. And they were commissioned by Berkeley to undertake an engagement process with the existing tenants to understand their needs. I wasn't involved in actually any of the interviews because we considered that would compromise the independence of it. But I helped write the questions, and those questions included questions about equality and included matters such as what type of space would you be looking for in a reprovided unit.
And in relation to retail, we've obviously got the Section 106 session to come, and Mr. Alston's evidence to come, who addresses this in more detail. But could you say a word, please, on the socio-economic impact in retail terms, please?
Absolutely. So just to echo that, I won't comment on the specifics of the square meters or the planning balance. That's for Mr. Alston to cover. But in terms of viewing the impact in retail terms from a social and economic point of view, I think I have three main points followed by a small narrative on Section 106. As an overarching point, I do not sit here to undermine the emotional or financial challenge of a small business moving. That is not what I'm here to do. I can understand that, and they definitely have my sympathy in that context. I don't put that down at all. But in the context of the alternative measuring process that I talked about at the beginning, we need to talk about the scale of that impact. And that's the scale in the context of the high street as a whole, and the scale in terms of the specialist goods, etc., that we have talked about. And I found in the equality impact assessment and in my ES chapter, I believe, I found that scale to be small, and I stand by that. It is a small percentage of a very vibrant and successful town centre, and in economic terms, that would be my conclusion. That is not a personal judgment on those businesses. It is a point of scale. The very important point, I think, is how much time these businesses have to make a decision to move or find alternative arrangements. We'll come to the support Berkeley will provide them for that. I'll mention it briefly, and then I understand it will be discussed extensively at the Section 106 meeting. The point about the time is that we've talked about how long the site has been allocated. I fully appreciate that small local businesses probably don't follow local plan processes. I acknowledge that. But some will have been aware for that long, and definitely many more of them will be aware through the good work of Jed in particular for the last 2 years. And we'll have 5 years from the grant of planning permission to potentially save money or consider alternative premises with the help of Berkeley. So I'll touch very lightly on the Section 106 because that will be discussed more, but I understand there are provisions in there for relocation support, both financial and potential for relocation on site for eligible tenants. There is a point to be made about what alternatives exist in the high street, and there are 3, 4 if you include Southwark's own Peckham Palms, but there are 4 other. So there are 4 other what do you call them, arcades on the high street. these are a wonderful local asset, I agree, but that does mean that there are other local options for small businesses, micro businesses, and there are a lot of vacant units on the high street at the moment. And that is both of those are my personal view based on site visits, not on data. So I don't know the rents or availability of those, but my view is that there is available space.
And we'll hear more from Mr. Alston, who gives more specific evidence on vacancy.
Absolutely.
Rates. Final issue I wanted to ask you about is the public sector equality duty. Now, the operation and content of that legal duty on the inspector and the case law will obviously be a matter for submissions, but you set out in your report in particular, I think it's page 43 of your report. Sir, just for your note, we don't need to go there now, but it's electronic page 154 of Mr. Alston's appendices part 2. You set out a couple of quotes from 2 of the important cases on
Yes.
what the duty to have due regard to equalities issues is. As I say, it'll be a matter that I'm sure we address in closing, but could you just summarise what you've written there, please?
Absolutely. So I think in summary, this relates to the due regard being a process. So that is consideration throughout the process of planning, and that includes usually the process of a site allocation, and I can confirm that Southwark did do that in this process. So it's all the way through the site allocation and drafting of a proposal, followed by conclusion at committee or an appeal. It's very important to note that the due regard is on the public body, so that would have been Southwark and is now you, sir, and you may take into account any factor you consider relevant. So you have before you my equality impact assessment and its addendum. If you agreed with Jed that it was not sufficient, I would encourage you to take any of the information in the committee report, which I found to be very robust, addressing of the issues. Further information I've provided in this appendix and my rebuttal, and any other information you have heard at this inquiry or read in this inquiry, you can take that into account, and I would encourage you to do so. I would like to comment slightly in response to the matter that Jed raised as well. This idea that the duty was being deferred. I don't agree with that. So again, you have all the information in front of you to make your decision, and the only element that is being considered later is if there is any further information that arises as a result of the deployment of the business relocation strategy. So up to this point and to the conclusion of this inquiry, there is a comprehensive swathe of information available on which to make the judgment.
And that takes me to my final question, really. Is it your view that the inspector, in granting planning permission, can fulfil his public sector equality duty?
Absolutely, and nothing in the Baker or the Ward's Corner cases would indicate otherwise in this case, in my non-lawyer view.
Those are all the questions I have for you. Thank you.
Thank you very much.
Thank you. Cross-examination now, please.
I will start this off. Thank you very much. Ms. Gordon, can I just pick up first, please, something you said in examination in chief? Am I right in thinking that you're saying that 12% is not a harm? There is nothing else that's going to be coming forward. If this development does not come forward, essentially nothing else is going to happen. That's my understanding of your evidence. Is that right?
In the short to medium term, I'd say, not in the long term. Perhaps the market could change, perhaps another developer could take on the site. I can't predict the future in that way, but short to medium term, it seems likely.
How do you define short to medium term, please?
Well, let's see, the site's been allocated since 2014, so it's hard to say, but let's say 10 to 15 years, possibly.
So you define short to medium term as 10 to 15 years, long term beyond the 15 years.
I guess so. That would make sense with the local plan period, but that wouldn't be an exact science.
Okay, let's test that, shall we? First things first, your clients have had are outright owners of this site since 2021.
I Believe so. I believe so.
I mean, I'm struggling to see why you wouldn't already know that. If you're going to give us evidence of certainty that or whether or not something's going to happen in the next 10 to 15 years, I would have thought you'd be very clear about how long they've owned the site, surely. Do you know when they got the site?
Yeah, it's not directly relevant to my evidence, but yeah, I understand they own the site.
It is completely relevant to your evidence. If you're trying to tell this inspector that nothing's going to happen in the next 10 to 15 years, I would have expected you to have a bit more evidence from Barclays, including you knowing when they got the site.
I don't think that I am referring to something not likely to happen is to do specifically with Barclay. It's to do with the evidence that Mr. Levine and the rest of the group have talked about. To do with the plausibility of any reasonable developer coming forward on this site with an alternative proposal.
Hang on a minute. We're here to talk about a reasonable developer, and Mr. Levine's evidence was purely about the viability of this scheme based on what Barclay has put forward in terms of their own costs and their own viability assessments. Are you saying that the short to medium term that you're talking to us about has absolutely nothing to do with Barclay, and it's just your hypothetical of understanding of what a reasonable developer might do? Is that what you're saying?
I think so, yes, actually.
So the 10 to 15 years short-term analysis has got absolutely nothing to do with your understanding of what Barclay might do.
Yeah, and I actually think that's a stronger point. Because Barclay could say, in theory, yeah, they could sell the site, and then would another developer come forward? I think Mr. Levine unequivocally concluded no.
Nothing to do with Barclay's intentions, I'm going to write down. And so your idea that this is a stronger point relates to a desktop-based exercise of an economist looking at what might happen in the short to medium term is essentially what you're saying.
That is what I'm saying.
And so when this inspector tries to understand whether the actual alternative to this development is nothing, he will not be able to reach that conclusion on the basis of what Barclays thinks at all. That's the conclusion. The answer to that must be yes. So when he comes to look at this and take a view on your evidence that the alternative to this development is nothing, he'll be able to say, Ms. Gordon told me that, and it turns out that that's not the view of Barclay. That's just her view based on a desktop exercise.
That is my view as an economist in this situation with the evidence presented to me, yes.
Yeah, but nothing to do with the intentions of your client.
Their intention is to build the site if it is granted.
No, Ms. Gordon, what if we're talking about a scenario where this is not granted? So
I don't know what they will do. I've put forward my view of what I think is likely, and I use the word likely.
That's why I want to get what you're saying correct.
I don't know what they will do.
You don't know what they will do.
No.
So insofar as you're saying, and this is very easy, insofar as you're saying nothing's going to happen, that conclusion has got nothing to do with what Barclays thinks.
No, it's to do with my
Good.
likely view of the outcome.
Okay. That's surprising because you're here to give evidence on behalf of Barclays, and it's surprising that you didn't even ask them what they might do in the short to medium term in the alternative. That is quite surprising.
I don't think it is in the context of what we're trying to do here.
Okay. Barclays are the outright owner of this site.
Yes.
They're in the business of making money.
Yes.
They're in the business of building homes.
Absolutely.
They've been an owner of this site since 2021.
Yes.
They've put in a planning application last year that's gone through various iterations and spent hundreds, if not thousands, hundreds of thousands of pounds to getting to this point, yes?
Quite so, a large amount of investment, yes.
Exactly. And even though all of that, despite all of that, and even though they're paying you to be here, you didn't even ask them what they would do in the short to medium term if they don't get consent.
No, I didn't.
That is quite surprising, isn't it?
No, I don't think so.
Fine.
I'm here with a specific goal in mind. And I understand that they've spent a lot, but that is why this is why they've put forward the proposal today and come to this appeal.
Well, I'll make my submissions on that, but I think we've got the point about the weight toward how we see what you say about what will happen in the short to medium term. Okay, going back to the main cross-examination point. You're an economist, Ms. Gordon?
I am.
And a big part of understanding economics is people's incomes, people's expenditures, how all of that works, yes?
Absolutely.
Did you know that 93% of households in Southwark Did you read my opening remarks?
I know this comment very well. Yes, I know it appears in the local plan, and I am aware of this graph. Yes.
Right. So the 93%
Yes.
income that requires social and intermediate housing.
Yes.
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 Where do you deal with that in your evidence? I don't see a single reference to that in your evidence. And you're an economist, and you didn't look at the fact.
I did look at it. In fact, I have my own version of the graph on my.
Where is it in your evidence?
It isn't in my evidence.
So you're here to tell us about economics and the impact of this regeneration project on people's socioeconomic impacts, and you do not grapple a single sentence in your evidence the fact that 93% of people are in some form of social or intermediate housing.
Let's clarify those numbers slightly. So I'm going to say one thing in response to your point about why it's not in my evidence. I write somewhere in my evidence, in fact, probably in multiple places, that there is clear and unequivocal need for affordable housing.
I didn't ask you about that.
But that is the statement that we're getting to.
I didn't ask you about that.
I acknowledge that, and I would never deny that. Southwark needs affordable housing, as do Peckham residents.
Miss Gordon,
but if we go to the 93%
yes,
point,
why is that not in your evidence?
I didn't put it in there.
Why? Is it relevant?
Because it is covered by the point that I say there's clear and unequivocal need for affordable housing.
Is the fact that 93% of people and their income, you're an economist, need social or intermediate housing, is that relevant or irrelevant to your evidence?
May I question the 93% because I don't agree with it in its own terms?
You don't deal with that in your evidence, so I do.
I deal with the fact that there is clear and unequivocal need for affordable housing.
Is this relevant to your evidence?
I do not agree that the 93% reflects the number that you think it means, Mr. Mohammed.
So is it relevant or irrelevant?
A number of percentage of affordable housing need is of course relevant. But the 93% is being mischaracterized in this inquiry.
Okay, let's have I'm really genuinely, that's the first I'm hearing of that.
Well, that's because it's the first time I'm speaking, Mr. Mohammed.
Well, it's not in your evidence, Miss Gordon. You can't make up evidence on the stand. I'm here to cross-examine you on what's written down. And now you're saying that the 93% figure is mischaracterized. How do I test that if that's not in your evidence? How do I test that?
I could tell you why I think it's mischaracterized, but no, it's not in my evidence.
So
would you like me to tell you?
You had the opportunity to tell us in your evidence. You didn't. So I'm here to ask the questions. Let me quote the passage to you.
Absolutely.
This is in the Southwark Plan at page 108. It talks about the SHMA identifying a need of 2,077 social rented and intermediate homes, which is approximately 71% of Southwark's total housing need. And then it says the CACI paycheck data confirms that 93% of households in Southwark have a household income that requires social and intermediate housing. There is a high proportion of residents that require some type of affordable housing. As such, we require social rented intermediate housing to be provided on all developments as either on site or as a priority for major developments. Now, you take issue with that 93% figure.
I don't take issue with the way it's been used in that sentence, to be honest, because it doesn't then go on to say 93% of homes are.
Where is that in your evidence?
I didn't put it in my evidence, Mr. Mohammed, but if you would like me to answer the question, I will.
I'm asking you why you didn't deal with it.
Because I wrote the statement, there is clear and unequivocal need for affordable housing, and I considered that covered it.
Okay, fine. So if this inspector agrees that 93%, which is what is said here, 93% of households in Southwark have a household income that requires social intermediate housing, and also, do you also quibble with the fact that 50% of households live in social rented homes?
I do not. That's my own number in my own report.
Okay, so you say he agrees with that figure of the 93%. And he agrees with the 50% of households live in social rented homes.
Yes.
This is a scheme that is introducing 88% of market housing into this context. An introduction of 88% market housing into that context is fundamentally alien to this community.
It's not inconsistent with a mixed and balanced communities approach, and there are still 77 affordable homes that would not otherwise exist.
I'm going to come back to whether or not this amounts to a mixed and balanced community. But in the context of 93% and the 50% of social rented, a scheme that is skewed to the position of 88% market housing is alien to this context in those stark numbers.
I don't agree. 93% of households in Southwark have a household income that requires social and intermediate housing. That is not I don't. So you've not given me the opportunity to argue with the 93%, which I would value. I think the room would value if I could do that.
No, I'm sorry. That's not how it works. I'm not sure when was the last time you gave evidence at a public inquiry, but that's not how it works. I'm here to try and challenge you based on what you've put in your evidence. I can't challenge you on something you say on the stand that I don't have time to check, assess for myself, take instructions. That's just not fair, and that's not how it works.
Fair
You
enough.
understand that?
I do understand that my position doesn't change. It's consistent with the mixed and balanced community, and it's consistent with delivering 77 affordable homes, which would not otherwise be there.
Okay. I can deal with that in my submissions. Do you agree that this development represents a once-in-a-generation opportunity for the people of Peckham?
I think I probably do.
And whilst the development can't get everything aligned to Peckham's specific needs, it's also important for our inspector here to get the balance right insofar as meeting the need that's identified in the local plan as much as possible.
As much as possible.
Did you hear on the first day that the Reverend talking about the population of Peckham decreasing by a certain percentage? Do you grapple with why that is, and what is the main cause of that in your evidence?
Is this in respect to the decline of, or purported decline of families in London?
Possibly, but I'm asking whether you.
I don't think I did. I know a lot about it, and again can comment on, but no, I did not deal with it in my evidence.
I'm asking you whether you've dealt with it in your evidence. And
I don't believe so, no.
Okay. So in terms of then thinking about mixed and balanced communities, this is what you wanted to check. Do you agree with me that any development of this scale should aspire to have a mixed and balanced community?
I think it's a general principle of planning, noting that this isn't a site-specific thing, a mixed and balanced community. It's a wider place-based matter.
Hang on.
From an economic point of view, this is does not always to be viewed on a very site-specific basis. It's a wider community matter.
Okay, so your understanding of what it means to be a mixed and balanced community is not something that applies to on a site-by-site basis?
That's not the way I would view it as an economist. Perhaps a planner would say something slightly different with respect to policy, but as a planner talking about demographics, I would look at it on a wider scale than an individual site.
So tell me, when you read mixed and balanced community, you read it as what? As something that is not site-specific, but then tell me what.
It might be based on a neighbourhood basis, or it says community, so however you would define community. Okay. In this case, for most of my evidence and research, I looked at the 2-ward area of the neighbourhood.
Okay. And then again, just in terms of, so you're not doing it on a site-specific basis. A planner might have a different view. You say I look at it more on a neighbourhood basis. Just thinking about it on a site-specific basis, I'll make my submissions on whether your approach is right or not. But in terms of site-specific basis, do you say that the 88% market housing that leaves it at and what we're dealing with here of the 12% affordable housing, just putting viability aside, putting your views on anything else, just as a pure numerical exercise of you being an economist, do you think that that's a mixed and balanced community? It's
definitely mixed. I would say it could be better, and I've said in my evidence that there would be greater public benefit if there were more affordable homes. I don't think anyone is denying that, and that it would be more mixed if there were more affordable homes. But it is still mixed.
So if it was 2%, would it still be mixed?
Yes.
So even at 2%, it would be mixed. Okay.
I think so. Again, less so, but it would still be mixed.
Okay.
I think it might be helpful to point, it's not in my evidence, but it is in submission to this inquiry because it's in the ES chapter, the socioeconomic ES chapter that has a child yield summary, which talks about how many children might live in the development. This is slightly in respect to your family's point, Mr. Mohammed. And there are projected to be circa 300 children living in this development based on the unit mix and the GLA's model.
So the answer to the Peckham's population decreasing is there going to be more babies?
Yes.
Is that your up? Okay.
Well, the question was, did I submit any evidence related to the the decline of families in Peckham and London.
Well, my question was, did you grapple with why there was a decline of the population of Peckham of 3% between the last census period?
No, I didn't grapple
You
with
didn't
that.
grapple with
But
that.
we were talking about the statement made by the Reverend on the first day about his school closing and children leaving the area. So it is relevant.
Thinking about the question of socioeconomics, do you also accept that it's not for us to understand whether or not this is going to be a mixed and balanced community? We need to understand the relationship between the housing and the commercial elements that are going to be introduced.
I'm not sure I follow. Sorry, do you mind saying that again?
So we have an issue with the fact that there is the market housing that we say is more than, let me rephrase that. We have an issue with the affordable housing that's not being provided on this site, as you're aware.
Yes.
And we've had this discussion about what threshold is a mixed and balanced community. You've told us that 2%, in your view, meets that threshold. We're dealing with we're dealing with the 12% and the 88%. That's a different point. What I'm trying to understand is the type of retail uses that are going to be lost on this site, and the type of commercial space that's going to be introduced, and all the impact that that's going to have in socioeconomic terms. Do you agree that that's also part of the picture of understanding what it means to be a mixed and balanced community?
I think it probably is, yes.
Good. And so the combination of lack of sufficient affordable housing and the retail offering and the commercial uses to be introduced, if that is not the appropriate balance, you can say that this is not going to result in a development that will produce a mixed and balanced community. Is that fair?
I don't think I agree with that on the retail term, especially in this context. Perhaps in a different context, I would agree with that in theory, yeah, but not in this context. I know that there's been a lot of issue taken with the various CF reports. I know there are many of them, as Jed points out, and they have example retail units in there that I know are distasteful to some residents and not in accordance with what residents would like to be seeing there. They are examples, and they are not definitive of who the tenants will be. And there are also parts of those reports that say that the tenants will benefit from being curated according to the independent and lively. I'm paraphrasing. They definitely use the word independent, and they definitely use culture of Peckham.
Okay. I'm going back to my question, which is that I think we're in agreement that when you come to understand the question of whether or not this development will result in a mixed and balanced community, we have to have regard to the lack of sufficient affordable housing from our perspective, the type of retail uses that are going to be lost, and what type of commercial use is going to be introduced. Those two things in combination is a material factor in understanding whether this development will result in a mixed and balanced community. Do you agree with that?
I agree that it's material, but I don't agree with your conclusion on the retail. So I don't think it's an adverse effect.
But I didn't ask you about a conclusion, did I?
Well, you're asking me to say that in combination, the effect would be adverse. And I don't agree that the retail contributes adversely to that combination.
I didn't ask you about anything to do with adverse. I've got my own evidence in relation to this. I'm asking you to agree with the proposition that we say there's a loss of retail use. You're introducing a commercial a space and use that we say is harmful. You don't need to agree with that. But what I'm asking you to agree with is the combination between the two in socioeconomic terms, as an economist, is relevant to whether or not you have a mixed and balanced community. And I think you agree with that.
I do agree that it's relevant, yes.
To the mixed and balanced communities?
Yeah.
Okay. On the question of the African heritage goods and services, you've been to the site, you've looked around
many times, yes.
Now, would you agree with me that these sort of African heritage and services, African heritage goods and services based businesses that you see in and around Peckham is a particularly unique and significant part of the local economy?
I would, yes. It's The point that I would add to that is that the provision of that is quite extensive along the full length of the high street.
And any price rises that result from this particular development will impact beyond the Aylesham Centre, but across the town centre as a whole.
I don't agree that there will be price rises in the retail from this development.
Are you able to tell us what's going to happen in the local economy in 10, 15 years' time?
I can't predict it,
So
but I don't think it's credible that this development will directly lead to retail increases.
You have absolutely no evidence to support this.
You have no evidence to the contrary.
You're not. Listen to my question. Any price rises? I'm sure you have lots to get off your chest, but listen to my question. Any price rises, I said to you, any price rises are likely to impact the areas beyond the Aylesham Centre to these particular businesses that we're talking about. That's a matter of fact.
That is a matter of fact. It's not to say that they wouldn't be able to withstand that. Again, that is outside the remit of us being able to predict.
I agree. But that's why I'm not trying to sit here and pontificate about what the economy will look like in 10 years. But I think the proposition is we've agreed that these particular African heritage goods and services businesses in this particular location are unique, and they are a significant part of Peckham, and any price rises from this development will impact not just the Aylesham Centre but beyond. And I think
you've said from this development, and I do not agree with that.
No, I meant from this development.
Yeah, and I don't agree with that, which is what I said before. You asked me to hypothesize if there was a general price increase, and now you've said increase from this development. Those are different statements, and I do not agree with the latter.
Okay, let me try that again. Any impact on prices from this development, insofar as they do happen, will go beyond the Aylesham Centre, but will impact the whole town centre as a whole. Any price rises. Doesn't mean it will happen, but what I'm saying to you is if it happens, it will impact beyond the Aylesham Centre and impact the town centre.
There's a lot of words added there that I don't agree with. So I think we have to agree to disagree there.
No, I'm sorry. That's not a good enough answer. I'm asking you a very simple question. If there are any price rises that result from this development, if they're going to be beyond the Aylesham Centre and they're going to be impacting the town centre, do you agree with that or not?
I agree with that statement.
That's what I mean.
There's an if, and we don't know by how much it will impact the rest of the town centre.
We don't know either way. You haven't produced any evidence that it won't, and I haven't got any evidence that it will.
Correct.
That's where we've got to leave this inspector to exercise his judgment.
Agreed.
But where we do agree, though, is that there are specific, unique businesses in this location, and if there are rises from this development, it will impact the town centre. That we agree on.
It may impact the town centre.
Thinking about then the question of this link between new homes and the increase in house prices, let's just look at a few of the documents that we do have. The GLA note that you referred to earlier at 611. The housing research note to the affordability impacts of new housing supply. You'd refer to some passages, but were very careful to not refer to others. So I just thought I'd deal with this now. Have you got that in front of you?
I do, thank you, yes.
So what this is a document produced in August 2023. We can see that it's trying to understand what affordability impacts are from particular housing, and it's a relatively recent research. And can we agree that the inspector can rely on it for the purposes of trying to understand what might happen?
I think so, yes. I think it's a very useful piece of research.
Okay, so let's have a look at what it says. 1.4 says, this research finds in general building new market rate homes make other housing more affordable. It does so by creating chains of vacancies and moves that can reach across an entire housing market area. That's talking about the context of the whole of London?
Yes, probably, yes.
I mean,
well, a housing market area could be, we've talked about it as a one London housing market area, but you could get sub areas.
Right.
Yes.
Okay. These moving chains improve the availability and affordability of housing throughout the range of prices and rents, including for low income households.
Yes.
we talked about earlier, that should be understood in the context of Peckham, where you have people who, half of people live in social rented homes. That should be the context to understand this.
Yes, although those residents aren't buying homes.
Correct. 1.5, building market rate housing, therefore, indirectly increases the availability of a more affordable low-income households, although not as directly as building social housing and other kinds of affordable housing. Now, when it says building market rate housing, therefore, indirectly increases the availability of homes,
Yes.
That's in the context where you're cross-subsidizing affordable housing through a market housing-led scheme.
No, that's not what it means, I don't think.
Building market rate housing, therefore, indirectly increases the availability of homes affordable to low-income households. Tell me how many people from low-income households in Peckham are going to be able to afford your scheme?
No, well, that's not what that statement is saying. That's about the general level of supply in the economy, if we're talking about a supply and demand situation.
So what you're saying is that the more housing that's provided, the cheaper it will get?
Yes. That is
Where
how
do we have-
broadly the housing market works.
Do we have any evidence in recent times where more supply has led to prices dropping, Miss
No,
Gordon?
because demand has continued to exceed supply
Okay.
continuously.
So there is absolutely no evidence to substantiate the idea that that would happen in Peckham or anywhere else in
Well,
London.
there is evidence in this report that says that it slows the speed of growth. So if you have a closed market,
I'm trying to
continue to increase.
overhear people laughing in behind me, so forgive me.
I can see them.
Carry on. Forgive me. Go on.
So that statement is not about cross-subsidy. That statement is about supply. It then goes on to say not as directly as building social housing, which would be your cross-subsidy point.
Exactly.
And I don't disagree with that. Of course, building social housing is the most effective way to deliver affordable housing. That's plain.
And you're not doing that here.
Because we can't, subject to viability.
Right. So that's fine. I mean, that's a viability point, but the point is you're not. If you look at page 13 of the same document, a couple more references. You took the inspector to a couple of paragraphs, but you can see the conclusions here. If you look at page 14, and the third bullet point, building market rate homes only building market rates home only in low income areas will induce higher income households to move into those areas, potentially increasing gentrification pressures. That's directly relevant to Peckham, isn't it?
Yes, I would say it is relevant. Yep.
These pressures will be greater if new homes are accompanied by significant improvements in local amenities. Next one, building new market rate homes in high income areas ultimately reduces gentrification pressures elsewhere. That's not relevant to us.
No. It's relevant to the London housing market as a whole, but not directly relevant to this application.
Yes,
agreed.
I agree. And the last bit, the penultimate bullet point, when demand for high cost homes is not met, repeat, not met by new supply, it is primarily low-income households that will lose out, because low-income households benefit from the construction of even higher cost homes, while high-income households can afford to satisfy their housing needs, even in the absence of new supply. Now, that paragraph is, again, the housing market area as a whole. And if there is no evidence that, for example, building all this market housing in this particular area will give people an opportunity to be able to buy that based on what we know about their incomes.
What that latter bullet point is saying that is if you don't build these homes, I take slight issue with the use of the word high cost here. I checked if it defined it in this report, it doesn't. But if we just take that to mean market housing, where it's not met by new supply, this will be primarily low-income households that lose out. I think that's probably the most important statement in this report, is that if we do not build these homes, the housing pressure on Peckham, because of the wider London market housing pressures, will continue unabated, and there will not be homes to absorb it. The impact will be on local people who might otherwise be able to buy or rent in the area.
So what you're saying is that if there's a development that's introduced into Peckham that does not meet Peckham's local housing needs, if they don't accept more housing that's market that does not meet their local housing needs, things will get worse anyway.
That's what that bullet point that you've taken me to says.
And is that your evidence to this inquiry?
Yes.
Okay. And if this development was to actually meet people's local housing needs by providing more affordable housing, What's the result of that?
That would be a greater public benefit. I'm not in denial of that.
Last bullet point, but while all kinds of new homes ultimately improve the availability of housing across the income spectrum, new social housing provides the most immediate and direct benefits for low-income households. So the only way to immediately help and directly benefit low-income households in Peckham is to increase the affordable housing.
It doesn't say only, it says immediate. So there's an indirect versus direct point there. So the report concludes, totally correctly, that the most direct way to meet affordable housing needs is to build affordable housing. That is clear.
No.
But there's an indirect point that we are addressing here.
No. While this last bullet point talks about all kinds of housing ultimately helping across the income spectrum, but it talks about particularly for low income households like in Peckham, the most immediate and direct way of dealing with this issue is to build more affordable housing.
And I agree with that. That's
okay. And if you're not doing that, it's particularly more egregious in an area with the 93% figure that you have an issue.
No, it doesn't actually say that, because then if we go back to the previous bullet point, it says that not doing it actually makes it worse for those households.
Gordon, I'm trying not to be argumentative with you, and it's not really helpful if we're across each other. I'm just reading the paragraph and I'm telling you what I think it also means.
Okay.
Try and engage with that rather than trying to tell me something else, please. So what I'm saying to you is that last bullet point, the clear implication here is, and I agree with you that this is not a development that's seeking to do that for viability reasons. I understand all of that. But what that is telling us is in Peckham in particular, in low income households, in a place like Peckham, what it's telling us very directly is the most immediate and direct way of dealing with this issue is to build more affordable housing. Do you agree with that?
I do agree with that.
Okay.
But I would take you back to the first bullet point you took me to, saying that if you can't do that, i.e. in this case, because there are good planning reasons that it can't be done, then not doing that has an adverse effect on those low-income households.
And the inspector can read that. I'm not taking that away from you. Final two bits on this, on the impact, and we've got the CBRE reports. The first is at 9.5, the property reporter. Again, it talks about house prices up 3.6% in regeneration areas. Again, insofar as we're able to forecast into the future, this is a net result of what's happening in regeneration areas.
Yes and no. So it doesn't do a proper, what I would refer to as a regression analysis, talking about what other things could have influenced that.
Okay, so I'm not interested in the regression analysis of ex post facto analysis of what else it didn't look at. But I've got a very simple question for you, Ms. Gordon.
Okay.
I'm not asking you to methodologically disagree with what's here, but is this an example of a clear direction of travel of what happens to prices for houses in regeneration areas?
No, for the reasons I was just about to say. I can't say that. There are many other factors that influence house prices.
Okay, so this is wrong because there are multiple other factors that they didn't take into account. I'm going to record this because I'm going to put this in my closing.
Quite probably. I didn't write it, so I don't know how they did it. But I would say there are probably many other factors that they could have or should have taken into account.
Okay. So this is, even though this is what it says, you're disagreeing with it because they might have not assessed multiple other things. They
had an objective when they wrote this. Presumably, they wanted, I assume, to demonstrate that regeneration had positive effects on property values, which is an incentive for developers to invest. That's an objective, and it's probably makes sense in that context.
Is your client going to have a negative effect on house prices in this area?
I doubt it.
So they will have a positive effect.
Yes, but the linking of one to another in a specified percentage, I can't do based on this report.
So they won't have a negative effect. They will have a positive effect. We have an article that says in some examples of 3.6% in regeneration areas. But you disagree with that because you don't know what else they haven't assessed under the sun.
Well, quite, because there are many other things
fine.
that influence that.
I get it.
Transport, investment in the high street, which is all Southwark policy, vitality and viability of the town centre.
I understand.
All of that influences house prices.
I understand. I know what I'm going to say. 9.4 of the CBRE report. Let's try this one more time. And again, I'm guessing it's the same answer. Page 3, 9.4. 9.4. Yeah. Page 3. Again, these statistics, you don't know what they looked into. They might have left other things out.
Yeah.
The percentages you can't really understand. They might have other objectives. Is that fair?
I would try and make myself sound a little bit more educated than that, but
So that's my understanding of what you're saying.
so I think there's a very important one in this one, and that is a compositional effect, right? So there may be homes here that are, the new homes may be more expensive than the average for the existing area.
So you're doing a methodological assessment again.
Well, that's what needs to be done with
Hang
numbers.
on. So just because my point is simple. If I look at these figures, and you look at, for example, Elephant and Castle,
Yep.
and we can see the percentage increase there. It's there, but what you're saying is lots and lots of other factors might be influencing this.
Yes, I am
That's
saying
fine.
that.
That's fine. I don't want to waste time of the inquiry quibbling about methodological issues, but I think that's fair enough. And then finally, you seem to, in your rebuttal, you seem to be disparaging about the research by Dr. Jalali by just basically saying that although you don't dispute the figures, no, actually, let's take the rebuttal so that I don't misrepresent what you're saying. Pick up your rebuttal at 110.
Yes, thank you.
So you don't dispute section 1. You don't dispute section 2, but when we get to section 3, you say at paragraph 110, section 3 provides evidence that house prices in Peckham have increased and that the increase has been significant. You do not dispute these numbers, so you don't dispute that their prices have gone up.
Agree.
But this section fails to provide any evidence that this is linked to new housing development. In fact, there is no analysis of causal links at all, nor any comparison between Peckham and any other comparable area to show any specific sensitivity or unique circumstances here. So can I be clear? Dr. Jalali has produced evidence of house prices in Peckham increasing. You don't disagree with that.
I don't.
She then projects and says it's likely to increase even more because of this development. You disagree with that.
Agree.
But you don't have any evidence to the contrary because you can't.
Well, I don't have a crystal ball, but I draw heavily on the GLA report, which I think is very instructive in this matter.
No, that's fine. So that's what I just wanted to understand. And then when you try and say that she's drawing on emotional understanding of what this is all about, you're not trying to suggest that this shouldn't be read as anything other than a robust piece of work that has a particular view.
No, I don't. I'm not undermining that. I'm just saying it puts a particular viewpoint forward, which relies heavily on testimony and emotional viewpoints, which is valid, but quite different to determining an impact on the housing market.
Okay. But the only evidence that we do have that we are clear about is that prices do go up.
Not always.
Well, I don't want to talk to you about Leeds and Hartlepool. I'm talking about London. The only evidence we have is prices go up in London.
They have somewhat leveled off actually in the last two years. But yes,
Okay.
they do increase substantially over time.
Thank you. Final point is, no, I think I'll take that in my closings because I know what the answer is already. Thank you very much, Ms. Gordon. Thank you, Mr. Turney. We'll have some questions for you.
Thank you, Mr. Mohammed.
Thank you. Over to you, Mr. Turney.
Thanks, sir. Do you want to take a break? I'm happy either way, but
Happy to press on. I don't know if the witness needs a break.
Are you happy to continue? Thank you very much. Good afternoon, Mr. Gordon. In your answers to Mr. Mohammed, you said that you're here with a specific goal in mind. Can you just explain what you meant by that, please?
Was that With respect to Berkeley's intentions, was that when
Yeah.
we were discussing that? That's, I think, getting planning permission for Berkeley, I think.
And that's
was
your
the-
goal in giving evidence.
Well, no, me giving evidence is to give a objective view on what I think the state to be. I think Berkeley's view here would be to get planning permission.
I see. So when you said I'm here with a specific goal in mind, what goal did you have in mind?
To give evidence to the inquiry and to the inspector that would balance the costs and benefits, as I said in my intro.
Very grateful. And just for parity, you're not a planner?
I am not.
No. And are you a member of any professional body?
I am not.
No. Okay, thank you. And then on policy matters, do you defer to Mr. Alston on questions of application of policy?
Yes.
Yeah.
If you want to talk about cost and economic, social impacts, I'm happy to discuss. But in general, I would defer to Mr. Alston. Yes.
Yeah. No, I just don't. I don't want to spend inquiry time asking you questions that are better placed to Mr. Alston. But specifically, your evidence doesn't refer to policies P32 and P33, shops and business relocation policies. Can I take it from that I should pose any questions about that to Mr. Alston?
Yes, please.
Thank you. Thank you. The local independent operators affected by this scheme, in terms of the ownership base, I think your conclusion was that it was entirely non-white.
Yes.
Yeah. And in terms of the customer base, disproportionately non-white compared to the wider population, Southwark, London, UK.
Very likely, yes.
Yeah. Okay. Thank you. So the closure of local independent operators will have what you describe in the EQIA, and it's paragraph 1.29 of your rebuttal as well, a differential and disproportionate impact.
Yes.
Thank you. And I just want to pick up a couple of points from that, largely covered by Mr. Mohammed, but you said in your answer to his question that there's no evidence of retail price rises that would be caused by the scheme. Is that right? Retail in terms of rent
prices.
Rent rises.
On the general high street, it's plausible, but we don't have evidence. No.
Yeah. Have you looked at the financial viability appraisal?
I haven't in detail. No, to be perfectly honest.
Because that does, as you'd expect, contain evidence about existing rents to establish what the existing use value is.
Yes, I expect so.
And contains evidence about expected rents to deliver a gross development value. Yeah.
Okay, yes, I accept that.
Yeah. Now, we can go to it, but do you suggest that shows anything other than an increase in retail rents?
I haven't read it, but I'm imagining you're indicating it does show an increase.
Well, what's your assessment if we're looking at retail rents? And let's be realistic about it. The existing Aylesham Centre retail
compared
rents,
to the existing?
Yeah.
Oh, yes, undoubtedly it will be an increase.
The rents will be higher in the developed scheme than they are in the existing Aylesham
Yes,
Centre.
I would be a fool to say otherwise.
Yeah,
yes.
Okay, thank you. I thought that would be the case. I just wanted to clarify that we were ad idem on that, and then we don't need to go through the document.
I would like to, slightly strange, the section 1 is not really for me, it's for Mr. Alston and for the section 6 session, but I believe there is some contribution to affordable and some deal to be made there that I don't know the full details of. I would welcome you asking Mr. Alston about that.
Thank you. Well, let's see if Mr. Alston also welcomes that. We'll find out tomorrow.
I can't see him, so I don't know.
No, it doesn't look like as though he will, but you may be in trouble later. Right. Section 149 of the Equality Act 2010.
Yes. Do you need me to have it open?
Probably not, because you probably know it inside out. Have one of the matters to which one must have due regard as a decision maker is the need to advance equality of opportunity between persons who share a relevant protected characteristics and persons who do not share it, which is a slightly convoluted bit of drafting, but probably the only way the point can be expressed. Can you agree for these purposes that the more effective the provisions are for retaining those local independent businesses, the better the Section 149 objectives will be met? The more effective the measures are, the better you will have reached that objective of the need to advance equality of opportunity.
I think I would agree with that. I would caveat by saying that I did not find the effect to be large in the first place. It is small in the context, but I would agree with the statement that the impact on them would be reduced.
Yeah, but when we're looking at section 149, we're not concerned with EIA small significance measures across a particular set, are we? Because, for example, the section 149 duty would apply to a decision that only affected one person.
Okay, I'll take that point. Yes.
Yeah. So the less effective those measures are, the more likely that they are to harm that objective.
I think we're slightly in the territory of saying less effective is harmful. I don't think that's the sliding scale necessarily works in that way.
Well, okay, let's take half a step backwards, because the more effective those provisions are, the better you will achieve the objective. So that if those measures are, the less well you will achieve that objective.
I accept that, yes.
Yeah, okay, so when you're looking at that duty in the due regard, the better the measures are for ensuring those local independent operators continue to trade in the scheme, the more you are achieving that objective.
Yes, I agree with that. Could I add that the Act doesn't require mitigation, it requires due consideration?
Yeah, I know, but when the inspector's looking at discharging duty, it's fair for him to note, isn't it, that if there are better measures, then in part of that due regard duty, he's got to think, should I impose better measures? Should I seek better measures than the ones that are put forward?
I think that's fair.
Yeah, thank you. Thank you. We'll come on to the detail of that then with Mr. Alston. Can I then just briefly pick up the question of the socio-economic impacts of new housing, and just a couple of, or at least a couple of scene setting points. The expectation in the Southwark Plan 2022 was that new housing in Southwark would deliver upwards of 35% affordable housing. Is that fair?
Yes.
Yeah. And to the extent that this scheme doesn't do that, that's not meeting that expectation.
Yes.
Yeah. And that expectation is set by reference to various objectives, including socioeconomic objectives, social, economic and environmental objectives, to use the language of the NPPF.
I agree.
Yeah. Thank you. The concern, well, before we get onto that, can we also agree this proposition that those with protected characteristics, and in particular the protected characteristic of race, that is to say those that are in ethnic minority groups or in racial minority groups, those groups are disproportionately present amongst those in need of affordable housing?
In Southwark, yes, that wouldn't necessarily carry elsewhere, but yes, that is true in Southwark.
In Southwark, yeah. Okay, fine. Thank you. So there is a nexus then, isn't there, between the protected characteristics of the Equality Act 2010 and the socioeconomics?
Yes, that's why I write both.
Sorry?
That's why I'm the author of both, because I see the link.
Yeah, precisely. Yeah. So there's an important nexus, isn't there? Because whilst being relatively poor is not a protected characteristic under the Equality Act 2010, there is nonetheless a nexus, because being relatively poor means that you are proportionately more likely to have one of those protected characteristics.
I agree with that, and I refer to that as intersectionalities in my report. Yeah. May I add a point to that?
Please do.
That I would therefore, in that context, say that the 77 affordable homes would therefore likely disproportionately benefit people who are not white in this area.
And the concern that's expressed about the impact on the housing market, which Mr. Mohammed took you to by reference to his evidence and to the GLA document, is a concern that is echoed in the officer's report. Can we just briefly pick up the officer's report, CD 5.1, 3.1, apologies and thank you, CD 3.1 and paragraph 163, which you find on page 127.
So I'm getting there. 127. Oh, PDF 127.
PDF
yes.
127.
Yep, got it.
Yeah. Paragraph 163. So the heading is wider socioeconomic effects, and then you see at 163 the potential for increased rents and house prices in the area as a result of the proposed development has not been explored in detail in the application, although officers recognise that this is often an effect of large-scale schemes. This highlights the need to ensure that such schemes deliver sufficient affordable housing and, where appropriate, affordable retail and workspace, so that the local community can benefit from the development and not effectively be pushed out. And then it goes on to talk about CLT homes, which you can read, but it's not relevant to my question. So that concern, which Mr. Mohammed expressed by reference to the GLA report, is a concern that's shared by Southwark officers, isn't it?
Yes, I understand that.
Yeah, thank you. And in terms of the nature of that effect, Mr. Mohammed touched on Berkeley Homes' own intentions and their expectation as to what they would deliver in terms of growth. But there, can we just briefly go to CD 1.23? CD 1.23, which is the application viability appraisal.
Yeah.
And when you get there, turn to page. Sorry, it's quite a big document.
Yes, I wasn't prepared with this one.
When you get there, turn to page 15 of the PDF. Sorry, that's my fault. I should have forewarned you about.
15, okay. It's a table of some kind. Viability outcome and conclusion table?
Yeah, thank you. And then if you just go to 16.4, this is the only point I want from it. Sorry for going to a big document for a small point. Whilst there is a viability gap on the present day basis, not asking you about that, Berkeley has confidence in its own ability as an urban regeneration specialist to bring value growth and a place-making premium to the development. Now, that phrase is about Berkeley saying that they think they will be able to uplift prices, isn't it?
It is.
Yeah.
Could I add my view in addition to that?
Yeah, please do.
So I think this is what I was trying to get at earlier with the compositional effect. And I think I do say this in my rebuttal, that I acknowledge that new houses generally are more expensive than the average for the neighborhood, and that makes economic sense for both those homes and the context. So that, while I agree with that statement, it seems plausible and it's in this very important document, it doesn't necessarily prove that it will uplift the general price of housing in the area.
Well, what Berkeley is saying there is what they expect is not just that they will achieve the sales prices, which they then go on and agree through the financial viability appraisal, Mr. Levine's evidence, but that they'll do more than that, that they will generate a uplift. And that's that's not a scheme specific uplift, is it?
It's hard to say. It could be.
So you're saying that the urban regeneration benefits in terms of value growth and placemaking premium are confined to the red line of the scheme?
They could be, or the other point that I make in my statement is that we don't have the counterfactual there. So the general house prices, this development may reduce the general house price inflation of the wider neighborhood. How high would they be if this development wasn't built? We don't know. But
no, and we don't know that because going back to the terms of the officer's report, that's a question which hasn't been explored in detail in the application. We haven't done that. You haven't done that economic modelling to work out what the consequences might be.
No, okay. Nor would you normally do so for an application.
Yeah, no, that's quite right. Although not normal might not be the determining factor here.
Fair enough.
Let's then just touch on one more point relevant to the viability matters and how they impinge on the economics of the scheme. Your position, as I understand it, is that if this scheme is not delivered, there is no other deliverable scheme. You were asked questions by Mr. Mohammed about where you got that from at the start of his cross-examination.
That's purely on the basis of Mr. Levine's evidence and the other evidence I have seen at this inquiry. That's not I don't have any intel from Berkeley on that. That might be.
But I'm not going to repeat my questions to Mr. Levine, but can the inspector record that on questions of the viability and deliverability of the scheme, you rely on Mr. Levine's evidence?
Yes.
Right, okay, that saves me repeating the questions. Thank you. Final point, and it's really just to seek to assist the inquiry. In your evidence, you explain the, by reference to the socioeconomics of Peckham, that you are in and around this site in some of the poorest LSOAs, the lowest super output areas, that is to say in the bottom 10 or 20% of those areas across the whole country.
Yes, agreed.
Yeah. London is a city which has a lot of those bottom 10% and also quite a lot of the top 10 and 20%.
Yes, I think so. Yeah.
Yeah. It's a city which has
City of two halves. Yes.
two halves or many different pieces. Yeah. Okay. Now, when you're looking at impacts of delivering housing and affordable housing, do you differentiate between whether you are in one of those poorer areas by reference to the indices of multiple deprivation, or whether you're in one of the richer areas by reference to those indices?
In the context of a socioeconomic ES chapter, no, we don't consider that. We just look at planning policy. In the context of an equality impact assessment, yes, we do look at that. And in the context of this development specifically, given the specifics of the context and the work that I did in consultation, both with Southwark and the community, that was very much a feature of our work, yes.
So when you're looking at these matters in the round, do you invite the inspector to consider the fact that these are proposals for this form of housing and mix of housing in one of the poorest LSOAs in the country?
Yes, I would invite him to consider that. Yeah.
And might that be a relevant distinction between this and other cases where inspectors have considered those matters in less poor LSOAs? I think as a matter of principle, it follows it must.
I think it's relevant, but I'm not sure I come to the same conclusion that I think you're getting at. Don't worry.
Okay,
I do think it's relevant.
About my conclusion. My line of thought is probably one that is completely irrelevant to this inquiry, to be frank. So don't worry about that.
May I add something that may be of interest to the inspector in that regard? So there is a very helpful statement in the Southwark Regeneration Framework that said that it is through regeneration and investment that they have reduced deprivation in many of their communities. So I think that is a relevant consideration there.
Yeah, okay. Well, I'll just land my question in case you can assist. Mr. Harris, who likes to report his victories, has referred a number of times to the Stag Brewery case, which is in Mortlake. Do you have any idea as to where that sits in terms of LSOAs nationwide? You presumably know the location.
I do. I would guess it is not a very deprived area.
Yeah. I think, and we can double check it, but I think it's in the top 20%. And
the other end.
Around, but
yes.
Port was in the lowest 10%.
In the London Borough of Richmond, which might not be the nationwide comparison, the richest borough in the lot. the poorest part of the richest borough, but the second richest borough.
All London boroughs have a big diversity of.
They do. Okay. Well, we'll check. But it's right to note, isn't it, that Mortlake is one of the richer areas in terms of looking at those indices of multiple deprivation.
I think it is right to note that, but I would also say, therefore, that investment in Peckham, that would point to me towards encouraging investment in the deprived area.
That point, I'm sure the inspectors noted, but your point is, and I think we've got it clearly from what you said before you went on to the question of improving and regenerating. Your point is that you do have to think about context.
Yes,
here, including where the site sits in relation to those indices of multiple deprivation.
Yes, agree.
Yeah, okay. Thank you very much. No more questions. Thank you, sir.
Thank you very much.
Okay, thank you.
Anything?
Is there any re-examination?
Just a couple of points, please.
Okay.
Ms. Gordon, just mainly on this mixed and balanced community issue. You'll recall during your discussion with Mr. Mohammed, there was a discussion as to whether it should be looked at on a site-by-site basis, and you said, no, you look at the community, and you said that you'd looked at the two wards. Do you remember that?
Yes, I did.
Yeah. Firstly, just looking at this specific site, is there anything in the site allocation policy that requires a specific proportion of affordable housing on this site in order to achieve a mixed and balanced community?
No.
And then when looking at the community,
Yes.
in your assessment, in your judgment, what do you say would be the effect of granting permission for this scheme in relation to this mixed and balanced community?
I don't think it would have a significant impact on the balance of the community. As I think we discussed, as already 50% social, 50% of local households are in social rent. So the impact of this in the context of that wider community would be negligible.
And on this point, you were discussing with Mr. Turney about the relevance of this being a poorer or
Yes.
more deprived area. And you said, you referenced something, I didn't get the exact note, and you then said it's through regeneration and investment that Southwark have improved
Yes.
communities.
Would you like me to get the reference? Or
Yeah, and can you just expand on that point, please?
Yes, if you give me a moment, I'll get the reference. It's in the regeneration framework, which I'm not sure. I don't may have it to hand. Might involve a short word search, please bear with me. I have not provided a page reference, but it is in page 3.16 of my Appendix G to Mr. Alston's proof. And it says, Southwark prefaces its framework, so this is the Southwark Social Regeneration Framework, by stating that over the last 2 decades, Southwark has implemented a range of ambitious urban regeneration and development programmes which have helped turn the borough from the 12th most deprived in the UK to the 41st.
Thank you. And in terms of, you were discussing the relevance of this community or this area being a poorer area.
Yes.
What's the relevance of this development in relation to investment and mixed and balanced communities being achieved here?
I would say it's hugely positive. It's a huge investment. The high street impacts, which I'm sure Mr. Alston will get into in terms of townscape, and I mean that I don't mean that in a technical sense, I mean that in a socio-economic sense. The retail, the ground floor, the placemaking, the sense of pride that I think it will have compared to the current site. I know there might be some locals in the audience who disagree with that, but I think this will be a significant improvement on the current site, and so highly beneficial.
Thank you. I've got no further questions.
Thank you.
Thank you both. No further questions from me either.
Thank you.
Just thinking about the timetable, I've only got one copy, and that was the one sent on Friday in terms of the unilateral undertaking. So if there is anything else that needs to be considered, I do need sight of the most recent iteration. I've not yet received anything.
Well, we can certainly do that, sir.
I've got a printed copy of the version sent last night, 8:30 last night. Is that the version that we're looking at?
I think that will do, sir, for present purposes.
Or it can be sent to the
would,
record,
yes.
Sorry, I took my flipped the back of my shoe off, and I'm going to fall over. And that's
You could have limped across. You could have limped across, and we wouldn't have noticed.
Thank you.
Yeah. Is that table in it, Richard? Do you know the table? Yeah, that's right.
I can take mine to hang on. I think it may have been.
It should be in there. It would be useful to have it in colour. Can we get a colour one?
Richard, take this one. You got a colour.
Thank you very much.
Sorry. So it wasn't attachment.
Right. Thank you.
When was it sent, Chloe?
Lunchtime,
Oh,
I believe.
we
Sent.
Just checking now.
we think there's another version that went at lunchtime. No, I'm talking about are we talking about the table or the thing as a whole? Yeah, okay. All right, it's just a table.
So, sir, that's the version. I think, could we just double check from our side, partly because we need to communicate to other people such as TfL. I think the way timetable's going, we would hear Mr. Alston tomorrow. There's clearly a bit of to and fro on preparing the Regulation 122 compliance statement. Would you be willing to schedule then the 106 roundtable for Friday morning?
I am willing. I was going to suggest that.
Thank you very much. And then we can tell TfL and anyone else who's coming specifically for those purposes to come at 9:30 on Friday.
We'd agree with that, sir. That's sensible.
Yes, I agree.
And so, given that at least one of the people on this side of the room is going to need a break very shortly, that's me. And given that we've got the whole of tomorrow to finish our planning witness, might it make sense, as Mr. Turney just suggested, that we start with him in the morning?
I think that would be sensible, yes. If we adjourn now and start again tomorrow, yes.
Thank you very much, sir.
Whether you're still intending to do the site visit on your own tomorrow or Friday, because I'm just thinking about the timetable again.
Yes, it may be over the weekend, but it'll be some time of my choosing between now and closings. I'll keep it flexible when I can go. So yeah, we'll adjourn there until tomorrow 9:30. Thank you.